statute, the way that's set up, when a person files a petition in court, according to the statute, the coordinator of elections and the Attorney General's office get a copy of that petition sent to them, correct?
Correct.
And that has to be 30 days before any hearing, so that if the Attorney General or coordinator wants to intervene, make any arguments, they can do that. Is that right?
I don't have the power to intervene. The Attorney General has the power to intervene.
Understood. But that would be for the purpose of making any arguments about the petition that need to be made from your perspective.
Yes.
Okay. And then I think we also covered yesterday, at the end of that process, once the petition is ruled upon by the court, a copy of that order also gets sent to you as coordinator. Is that right?
Correct.
Okay.
So let me back up. So the Attorney General could intervene if we said something. It'd be their decision, but also I think they'll reach out to the TBI, particularly when it comes to gun rights.
Understood. And we'll touch on the gun rights thing here in just a minute, very briefly. So part of your office, as we talked about yesterday, part of what your office does is to keep track of, we have the felon list, which is keeping track of people who have been convicted of felonies. Is that correct?
We got the TDOT list. That's correct.
And I'll cover that with Ms. Henry Robertson. Do you also keep databases in terms of whose rights have been restored and whose rights restorations have been denied?
Yes.
Okay. Let's look at a document. This has been pre-marked Plaintiff's Exhibit 75.
Now, what is the next exhibit? Is it 61? Okay.
Oh.
Did you want to enter that?
Yes, Your Honor. I'll ask first if there's an objection.
Well, the court will ask if there's objection.
Apologies, Your Honor. I was
That's
going to
okay.
ask the witness to tell us what it is, but
Okay, did you want to, well, you passed it up to us. Is there any objection to the admission?
No, Your Honor, no objection.
No? Okay, we'll go ahead and admit it as Exhibit 61.
hand that to the witness, please.
Okay.
Thank you.
Mr. Goins, this is a letter that you sent on December 21st, 2021 in response to an open records request, it looks like.
Yes.
And I want to call your attention to the paragraph on page 2. Here you tell this person regarding numbers 1 and 3 through 5 of your request, I've attached 2 databases responsive to your requests. Skipping a sentence, then you write, the first database reflects the individuals whose rights to vote were restored/verified by this office. Do you see that?
Yes.
And then if you keep reading, you mention another database. There's a sentence that starts, the second database reflects the individuals whose voting restoration applications were denied by this office. Do you see that?
Yes.
So we're going to look, you reference attaching databases to this letter. So let's look quickly at some excerpts of those. The first one has been pre-marked as Plaintiff's Exhibit 76. And we're going to also do Plaintiff's Exhibit 211. '76. Just a moment, Your Honor.
Any objection, counsel?
Your Honor, fundamentally, we have no objection to the admission of the exhibit. Having worked at the state for a little while, I'm cognizant of these things. This contains some personal information about voters, including what their names, addresses, what they've been convicted of. I leave it to the
That's
court's
public record, is it not?
It is.
As long as it doesn't include socials, I'm not sure if birth dates are considered protected.
And Your
But
Honor,
we
we
can certainly redact birth dates.
we redacted the birth dates.
You did, okay.
On this exhibit.
I just want to
Okay.
be sensitive to it if Your Honors think it should be handled however.
Okay, thank you for bringing that to our attention, though.
And Your Honor, before we move that into evidence, we have basically a continuation of this exhibit. So this will be Plaintiff's Exhibit 211. I want to show. Yeah.
Are you trying to mark it separately or part of 62?
Your Honor, yeah, I was going to try to do a collective exhibit.
Okay, collective, okay.
Oh, wait. Did you want to hang on to that?
Any objection to that document? No? Any objection?
No, Your Honor.
No? Okay. All right, so we have plaintiff's exhibit 76 and 211 marked collectively exhibit 62.
Mr. Goins, you have copies of what has been admitted as Exhibit 62 in front of you?
Yes.
And as you referenced in your letter, it looks like these are the restoration database, is that right?
I'm not sure, honestly. I'm not sure.
Well, so if you look at the top of the page of either exhibit, the title is Restoration of Voting Rights After Felony Conviction, and then Restorations, correct?
Yes.
So based on your experience as coordinator, would this reflect a database of people whose rights were restored?
I don't know if this is our document. I'm not saying it's not. This might be something that Beth might be more familiar with.
Okay.
Like I say, I have a person that works with felon restoration. The truth is, I haven't given myself access to this database.
Okay.
So it's not something I typically work with.
Okay. Are you aware that under law, there are certain felonies for which people can have their rights restored, and there are certain felonies for which people cannot?
Yes.
And that latter group, people, those are the people we've been calling permanently disenfranchised. Is that correct?
Your Honors calls for a legal conclusion.
Overruled.
There are some folks that are not eligible to get their voting rights back. So that would mean that unless the court were to give them their right back, that they would not be able to get them back. So that would be permanent.
Okay. Let's take a look. I'll tell you what. Since you said Ms. Henry Robertson deals with this database.
No, she doesn't either. But she is the. So the way it works in the office, someone specializes in felon restoration. They're typically very specialized because it's all that they do. If there's questions, then they can go to Beth, and then if there's further questions, then they'll come to me. Beth, I would assume, is familiar with this database, particularly with the recent law change. There's been some updates to the database. I know that they've worked hard on it, so updating certain things, but particularly to a place to put the court orders.
Okay. Let's then I'll just have one or two questions about this, and we can move on. If you see on the first page, I'm going to tell you about how to find this.
And to clarify, when I said I didn't give myself access, there's security functions that we have because there is personal identifying information, and I have to sign off on everyone that gets access to that database, including myself. I know that kind of sounds weird, but it's a protection that we have in place to protect the individuals.
Understood. So if you look on this first page, for example, there was a person here, the second line down, who had their rights restored from aggravated burglary and aggravated assault I'm sorry, aggravated burglary is the second line. Do you see that?
Is that the person with the initials RB?
Yes.
Yes.
And then on the next line, the person with the initials RE had their rights restored from a conviction of aggravated assault and aggravated burglary. Is that right?
According to this document, yes.
Okay. On the second page of this exhibit, if you go down towards the bottom, there is a person with the initials CS who was restored from a conviction for produce/traffic in counterfeit devices. Is that right?
Yes.
And then a person, the initials SP, who was restored from a conviction for Schedule II kidnapping and aggravated assault. Is that right?
Yes.
I'm sorry, did you say SP?
Yes, Your Honor. It is the second person from the bottom on page
Oh,
2 of this
okay.
exhibit.
All right, thank you.
Page 3, the last person listed with the initials DN. This person was restored from a conviction for, it looks like, Schedule II and forgery. Is that correct?
Yes. And FTA? I don't know what FTA is, but
Correct. And then the last page of this exhibit, we have a person, I think it's the fourth person listed with the initials RA. That person was restored, they had their voting rights restored, despite having a conviction for forgery of signature of a court officer. Is that right?
so, okay, I see that. It's all right, I see that now.
Is
Yeah,
that correct?
Yes.
Okay. And then if you flip over to the next exhibit in this collective exhibit, which was plaintiff's exhibit 211.
211.
Do you see that
Yeah,
page?
I'm
And you
211.
see the one we just discussed, forgery of signature of a court officer, that's the fourth one down.
Yes.
And so this is a continuation of that prior exhibit?
Yeah, I see what you're saying.
Okay. I want you to turn to page 2 of this exhibit. And we have a person, it's about maybe close to halfway down with the initials LS, who restored their right to vote from a conviction of identification, document, and info fraud and aiding and abetting. Is that right?
Yes.
And then I think the last one here, if you turn to the next page, there's a person about, I don't know, 6 or 7 down with the initials GR, who was restored from a conviction of identity theft and forgery. Is that right?
Yes. Now, this may be what they were charged with and pled down. I don't know how the intake goes in the system.
Understood. And I'm sorry, I actually skipped one I wanted to ask you about. On that same page, the second person down with the initials LP was restored from a conviction of making a false statement. Is that right?
Yes. And once again, that may have been the initial charge, and it may have been something different.
Okay. Mr. Goins, you can set that exhibit aside. So let's talk briefly about Ms. Moses specifically in this case. So in 2019, I believe you had some correspondence with Mr. Kirby May, who was an assistant district attorney here in Shelby County. Do you recall that?
Did I have the correspondence with Jessica? There was correspondence, and it was from my office. I do know that.
Well, let's, thank you. That's a good clarification.
Was it Jessica? I think Jessica had the.
Let's
So
look,
Jessica did felon restorations at the time.
let's look at an exhibit. We can answer that
Okay.
question.
All right.
I'm going to hand you a copy of what has been pre-marked as Plaintiff's Exhibit 201. We'd like to move this as the next number to exhibit.
Any objection? Thank you. 63.
And Mr. Goins, do you have a copy of what has been admitted as Trial Exhibit 63 in front of you?
Yes. And it does have my name, so I would have been communicating with General May.
Great. And that was the next question I was going to ask you. Thank you. So this is an email from you to General May with respect to Ms. Pamela Moses. Is that right?
Yes.
And at the end of the first paragraph of this email to General May, you note that your office restored the voting rights of Ms. Moses on March 28th, 2014. Is that right?
Did you say 20? I'm not with you yet.
So
Where did you say that?
the end of the very first paragraph.
Oh, first paragraph.
So the sentence is, using the information from the March 24th COR, C-O-R, this office restored the voting rights of Ms. Moses on March 28th, 2014.
Yes,
Okay.
I see that.
And then at the end of the third paragraph of the email, you say, in processing that COR, this is now referencing a 2019 COR, you write, in processing that COR, this office researched the conviction type and learned that Ms. Moses was convicted under Tennessee Code Annotated 39-16-503, tampering with evidence, a conviction for which voting rights cannot be restored in Tennessee. Is that correct?
Correct.
And then you go on to say, this office notified the SCEC, and is that the Shelby County Election Commission?
It is.
This office notified the SCEC that under Tennessee Code Annotated 4029-2043B, Ms. Moses is permanently ineligible to vote in Tennessee. Is that right?
Yes.
And then the last thing you say in response to Mr. May here is, documents relied upon for this explanation have been attached to this email. Is that right?
Yes.
Okay, let's look at a couple of those documents. If you see in the attachment line of this email, looks like there are two attachments. Is that right?
Yes.
So let's look at that first attachment with the file name Pamela Moses 2014 Restoration. This has been pre-marked as Plaintiff's Exhibit 252. Yeah. And we're also going to move to admit Plaintiff's Exhibit 253, and we can do this as a collective exhibit.
Okay, any objection to these attachments?
Let me see the second one real quick, Your Honor. I'm sorry.
Okay.
No objection, Your Honor.
Okay, we'll mark them collective, 64.
Just so that you know, you're fine. It's enough. You're correct.
Thank you.
Okay, Mr. Goins, do you have in front of you what has been admitted as Trial Exhibit 64?
Yes.
And as we just went through, these are the attachments to the email that you sent to General May.
I believe so. Yes.
So on the first page of this exhibit, we have a letter from you to the Shelby County Election Commission that lists several folks who are now eligible to register to vote in Shelby County. Is that right?
Yes.
And one of those listed is Ms. Moses.
Yes.
And then the second page is the Certificate of Restoration of Voting Rights, or commonly known as a COR. Is that right?
Yeah, at the time, that's correct.
If you'll continue moving through that exhibit, what is the third page of this collected exhibit? This is an email from Jessica Lim, who was one of your employees as coordinator, is that right?
Yes, she was an attorney that handled felon restorations at the time.
And that was gonna be my next question. She largely handled the felony disenfranchisement and the restoration work?
She did.
Okay. And in this email, she is sending your letter to the Shelby County Election Commission, and your letter is the next page, is that right?
Yes.
And so in Ms. Lim's cover email, she says, attached, please find a denial letter for Pamela Janine Moses. The reason for denial is that Ms. Moses is permanently ineligible to vote due to her conviction, correct?
Correct.
Okay, can we take a recess at this time? It'll be a short recess.
Just 2 minutes.
Yes, Your Honor.
All right, thank you. Problems with the streaming.
Do we need to wait for that? We need to wait for Jason.
If we're gonna hold on to it, I don't mind telling Flint how it's good. Okay.
You want to do it now?
No, I think we're good,
Oh, okay.
but we don't have a witness. Yeah, let's
Okay.
just go ahead.
Okay, can we have Mr. Hilo, Mr. Wilson, Mr. Harbin-Rick, and one of the attorneys from Porter Arnold come up, please?
Can you hear?
And our court reporter, could you please come up? are we ready?
Yes, Your Honor.
All right, we may proceed.
Mr. Goins, we were looking at what was admitted as Trial Exhibit 64. So we talked about the first page from Ms. Lim. I want you to, and we talked about the second page, which was your letter. I want you to just look at the last few pages. So after your letter comes the 2019 Certificate of Restoration of Voting Rights form that Ms. Moses filled out, is that right? Excuse me, that was filled out on behalf of Ms. Moses?
Yes.
And if you'll look at the very last page of this exhibit, this is the application for voter registration that Ms. Moses filled out in 2019, is that correct?
Oh, last page. Yes, I mean, it's a voter registration. I assume that's the one that was submitted.
Okay. And you can see it has Ms. Moses's name and email address and those kinds of things, is that right?
Yes.
Okay. So, going back to your letter, the denial letter, that's page 2 of what was pre-marked Plaintiff's Exhibit 253. After you send a denial letter to the local election commission, the local election commission will then notify the voter that their registration has been denied. Is that right?
Yes, because, and the reason for that, the statute says that the administrator is in charge of voter registration. It also says that the administrator is the person responsible if someone is being denied to notify the voter, and they also notify the voter that they have the opportunity to appeal it to the local county election commission. So that's by statute.
Correct.
So we do not communicate with the voter unless they reach out and want a public records request or something like that.
So let's take a look then at the next exhibit we would offer into evidence. This is pre-marked Plaintiff's Exhibit 181. This is 2019. Give that to the witness. Your Honor, we would ask that this be admitted as the next numbered exhibit.
Any objection?
So, Your Honor, we've stipulated its authenticity. It was not written by or to Mr. Goins, and so at this point it'd be hearsay.
Okay, counsel, hearsay?
Your Honor, under Tennessee Rule of Evidence 803-8, there's a public records exception, and this is official correspondence from the Shelby County Election Commission to Ms. Moses informing her that she can register. We would argue that this falls under the Tennessee Public Records exception.
803, what section?
803-8, Your Honor.
803.8, thank you. I'm familiar with the exception, but let me review it, let the court review it. Okay, 803.8, unless the source of the information or the method of, or circumstances of preparation indicate a lack of trustworthiness, records, reports, statements, or data compilations in any form of public offices or agencies setting forth the activities of the office or agency or matters observed pursuant to a duty imposed by law, as to which matters there was a duty to report, excluding, however, matters observed by police officers and other law enforcement personnel. So the condition is that the document does not lack trustworthiness. So that's the first thing that we look at. Does it look like it's a credible document, a reliable document? It doesn't appear to be forged, but is there any lack of trustworthiness? And then, of course, if it is a public record, if the agency has a duty imposed by law to report that document, then it would come in under the 803.8 exception. So, having said that, counsel, do you still have an objection to the document
So,
as hearsay?
yes, Your Honor.
Okay.
I'll point the court to Rule 1005 of evidence, which explicitly speaks to public records. And so to fit the 803 exception, it's still got to qualify as a public record. And it says in Rule 1005, the contents of an official record or of a document authorized to be recorded or filed are actually recorded or filed. If otherwise admissible, may be approved by a copy certified as correct in accordance with Rule 902, or testified to by the witness who compared it to the original. This isn't a certified copy.
Your Honor, what we would say is two things. One, this was produced by the defendant, and so to argue that this is not a true and correct copy when the defendants themselves produced it, I think they are precluded from making that argument. But two, as noted by Mr. Hellu, the parties have stipulated to authenticity of this document, and so I think that satisfies what this Rule 1005 is getting to, which is this an authentic document? Certified copy is one way to authenticate a document, but stipulation by a party is also a way to authenticate.
All right, well, it says may be proved. So, for example, if it doesn't meet the exception, because remember the objection was hearsay. So if it doesn't meet if it's not authentic, if it's not reliable, authentic under 901 or 902, and it would appear to be hearsay would not appear to come under one of the exceptions under 803, 804, then you go to 1005 and you may enter a certified copy of that public record. But that's the option. It doesn't have to qualify under 105 to come in under 803.3. And if this document was tendered or produced by the defendant, of course, is the Shelby County Election Commission, that is a division of your organization, of your agency? The Shelby County Election Commission, is that Ms. Phillips?
She's not a part of the Division of Elections. The Division of Elections and my staff of like 9 or 10, they're hired by the County Election Commission. Typically, they're under, county policies for HR issues.
Right.
There's litigation in the past on whether they're state employee or county employee, but there's a statute that actually says they shall not be considered a state official. I think it says state official. So it's one of those things that's kind of out there in limbo. Once again, I can't hire or fire her, and I think that is, that's one of the tests that someone would look upon it, if they're your employee or whatever.
Well, I understand that she has her own legal counsel, but is she bound by the rules and statutes that apply to your agency in terms of elections?
Your Honor, I'm sorry to interrupt. I believe the defendants may be willing to withdraw the objection.
We are.
Okay, because it's signed by Linda Phillips. So unless there would be some evidence that it's not a reliable document, which would indicate lack of trustworthiness, but if there's not any evidence of that, thank you. The court will admit it as the next exhibit, which will be, is that 65? Okay, thank you.
Mr. Goins, I think I just really have one or two questions about this. So you see the second sentence of that first paragraph,
Second sentence.
and I'll start reading it and see if you can follow along.
Yeah.
It reads, "The SCEC has been notified by the state coordinator of elections," that's you, "that due to the April 29th, 2015 felony conviction on your record for tampering with / fabricating evidence, you are permanently ineligible to register to vote," correct?
Yes.
Okay. Okay. We can put that aside. Now, I think you still have in a stack beside you, Mr. Goins. We need to turn back to what I believe was the first exhibit we admitted during your testimony, which is Trial Exhibit 47. It is your third supplemental declaration, and it was pre-marked Plaintiff's Exhibit 65. Do you have that?
I do.
Okay. Let's look at paragraph 24 of this declaration. So this would be the fourth page of this document. And we're looking at paragraph 24. You found where I'm talking about, Mr. Goins?
Yes.
Great. So paragraph 24 of your declaration, you start out by saying Tennessee elections have proven that every eligible vote counts and every eligible voter matters. Is that right?
Yes.
And then in this paragraph, you list a number of elections starting in 2010 up through 2022 that were in some cases tied, in some cases decided by a very small margin of votes. Is that right?
Yes.
And earlier in this case, we admitted as an exhibit a report of plaintiff's statistician expert, Dr. Baumgartner. It was pre-marked Plaintiff's Exhibit 31. If you give us just a moment, Your Honor, I want to say the correct trial exhibit for the record.
I think we triggered the cord, the screen is going off.
We think it was Trial Exhibit 31. I'm sorry, 34. Trial Exhibit 34.
Oh, okay, there it is.
So if you will, if we can find Trial Exhibit 34 and have that with you as well? Oh, great. Thank you. So Mr. Goins, if you can, keep both documents in front of you. I just want to ask a couple of questions about the elections that you identified in paragraph 24 of your declaration. So the first election you talk about here, you say in 2010, an election for judge in a county in East Tennessee ended in a tie vote with both candidates receiving 6,442 votes. Is that right?
That's correct. That was to fill a vacancy. I remember that election very well.
Do you remember what county it was in?
Anderson County.
Anderson County. Great. I was going to refresh your recollection, but you knew it off the top of your head. That's great. So this was in Anderson County, Tennessee. It was a judicial race, and the results were tied. Is that right?
Yes.
And so if you look at Exhibit 34, which is Dr. Baumgartner's report, there are a couple of appendices, and we can look at them, but I want to ask you a high-level question. Do you understand that in Dr. Baumgartner's report, he did county-by-county estimates of people who were disenfranchised. Do you understand that?
I was not in here for that. I don't understand that.
Okay. Nevertheless, this exhibit has been entered into the record, and so what I will, without getting into the details of the exhibit, let me ask a slightly different question. If Dr. Baumgartner found in his report that, for example, in Anderson County, there were, say, there were 93 people who were permanently disenfranchised. If he found that, that would be enough that if those people had been able to vote, that could have swung the results of that election.
Objection, Your Honor. Two. One, calls for speculation, and two, relevance.
Overruled. In terms of speculation, it's a hypothetical, which hypotheticals are appropriate. And then in terms of relevance, it's highly relevant based on Dr. Baumgartner's testimony and Mr. Goins' testimony that elections are close. So that hypothetical would be relevant to the issues in this case, would it not?
Thank you, Your Honor. No.
No? Okay.
This court has been clear on numerous occasions that general disenfranchisement is not at stake. What Dr. Baumgartner's report did not say as to this county or these felons is whether they are a part of that subcategory of the, quote, permanently unable to seek re-enfranchisement. And so because general disenfranchisement is not an issue, whether generally disenfranchised people would have swung this election is irrelevant to this
Well, that
lawsuit.
wasn't the hypothetical. The hypothetical was specifically if 93 people in Anderson County were permanently disenfranchised, would that have been enough if they had the right to vote to restore, to affect the election?
Then would be overruled.
Well, that's an argument,
Yeah.
but that was the hypothetical. So in terms of relevance, the court will overrule the objection.
Thank you, Your Honor.
All right, thank you.
So again, just to go back, Mr. Goins, on a tied race, if, for example, Dr. Baumgartner's report calculates that there were 93 people in Anderson County that were permanently disenfranchised, the question was, if those people had been able to vote, that's a sufficient number to possibly have swung that race.
So this one is really interesting because that county was so divided. So the way it worked, that tie went to the county commission. And if I remember correctly, I think one vote on the county commission separated. So the county was equally divided. So you'd have to look how many of those individuals would vote. If two voted, it could have been a tie again. If one voted, it may have made a difference, or would have made a difference if one person voted in that race. So there's a lot of factors that come into play. It may not have. But that was one where it was very clear from that county that they were very divided on who should replace April Meldrum. I know that's one I will not forget.
Understood. And so just to sort of summarize your testimony, I think the answer to my question is, in a race like this that's tied, you have a sufficient number of people, could have affected the outcome, can't say for certainty, but it could.
Yeah, a lot of factors. I mean, 93 may have been eligible and may not have voted. That could have been a low turnout election as well. I think if you look at the population of Anderson County, that's not very well. Although the county, those that showed up were divided, just not a lot of people voted. So I can't say with certainty because there was a lot of variables there that come into play.
Right, and I'm not asking you to say with certainty. My question was, understanding that there's some uncertainty there, it could have changed the results.
It could have.
Great. And that would be a similar result. I want to go through briefly the rest of the examples you have here just to identify the counties involved. But as an overarching statement, if you had a race that was decided either tied or decided by a very small number of votes, if there was a sufficient number of people who were permanently disenfranchised in the counties that issue, I think your answer would be the same. There's some uncertainty there, but if it's a tied race or decided by a very small number of votes, those permanently disenfranchised folks could swing the results of the race as a general matter.
Your Honor, I'm going to renew the objection because the variable is still difficult. So we don't know from Dr. Baumgartner's report, and it's a relevance objection, so I'm just still reading off of that. We don't know from Dr. Baumgartner's report if these people that were, quote, or let's use the right term, permanently banned from reenfranchisement, if they had finished their sentence, in other words, eligible to vote. We don't know if they had paid their victims restitution, in other words, eligible to vote.
Well, that's not the question. I'm sorry, I don't mean to interrupt, but the question is if they had never been, if they had been reinstated, but the question is if they had never really been disenfranchised permanently in the first place.
Yes, Your Honor, and so
Right.
my answer is, if the disenfranchisement was permanent or temporary, to the extent that's a thing, we don't know if the 93 people he looked at in Anderson County would even be eligible under the temporary standard. Like, they could still be in jail. They could still not have satisfied all the other qualifications. In other words, whether it was permanent or temporary, they could still not be able to vote. They couldn't be we don't know if they were eligible or not. All we know is that they committed one of those felonies. If they committed it 2 weeks before the election, it doesn't matter what else, permanent or temporary, they would not have been eligible to vote.
Well, in terms of relevance, I'm having a hard time understanding that. I understand your argument, but the hypothetical was if they had been reinstated.
I didn't hear those words.
That's what was said twice.
Yeah.
So we're gonna add that extra, so now
No,
we're
no,
outside.
hang on, we're not adding anything. That was the question twice, counsel.
Okay.
That was the facts in the hypothetical.
Then it doesn't match up with Dr. Baumgartner's report, so the reference to
Okay, well,
his
again,
report
that's
takes us out.
argument, but that's not a response to whether or not it's relevant or not.
Thank you, Your Honor.
Okay, thank you. That may be an argument for closing arguments, but not in terms of the objection, in terms of whether or not it's relevant.
I understand.
It's a hypothetical, okay. All right, let's move on.
So, Mr. Goins, I think essentially I was just, without having to go through each one of these, would your answer about a close election, either tied or decided by a small number of votes, the answer you gave me about Anderson County, that would apply as well to other counties with similar situations, tied, close votes, enough people who were permanently disenfranchised, and assuming they were eligible and reinstated, that could have changed the outcome.
Anyone that has lost their right to vote, if they got their right to vote back and it was a close election, depending on the different variables, if they went to vote, if it's a close election, if 16-year-olds were allowed to vote and they went and voted and it's a close election, it could make a difference. I mean, that's, yes.
Okay, yes is the answer. So let's look then back at paragraph 24. The second sentence, you talk about in 2012, a Republican primary for the office of Tennessee House of Representatives, District 71, was decided by 4 votes. I don't want it to be a memory test. Do you happen to know which counties District 71 comprises?
So I know the two people involved, Shirley Curry and Vance Dennis. I can't remember the exact counties that were involved.
So I'm going to hand you, and Your Honor, not seeking to make this as an exhibit, this is purely to refresh the witness's recollection about the
Okay.
districts. It's just a kind of map of 12.
Oh, geez.
And while you're looking at that to refresh your recollection, Mr. Goins, I'm asking about District 71. And my understanding from looking at that 2012 legislative district map is that District 71 was comprised of Wayne County, Lawrence County, Lewis County, and some of Giles County. Does that seem right?
You said 3.5 partial, is that what you said?
Correct. So,
Okay.
just
Yes.
okay.
Sorry, my eyesight is not.
No, that's
great.
fine, and this is a little small. So let me ask the next sentence in your paragraph 24 of your declaration. In a 2010 Democratic primary for the office of Tennessee Senate, District 21 was decided by 17 votes. You see that?
I do.
And Senate District 20 within Davidson County, Tennessee. Is that right?
It is.
The next sentence, you say the ultimate winner of a congressional seat won the primary by 38 votes out of 77,504 votes cast
That's
in an
correct.
election in 2014. Do you see that?
Yes.
And do you happen to remember which congressional district that was?
It's Jim Tracy and Scott Desjardins, and I think, let's see, Desjardins is District 4, I believe.
You got it. I was ready to refresh your recollection, but Congressional District 4 is exactly right. Would you mind taking a look at that exhibit to refresh your recollection about which counties are comprised within Congressional District 4? I'm going to read a list. If you'll look at the
Oh, you want me to
color.
look at this?
Yes, sir.
I don't, this doesn't have,
It does. Down at the bottom right corner has the congressional
okay.
districts.
yeah, they're not labeled, well, they are.
They are. There's a
That's
there's a 4.
tough, man. That's tough.
Just I'm going to read the list of counties just for the record, and just check me. I believe I have these right. So my understanding, based on this map, is that as of 2014, Congressional District 4 was comprised of Lincoln County, Moore County, Franklin County, Marion County, Grundy County, Sequatchie County, Warren County, Van Buren County, Bledsoe County, Ray County, Meigs County, Marshall County, Bedford County, Rutherford County, and then about half of Bradley County and about half of Murray County. As far as you can tell, is that correct?
Yes.
Okay. And then let's go back to your declaration. The last set of races you talk about, you say this past 2022 election cycle, there were 5 local races that had tie votes for the offices involved. Do you recall which local races those were?
I don't recall all of them. It seems like 2 or 3 of them were in one county. I think it was Sumner County. I think that's right. But they may have all been in Sumner. It seems like they were all
Okay.
kind of in the same area.
Thank you. We can take back that exhibit that was used to refresh your recollection.
Which one, this?
The map.
Okay.
Sorry, not an exhibit. Document. Mr. Goins, I'm going to switch topics here. I think this is a quick one. I believe you were present during the testimony of Dr. Holloway earlier on in this trial. Is that correct?
Some of it.
Some of it.
Most, I don't even know if it's most, but I was present for some of it.
Okay. Based on your participation in this case, you're aware that one of the claims has to do with the impact of felony disenfranchisement on Black Tennesseans, correct?
Objection, Your Honor. That calls for a legal conclusion.
Overruled.
I'm not sure what all the claims are because of the different stages. There's a lot of papers filed here.
I'll represent to you that at least one of the claims here has to do with the impact of felony disenfranchisement on Black Tennesseans.
Okay.
That being the case, I want to ask you, as coordinator, have you ever evaluated any of election laws to see if they have a disproportionate impact on Black Tennesseans?
I don't think so. If we did any at all, it would have been over the photo ID law that passed in 2011, implemented in 2012 for a court case. But that's not something we normally would do.
Okay. And I think the first about Tennessee's election laws, let me get a little more specific. As coordinator of elections, have you ever evaluated Tennessee's felony disenfranchisement laws to see if they have a disproportionate impact on Black Tennesseans?
No.
If there was testimony from Dr. Baumgartner that Black Tennesseans are permanently disenfranchised at a rate of approximately 3 to 1 as compared to white Tennesseans, is that a number that is surprising to you?
I don't know
Objection, Your
the
Honor.
number.
What's the objection?
Relevance as to what surprises it.
Counsel?
This goes to, we have a substantive due process claim that has to do with whether or not the coordinator of elections has even evaluated either the disproportionate impact on Black Tennesseans, has looked at it, has researched it. We have a similar argument around whether or not the coordinator has looked into, researched, evaluated the trial by jury issue. This goes to that substantive due process claim because it demonstrates what the coordinator has or has not done.
Well, the question is, would it surprise you? I don't know that that's a proper question, so I'll sustain the objection.
So if Dr. Baumgartner testified, and I'm offering this to you, that Black Tennesseans are permanently disenfranchised at a rate of approximately 3-to-1 as compared to white Tennesseans. As coordinator of elections, does that concern you?
Objection, Your Honor. Relevance to how his concern matters to substantive due process.
Overruled. He's the coordinator of elections, so he may have concerns, he may not, but he can answer the question.
I don't know if that's true. We haven't studied it. I don't know if it's true.
And I'm asking you, if it is true, take for basis of the question that it's true, does it concern you?
That it's 3 to, you say it's 3-to-1, is that what you said?
Correct.
Well, I mean, this gets into the criminal justice system. There's a lot of issues to unpack there. But ultimately, if someone commits a crime, whether they're any color, they lose their right. Anyone. And the terminology temporary, it really doesn't, I don't resonate with that, because essentially you've lost that right until you have got it restored. So in a sense, until that action has taken place, everyone's lost their right. So it's the crime that, it's the underlying crime is the reason that someone forfeits their right. And forfeit is the word Justice Bivens used. It's from a statute. So I would be equally concerned if someone commits a crime. So if someone commits a crime, and this is what the legislature has said, that they should not be able to participate by voting, whether they're white, black, or indifferent. That's the law I'm charged with carrying out. I do think there's certain crimes where folks forfeit the right forever. And that may not be an answer people like to hear, but that's how I truthfully feel. And we got into some of this in the deposition where I had someone that was killed
So we'll
in the family. So, you know, that's just the way I think.
Understood. Are you aware that your own expert in this case also confirmed the 3-to-1 impact?
So whether it's 3-to-1 or whether it's not 3-to-1, if someone commits a crime, then I do believe, fundamentally believe, that they have forfeited that right to participate in the system. We're also a country of second chances in many instances. And there's some crimes that I think you should have a second chance. So I don't, whether it applies 3-to-1, 2-to-1, 5-to-1, don't commit the crime. That's where I come from. Don't commit the crime.
And that matter, whatever the ratio is, right? That's your answer.
Correct.
Don't commit the crime.
Yes.
Okay. Let's look back at your third supplemental declaration. That's Exhibit 47. You should still have it in front of you.
Which one is that?
It was your third supplemental declaration. It was pre-marked Plaintiff's Exhibit 65.
65.
It's the one that was filed in court in the federal case.
Unfortunately, I've got them mixed up. Oh, I got it. So 65. I got 65. I'm sorry. Also, Exhibit 47. is
Okay.
confusing. That's the one, right? It says 47 as well.
Correct.
Yeah.
Okay, that's exactly.
So we're looking now at paragraph 3. So in paragraph 3, when you are listing your statutory duties, you reference Tennessee Code annotated 211-202. You see that?
Yes.
And we talked a little bit about this yesterday. The one I want to ask you about is the third bullet point. One of your duties is to authoritatively interpret the election laws for all persons administrating them. Is that right?
I interpret it for election officials, correct.
Okay. So when you are authoritatively interpreting the election laws, what sources do you look at? You look at Tennessee case law, I assume.
The statute, case law.
Sometimes you look at the text of the Tennessee Constitution.
Yes, but we presume what the legislature has done is constitutional. I see my role there is that it's the court system to declare something unconstitutional. It's not my role to. We're more primarily focused on what the statute says.
Understood. And in interpreting the statute, though, I think my only question here is sometimes you need to look at the Tennessee Constitution when you're doing your authoritative interpretation.
I don't know that I can't think of a context of. I mean, in looking at, so when something's passed, the answer to that question is no, because we do presume it's passed. And honestly, I don't think I have the authority to say something's unconstitutional from advising an election official to that extent. If legislation were to be proposed that said 14-year-olds could vote, I would tell the legislators that seems to me to be unconstitutional. If the legislature passed it, I think I have a role to say that's what the statute says. Now it'd go before the judges, and the judges would shoot that down, and I would say, legislature, you should listen to me. But at the end of the day, that really isn't something that comes into play in our office.
Okay.
After the fact.
Well, let's look at what has been pre-marked Plaintiff's Exhibit 72 then.
Any objection?
I'm sorry, Your Honor. Sorry, Your Honor, 1 second.
Okay,
No objection.
all right, thank you. Exhibit 66.
So, Mr. Goins, you have in front of you what's been admitted into evidence as Exhibit 66. This is a letter from you to the Sumner County Administrator of Elections. Is that correct?
Yes.
And this has to do with a situation prior to the new law where there was folks who were trying to get their rights restored but could not get their gun rights restored, and so there was a tension there, and your office took the position that a person needed to have their guns rights restored in order to get their voting rights restored. Is that right?
Yes.
And in this letter, this is having to do with a woman who got an order from the Davidson County Criminal Court stating that her full citizenship rights were restored even though she couldn't restore her gun rights, right?
That's correct.
And I want you to look at paragraph 2 of your letter. You say, a Davidson County Criminal Court has entered the order stating the court restored the full citizenship rights of, and I will leave out the name for the public record, while not restoring the gun rights of Ms. last name. Is that right?
Your Honors, this is a letter about citizenship and gun rights restoration, not relevance, I'm sorry, I didn't mean to speak, the objection.
It's already admitted. I asked you if you had any objection.
No, the testimony related that he's being asked about right now is all starting with gun rights, and I'm saying that testimony is irrelevant.
The question? Okay.
The very next sentence, Your Honor, is what I'm getting to about the sources that the coordinator uses to authoritatively interpret the election laws.
Okay, overruled.
So I read that first sentence. Do you recall if I read that first sentence correctly?
You did.
The second sentence of that paragraph, you write, the order appears to conflict with Article 1, Section 26 of the Tennessee Constitution, which states that the citizens of this state have a right to keep and bear arms. Did I read that correct?
You did.
And then the next sentence says, based on the Tennessee Constitution and Tennessee case law, I am of the strong opinion that gun rights are a citizenship right for Tennesseans, and the average Tennessean would consider gun rights to be a right of citizenship. Is that right?
Objection, Your Honor, the relevance of his opinion about gun rights and whether or not they need to be restored to this lawsuit.
Counsel goes to the issue of whether or not, in terms of his statutory duty to authoritarily interpret the laws and the sources that he used, including statutes, case law, and the question had to do with the Constitution. And this is an example where Mr. Goins respectfully references the Constitution. So this would be relevant. The objection is overruled.
Did I read that last part correctly, Mr. Goins?
Yeah, and to give context, so my prior answer is if something is unconstitutional, that's not something we normally would do. And we normally wouldn't look at the Constitution, but here was the interesting question that was posed to us in the corner we were backed into. Falls v. Goins said that you had to have your full right. It talked about a two-step process, and the legislature had tried to change the law in 2006, but they hadn't gone into Title II. They'd gone into Title 40. And essentially, Title II had a statute that's been amended now, but at the time it said you had to have your two steps. One of the steps is you had to have your full rights of citizenship. The struggle was, until the legislature just recently acted, full rights of citizenship was not defined. We had to go through, so this was unique. It was a unique situation, and one where, honestly, we struggled because, you know, here I am as coordinator of elections defining what full rights of citizenship are because I had to, because the legislature several years ago had put that language in the statute, and then when the legislature updated it, they intended to do one thing, they just didn't accomplish it statutorily. I agree with the decision, but we had to figure out what those were. And so we were looking, in that case, we did look at various sources. And I apologize if I misguided you on the prior answer. I was thinking more in the context of something being unconstitutional. But in that instance, we had to figure out what full rights of citizenship were. And unfortunately, the legislature had not given us a statute that said these are what they are. You had to figure those things out. Fortunately, the legislature has now answered that question. And I think that's very helpful. Although it happened in this case, I think it helped in others, particularly with fiduciaries and others, because they were in no man's land. They couldn't be a fiduciary in certain instances.
So thank you. I appreciate that context. In this letter, this is the result of your analysis, and I think you called it, you had to struggle with figuring out the right answer. You answered the question in this letter, at least as to this person, right?
Yeah, and some of this East Tennessee in me, some of it's just common sense and I realize that may not be something that should be drawn sources, but you know, that's just something that's kind of inherent as a citizenship right in many instances, you know, is gun rights. So I put that last sentence in there as well. And I remember in the deposition you focused quite a bit on that last sentence, but there was a lot of attorneys that worked on this letter, but that last sentence was the East Tennessee enemy, I guess.
And as a result of this letter, what you're telling the Sumner County Election Commission is, go ahead and register this person let her vote as a result of this court order?
I don't know. I think
If you look
so.
at
There was litigation in this, and it seems like there was. I think she was allowed to vote provisional, or
if you look
until
at the, I'm sorry.
until the litigation was done, or something. There was some litigation on this specific person.
Understood. If you look at the last sentence on the first page of this exhibit, you write, consequently, I advise you to follow the steps provided in the court order, process the voter
Yes.
registration, and count the provisional ballot for this person. Is that right?
Yeah, and the sentence I'm talking about, litigation concerning Ms. Hobson's request for restoration of rights is still ongoing, and this court order may ultimately be reversed or amended. If this happens, and the voter registration may be subject to being purged.
Correct. And so I just want to get the sequence right. In your
Yeah.
letter, you're saying, register this person, but if something else happens in the litigation, I may update you
Right.
and tell you to purge this person. Is that right?
That's correct.
Okay. So I think I have a little bit of a broader question than based on what happened here. Without, and I want to make this clear, I don't want you to tell me any conversations you may have had with your lawyers about this, but my question is, have you as coordinator done any analysis or thinking through whether or not Article 1, Section 5 of the Tennessee Constitution means that if people were not convicted by a jury, they can't lose their right to vote? Have you done any of that analysis is my question.
So I want to make a very limited objection. We know this question was asked in the deposition. We know it was answered in the deposition. We also know that he's had conversations since the deposition that would be privileged because they spoke to that issue with his attorneys. If the witness wants to testify as to what he said in his deposition, that's fine. It's the conversations that happened after that would be privileged if he has a new thought on it.
Counsel, you can't shield the witness through communicating about issues in the case through the attorney-client privilege. It's just it's a slippery slope, especially after a deposition. So if the question was asked, if he answered it, then you had conversations about his answer. That's kind of a slippery slope. I'm not going to limit the witness to testifying what he said in his deposition. So that's a real slippery slope, because not to say that you're unethical, but if we allow attorneys to do that in cases to shield their clients from having to answer questions, where would our legal system be? So I respect the attorney-client privilege, we all do. That's not an issue. But it's an important question. It's a question that the witness has already answered. And the attorney-client communication does not shield everything. It's in anticipation of litigation. We were already in litigation, so again, I respect the communications. Let's see how Mr. Goins answers that question. So I'm going to take that objection under advisement. You may answer the question, Mr. Goins.
So, independent of actually this week while I was here, so I have a job and I have to implement certain things. So the impact, and while Dr. Holloway was testifying, I started thinking through this, and essentially I was trying to figure out how this would work. And I hate to use this example, but it's the example that came to my head in all honesty. Take Mr. Epstein and his wife. If she were to if he were still alive, if she were to plead guilty and he was convicted of a jury, this is my analysis, okay? One would lose their rights, one would not, which would mean that election officials would have to go to the prison. They would vote one and wouldn't vote the other, because one didn't lose their rights, irregardless of print. And so I was thinking, if it occurred to me when she's talking about how smart the folks were at the Constitutional Convention, I'm like, Why, and maybe they did. That seems to me that would be a discussion that should be had, that they both, I think most anyone would say neither of those individuals should participate in the process because they traffic children, both of them. But literally, if CNN or Fox or MSNBC, if they were in Tennessee, if we had a horrible situation with those people, thank goodness we don't in the state, but could you imagine as the election officials walked into the prison to vote one of those and not the other? And that is the analysis that I did. It makes no sense to me that someone could commit the same crime, that they would never lose their rights at all. So it's not a permanent, I mean, you know, it is a permanent if you do something with children, but in that instance, one of them wouldn't lose their rights at all. And so we're literally going to prison to vote someone that horrendous. I can't wrap my head around that. We would have similar circumstances in Tennessee, not to that level, but murderers and just generic folks. So that is the analysis I have done. It's independent of them, but you got to understand, my thinking is, how do you implement this? How do you keep election officials safe? Because we don't live, I mean, they have to protect these judges. I mean, that's our, you know, that's kind of our country right now. And I'm like, if it was a high-profile case like that, literally, election officials could be in danger. So that's kind of, I'm more of implementing policy. That's my thought process. And that is honestly what I thought about while I was here.
You would agree with me, a constitutional right, you have the right to free speech. That right is not limited, even though it may be difficult or procedurally difficult to allow people to speak, right? You're not limiting constitutional rights just because the process is hard.
Objection, Your Honor. Relevance is to constitutional rights generally.
He opened the door with his testimony, Your Honor.
Did he open the door, counsel?
I don't think the witness can open a door. I think he asked a question that was objected to and got the answer that he didn't like. I don't think that justifies an objectionable question.
I'm sorry, I didn't understand that.
I don't think the witness opened the door to irrelevant questions, no.
How did he open the door, counsel?
Your Honor, he talked about constitutional rights and the analysis of what happens under the Constitution and how difficult it would be to implement. My only question is, should constitutional rights, in his opinion, yield to whatever process issues he's identifying?
Overruled.
You would agree with me, I'll re-ask the question, Coordinator Goins. Would you agree with me that if you have a constitutional right, like a gun right, you've got that constitutional right, and even though it may be difficult to implement, it's still a constitutional right, correct?
If
Calls for a legal conclusion. Calls for speculation. Both.
I'm sorry, could you repeat that, counsel?
It calls for a legal conclusion and calls for speculation.
Okay, legal conclusion, speculation?
I'm asking him a follow-up question from his point, which is, the premise is, if this were implemented, if this were decided that conviction by a jury was a prerequisite to being disenfranchised, his thought process is that would be very, very difficult to implement. And so my follow-up question is just, if something is a constitutional right, like a gun right, it shouldn't yield to process issues. It's still a constitutional right. That's my only question.
I don't believe it requires a legal conclusion. Again, he is the coordinator of elections, and he's testified that it's his job to implement the laws, to interpret them and implement them. So the question is a hypothetical. If the courts determine that this provision is either unconstitutional or Article 1, Section 5 requires a conviction by jury, then would Mr. Goins' office be able to implement or follow that law? Was that the question, counsel?
That's a version of the question, Your Honor.
Okay, restate your question.
So let me ask a slightly different question. If a court ruled that it is a constitutional right that a person cannot be denied their right to vote unless they're convicted by a jury, if that was the ruling,
Okay.
your job as coordinator is just to implement that, correct?
My job is, I don't know we could do it because I don't know how we separate them. There may be a database out there that says, I guess we'd have to work with the Administrative Office of Courts to figure out if there is a database that says this person pled guilty, this person was convicted by a jury. Just working the system, what I know, I don't think we could do that. I don't know that we could separate them, but we would do our best. If that's what the court says, then you better believe that we will, you know, we election officials do extraordinary things in extraordinary times. And so, and I'm not bringing on me, I'm talking about the counties. I'm talking about Linda Phillips. I'm talking about Alan Farley. I'm talking about Chuck Vest. We'd do our best.
And Coordinator Goins, just to go back to, I think, where we started with this line of questioning, my original question was, have you done any analysis about this conviction by a jury issue? And I believe my understanding of your answer is this week you've looked at it, but prior to this trial, that's not something you've analyzed.
I had not thought that through. I had kind of been similar thinking about implementation, but it occurred to me that these discussions should have happened, and then I went to the extreme of using two deplorable individuals while I was here. So I really hadn't thought through it. And then the other thing, and this is kind of getting into what I talked to counsel about, is how can it apply to one person and not the rest? So if the court says it's unconstitutional, the way I understand it, it's limited to Ms. Moses, but I can't reconcile in my head if the ruling comes down, I mean, does it apply just to forgery, or does it apply in falsifying evidence, or does it apply to murders? And maybe I'm going too far here with some of the discussions I've had. So I've done that analysis. As well. So that to say I haven't fully, well, I'm getting away from your question, and I realize it. I apologize. I'll stop.
No, that's fine. I think you answered my question about when you did that analysis. That was really the only question. Those are all my questions at this time, Your Honor.
All right, thank you, Mr. Harbin. Rick, cross-examination?
Thank you, Your Honors.
You're welcome.
Mr. Goins, gonna start with some direct about your role generally. Can you register a Tennessean to vote?
No.
Can you remove a Tennessean from the voting rolls?
No.
Can you or anyone in your office purge a Tennessean or group of Tennesseans from the voting rolls?
No.
Can you add a Tennessean whose right to vote has been restored by virtue of having lost it by the conviction of a felony to the voting rolls?
No.
Who is statutorily authorized to do those things?
The Administrator of Elections, and then if there's an appeal, then the County Election Commission can overturn the administrator.
And you almost predicted my next question. If an administrator of elections makes the wrong decision on registration, on purging, or on restoration, can you correct that wrong decision?
No.
And who, in fact, is statutorily entrusted to correct that wrong decision?
The County Election Commission, and that's considered a final administrative decision. So then they could go to the court system.
Okay, and do the county election commissions report to you?
No, they report to the State Election Commission.
And do you appoint members of the county election commission?
No.
Okay, and you use the word administrator quite a few times in your testimony. Who are you referring to by the administrator?
Administrator of Elections.
And those are appointed by the various county, is that right?
Yes, the State Election Commission appoints the Election Commission, which in turn appoints the administrator.
Okay, and if an administrator of election is not doing their job, either say not registering people they should, or purging people they shouldn't, or not restoring people that they should, who has the authority to hire or fire that administrator of elections?
So the State Election Commission doesn't have the authority to fire, they can decertify, but the local election commission has the authority to fire.
Do you have any authority to hire or fire or correct the decision of a county election commission?
I don't have the authority to hire or fire.
Okay, and now, let's get to what the statute says you do. You do have the statutory mandate and authority to authoritatively interpret state election laws, is that right?
Yes.
And once you interpret those laws, you generally pass those interpretations to the various county election commissions and administrators, is that right?
Yes.
Okay. In your experience, do they more often than not follow your interpretation?
Almost always.
In your experience, do some county election commissions and administrators, specifically Shelby and Davidson, retain their own counsel for interpretive needs?
Yes, in fact, as the judge pointed out, I knew that letter from Linda Phillips after she pointed, you could see where they copied their attorneys, as was already pointed out.
And
yes.
Let's be more clear for the record. You're referring to Exhibit 65, are you not?
Yeah, and to be clear, some counties, if it's a HR issue or if it's a public meetings that's outside of Title II, other counties will consult with their county attorneys. It's rare, but it does occur if there's a personnel issue or those things. Shelby and Davison's different because there could be a substantive issue in Title II, and if we, sometimes if Shelby County doesn't agree with us, or if Metro and Davidson County don't agree with us, we'll have conversations. And then also you have a Metro charter you have to deal with, you have different charters down here. So the answer is those two, and Hamilton County at times has had an attorney. So you see this sometimes in the larger counties, but those two have consistently utilized attorneys more than the other counties.
What, Coordinator, given that this case is focused on a Shelby County voter and restoration and would involve the Shelby County administrator, let's drill down on Shelby County. Shelby County always, to your knowledge, includes their own independent counsel in interpreting election law. Is that right?
I don't know that I would agree with always. I mean, there's certain things that, they're lower profile, but anything that is high profile, my understanding is they normally will consult with their attorneys.
And if you don't mind putting Exhibit 65 in front of you, that letter you just referred to.
I have no idea where it is.
We can hand you another copy if you can't find yours.
Yeah, if somebody could hand me a copy of that, that'd be great. Oh, 65?
Yeah.
I apologize. These different numbers throw me off.
Oh, there's two stickers on your copies. I'm sorry.
Yeah, that's the problem. I've got it.
Okay.
You're talking specifically about, Exhibit 65 has several things, but you're talking about the letter from Linda?
Yes. What is that letter? What's the topic of that letter?
That is regarding Ms. Moses.
And in fact, that letter, who wrote it?
Linda Phillips.
And who is Linda Phillips?
Linda Phillips is the administrator of elections for Shelby County.
And who is that letter to?
It is to Ms. Moses.
And who is copied on that letter from the administrator of Shelby County Elections?
Those are the two that's copied. One is deceased, the other one, John Ryder's passed, and the other one is Pablo. And honestly, I don't know his last name, but he's an attorney. I do know his last name, I can't recall it right while I'm here, but he is no longer their attorney either. He's maybe with the Attorney General's office, but anyway, those are two attorneys that we've worked with for a while, and then there's another attorney here, Moniz, that we've worked with as well, and then now Jacob Swally.
Okay, and those attorneys are not associated with your office at all, are they?
They are not, other than Pablo may work with the Attorney General's office, but he's not associated with us. He handled an election case when he first came to the AG's office.
Yeah,
And
and
worked on one, but at this time, at this moment in time, he was not affiliated with us in any way.
okay, and he wasn't at the Attorney General's office at that moment, was he?
He was not.
He in fact worked at John Ryder's namesake firm.
That's correct.
Okay. And so when Shelby County was talking to Mrs. Moses about her right to vote, for lack of a better term, in fact, the Shelby County Election Commission didn't copy you. They didn't pass on a letter that you sent them. They in fact sent Ms. Moses independently a letter copying their own independent attorneys. Is that right?
That's correct. I wasn't copied. We may have received it. You know, counsel said we turned it over for discovery. I don't know whether we received it or not, honestly, but I was not copied.
Okay. Related to this, have you, and I don't want to besmirch the name of any election administrator in Tennessee, have you ever given an interpretation to an election administrator that basically just said, I don't agree, I'm not doing that?
We had an election commission very specifically disagree and would not comply with what I had interpreted the law.
Okay.
We've had it a few times. Yes, we have.
And so
We've
just,
had an administrator, we've had election commissions, yes.
and so just because you tell an administrator what you think the law says they should do, or an election commission what you think the law says they should do,
Yes,
they don't always do it, do they?
they do not.
Okay. I want to talk about the voter list that Mr. Havenreich talked to you about. Does the coordinator of election or your office, the division of elections, do you keep any independent list of voters?
List of voters. What do you mean by that?
Do you maintain a list from your own sources beyond what the counties give you?
No, it is with the counties, and there's, whatever the county has is what gets transferred to us. If there's a slight period, if someone registers in Shelby County today, then it's not gonna be in the state system until that night, but, you know, that early morning. But other than that, if someone, our list is either who the county has listed, or PERS list would be similar.
Okay, and so I think we heard testimony that you send purge lists to the various counties, is that right?
So we send lists of potential voters that need to be looked at to figure out whether they're purged or not.
Perfect, that's
And we
about,
normally do different categories based off the match. There's a lot of data we deal with.
you're almost guessing my next questions. You mentioned categories. Tell me about the categories on the purge list.
So, and there's different types of purge lists. You got the non-citizen list. That's a list where we send to the counties. And that one actually is a little different than some of the other lists because the legislature says that those folks have to be notified by the election commission. They have 30 days to respond. So we send that out. We may, I don't know if we have hard and soft matches on that one because that one's different because the voter gets notice and has a chance to respond. When we do a compare with folks that, we're allowed to use commercial sources if someone's moved to a different state. We have different levels there. We'll have level 1, level 2, may even go to level 3 on that one as far as data that we think is the person, but we're not 100% certain. And then with the same thing with the felon restoration, we'll have different levels of individuals. The death list as well. We'll have, sometimes on Social Security numbers, it could be that the voter, the person that registered to vote might be off a digit, or it may be that when the election officials entering in the information. It could be off a digit. So we see that not quite a bit, but you'll see that on, in a year period, you're going to see everything matches except maybe a couple digits on the Social Security number or a digit on the Social Security number. And,
Let me see if I can focus you in on what I'm trying to get at.
focus me. I'm sorry.
So you send these lists to the various counties, and I assume you don't send the entire list to each county, you just send the applicable people to that county, to each county, is that right?
Yes, but there's some instances where we're not sure what county the person's in.
Okay. In these categories, do you then expect the counties just to look at the list and say the coordinator told us to purge these people, we're purging them? Or do you expect the counties, in fact, to make an independent analysis of which of these people should remain on the voting rolls and which of these people should be removed?
The county administrator has to make an independent analysis. And once again, they're trained different levels to, if it's category 1, it's a reasonably degree of confidence. 2, we think, not sure.
And so you're not, in fact, sending the counties a list of people that must be purged. You're sending the counties a list of people you'd like them to investigate and decide whether should be purged.
Yes.
Okay. Could you go into the database that Mr. Habenreich asked you about, that the state has, and independently just go in and say, I'm going to do the purge myself. It's easier that way instead of 95 administrators.
No one in my office could do that, and that's just not something the coordinator does.
And in fact, the coordinator is not statutorily authorized to do it, are they?
That's correct. If someone were to manipulate the rolls, then the county would catch that, I would assume. But if they didn't, then someone would be, that would be criminal in my mind.
Okay. As it relates to restoration, and we will get deeper into restoration, but broadly speaking, if someone goes to court and petitions the court for their restoration and successfully receives that order, and they brought it to you and said, I'd like to register, what would your response be?
So the statute actually is fairly clear. It says submit to the county. So we would tell them they would need to take it to the county. That's the language. It doesn't say give to the coordinator. It says give to the county.
Okay, so you wouldn't register them.
Oh, no, I would not register. I can't.
In fact, not statutorily authorized to.
Yeah, whether they committed felony or not, if someone brought a voter registration form, we would forward that on. In fact, when we do a voter registration drive, we invite the county, we will have them either deputize, so the Grizzlies, we've done voter registration drives at the Grizzlies. I will invite Ms. Phillips to have a staff member there, or we will try to get her to designate us in order to do there's a statute that says you can designate someone to intake these voter registration forms. But the reason is not to register them, is to help the voter, because if an election official or someone that's not been designated accepts a voter registration, if someone not authorizing the statute accepts this, then the voter has to come and vote the first time in person. So Linda can deputize a citizen in here to be authorized to accept those forms. The administrator still has to decide if they're eligible. But even as a coordinator of elections, when we do a voter registration, because of the way the statute is set up, we either have to have someone there from the Election Commission office, or we will get them to designate us so the voter can literally vote by mail the first time if they qualify, as opposed to showing up in person.
And I want to give the title the respect it needs. Is it Administrator Phillips? Is that how I should refer to her?
Yeah, she's Administrator of Elections.
If Administrator Phillips sent you a order allowing restoration for verification, and you verified it, but then attached to that verification a letter that says, I still don't think you should register her for the following reasons. And then Ms. Phillips went ahead and registered. Anything you can do?
I could potentially take it before the State Election Commission.
So the State Election Commission could do something about it if it was brought to their attention.
That's correct.
But you couldn't reverse her decision.
I probably would reach out to her Election Commission first. But I couldn't do anything. Yes, either local election commission or the State Election Commission. I couldn't say you're fired, Linda.
And nor could you say, Linda, you must register this person, I'm making you. Or must not register this person, I won't allow it.
I could say it, but she would talk, I mean, I can say anything, but that, you know, she didn't follow, she didn't follow.
Sure. I'd like to put exhibits 54 through 56 in front of the witness. Can we grab those? And for your honors, those are public acts of 1986, 96, and 2006,
Okay, thank you.
for your own sake.
All right, thank you.
I think that's right. Is that not right? I think I have my numbers right. This is my, like, one of these numbers for you. If, may I approach the reporter to, thank you, Your Honor.
Right.
But he can't make her do that. Okay, that's fine.
We good?
Yes.
All right, thank you, Your Honor. If you could look at the first one with me, it's the Public Acts of 1986. Do you see that?
Yes.
And who sponsored this public act? I think you can see it on the first page, second page.
Senator Cohen, who's now a congressman down here in East Tennessee, and Representative Cobb.
All right, and I want to steer you to what is section 1. Or first, let's start with the title, an act relative, do you see where I am?
Yes.
Can you read that for us?
An act relative to restoration of voting rights to convicted felons after release from incarceration, and to amend Tennessee Code annotated Title 40, Chapter 29, Title 40, Chapter 27, and Sections 2-2, 139.
All right, and so to be clear, this is a restoration statute, not a disenfranchisement statute, correct?
Objection, Your Honor.
What's the objection?
Misstates the evidence and also calls for legal conclusion.
Do we have a copy of the statute? What exhibit was that? Was it 65?
54, Your Honor.
54?
Yes, Your Honor.
Okay, counsel, how does it misstate the statute or the evidence that's in evidence?
I think the objection really is that there is no evidence about this statute or what it is. I think you can ask the coordinator what kind of statute it is. But it also does call for a legal conclusion as to the terminology Mr. Heller was using.
Could you restate your question, please?
Yes, and, okay, I'll just ask the very same question again.
Yes,
Yeah. Is this in fact, and I'm going to try and get the words as close as I can, is this in fact a restoration statute or a disenfranchisement statute?
This,
Your
Okay,
Honor,
let's
same
take-
objection.
Okay, let's take a look at the statute. Do we have a copy of it? Do you have a copy? Did you find it?
Find it, I haven't found it
Okay.
yet.
55?
It's 54, 55, and
54.
56. I'm
Okay.
sorry, I gave you guys my only copies yesterday, I'm sorry.
That's okay. Mr. Okay, Mr. Court Reporter, do you have a copy of this, marked exhibit 54, 55, 56? Can we see the witness's copy, please? Just, and then we'll give it back to him. Okay. Okay.
Okay. Okay. Okay, now I know what it looks like. I remember seeing it.
Hey, Mark,
Oh, that's what
you okay?
Okay, the objection is overruled. The witness can answer the question if he can.
so this this is not one that would say you don't have your rights. This would be an opportunity. It's a path. It appears Senator Cohen was, and Representative Cobb was setting up a path where someone could get their rights restored. So
Okay.
someone, at this point, someone's lost it. This is how you get them.
Okay. And could this act possibly apply to any non-felon?
No.
Okay. Now, I want to ask you before, well, first, let's start with Section 1B. Can you go with me to that? Begins provided, however.
What section was that?
1B.
Thank you.
I'm there.
Okay. And Section 1B states, provided, however, persons rendered infamous after the effective date of this act by virtue of being convicted of one of the following crimes shall never be eligible to register to vote in this state. And then it lists first-degree murder, aggravated rape, treason, or voter fraud. Is that right?
Correct.
And was that the first time, to your knowledge, that these sorts of, this carve-out was in the code?
I don't. 86, 96, and 2006 are the three that I'm familiar with. I think so. I'm not. Honestly, I'm not 100% certain.
Okay.
I don't know.
And let me ask you if you can flip to the, or not flip, sorry, the bottom of that page, and it's going to be Section 1D. It says, any authority issuing a certificate of restoration. Do you see that?
Yes.
And you know what? I pointed you the wrong place. Before we go to 1D, 1C. Sorry.
Go where?
1C. It's right above 1D.
Okay, 1C.
You see where it says, any person eligible for restoration of citizenship pursuant to Section A of this act shall be issued a certificate of restoration upon a form prescribed by the coordinator of elections. You see that?
Yes.
Was this the first instance in Tennessee of restoration being allowed by certificate as opposed to court order?
I do believe that's true. Yes. Yes.
And so in short, this statute made it easier to have your rights restored by, instead of requiring you to go to court, it only required you to get a certificate filled out, which was normally filled out by a parole officer, right?
Objection, Your Honor.
What's the objection?
A combination of leading and.
I'm sorry?
Excuse me, combination of, we object to the leading, but also.
Well, leading is crossed, so he can lead.
Understood, Your Honor. The
Okay.
other objection would be that this is essentially counsel testifying as to a legal conclusion as to what this statute means.
Well, again, Mr. Goins is the coordinator of elections, so he's charged with understanding certain laws and implementing certain laws. And with regard to restoration, that's something that his office has handled. And at some point, if restoration was allowed through a certificate of restoration, Mr. Goins would arguably be knowledgeable about that, so the court does not think that it calls for a legal conclusion, and if it does, that it would not be outside of his scope of knowledge, so the court will overrule that objection.
Thank you very much, Your Honor. Thank you. And so, Coordinator Goins, this statute sounds like, for the first time, it did two things. It created an easier path to restoration, as well as designating certain criminal violations. The people who have committed those is unable to have their rights restored. Is that right?
Yes.
Okay. If you could go to the next exhibit, which is going to be 55. And that's the Public Acts of 1996. Do you see that?
Yes.
56.
And,
No, 55.
and who sponsored Public Act of 1996? Is it written on here?
It's not on my. I don't know who sponsored this one.
Okay. This Public Act, in fact, took away that simpler avenue, did it not? It took away the certificate of restoration process. Is that right?
I'll have to read it. I didn't implement this.
Let's look at section 2. And if you look at, it looks like C1. Do you see where I am? It says except as provided in 2B.
Hey, give me a second. Let me read it.
Yeah.
If you don't mind. Yes.
And so here, this amendment to the Tennessee Code again required people seeking restoration to go to the court and petition the court. Is that right?
That's correct.
And it took away the much simpler process of a certificate of restoration, didn't it?
I'm just checking to make sure it deleted everything.
It's okay, take your time, Mr. Goins.
Well, and if I could point the witness.
No, just
Okay,
let him
that's
read
fine.
it. It's a long statute, so he wants to read the statute. Or should I say bill? Is it a bill or a statute?
This is, so the way the public acts work, this is
Oh,
what
public act,
goes to the
okay.
clerk. Yeah.
Yes, okay.
I'm getting there.
All right. I apologize. So just to be clear, I never worked under this
Sure.
framework. That appears to be what that did. It went to something very similar to what we have today.
Okay. And I want to draw your attention to section 2B.
What was that section?
2B. And it's just because it now amends the law. Let's read what 2B says. If a petitioner was rendered infamous or deprived of citizenship rights by judgment of a federal court, the circuit court shall give notice in subdivision A of subpart to the United States and the district attorney. Is that right?
That's correct.
Okay. And so this now, in fact, required notice of restoration to go to the authority that actually had the conviction. Correct?
Yes.
Okay. You can put that one away and let's go to the next numbered exhibit, 56. And who sponsored exhibit, or what is exhibit 56? I'm sorry.
It is Public Acts 2006, chapter number 860.
And who sponsored this public act?
So I'm more familiar with this one. In fact, I know every sponsor on this. I served with them in the General Assembly at one time, or most of them, but I know all of them. Senator Cohen, once again, who's now Congressman, Representative Senator Kilby, who was from Morgan County, Bowers, who was from Shelby, and Senator Thelma Harper, who was from Davidson. Representative Larry Turner, who was from Shelby, Representative Maharo from Shelby, Ulysses Jones. A lot of these have passed away, actually, but Chairman Jones, actually, he was chairman of the committee I served on. He was from Shelby. Representative Barbara Cooper, Representative Henry Brooks, those two are from Shelby. Representative Joanne Favors, I think she was Davidson. Representative Shaw, he's here in West Tennessee, still in the legislature, actually. Representative Langster, Representative Tidwell, Representative Briley from Davidson, Representative Brown from Chattanooga, Representative Pruitt, I think was from Nashville, Representative Towns is still in the legislature, he's from Shelby, and Representative Larry Miller, who's from Shelby. He also is in the legislature, so Representative Shaw, Towns, and Miller have survived. Representative Shaw, unfortunately, is leaving this time. This is his last session.
And do you see several members of the Tennessee Black Caucus at the time as sponsors to this legislation?
Yeah, most of them, and Senator Cohen is white, but Representative Larry Turner, who actually sat in front of me in the General Assembly, he's a black gentleman. He's passed away.
Okay. And Coordinator Goins, did this act, for the first time since 1996, bring back the certificate of restoration process?
It did, yes.
And so again, this act made it substantially easier on felons seeking to have their rights restored. Is that right?
The goal was to make it easier, correct.
It did another thing, though, didn't it? Did it add to the list of ineligible for restoration crimes?
It did. It broadened it.
And let's talk about what got added, if you could steer us to that section.
So that is, it is section, it's the last part of section 1.
So page 3, I think the top.
Yeah, it's page 3. I apologize, it's a better way to get there. It starts with, notwithstanding the provisions of this part, the following persons shall never be eligible to register and vote in this state.
Okay, and what crimes can you just read that section? I think that's important.
Yeah, those convicted after July 1st, 1986, of the offenses of voter fraud, treason, murder in the first degree or aggravated rape. So that was in the prior law that you passed. They just put that in there again. And you can't go retroactively, so I assume that's why the dates are in there. Those convicted after July 1, 1996, but before July 1st, 2006, of any of the offenses set out in subdivision 1, or any other degree of murder or rape. Those convicted on or after July 1st, 2006, of any, and this is a pretty broadening, this is where it broadened, any of the offenses set out in subsection 1 or 2, any other felony of Title 39, Chapter 6, Parts 1, 4, 5, designated as a felony. I think that's where Ms. Moses falls in, but any sexual offenses set out in 40-39-202, 17 are violent sexual offenses set out in 40-29-202-25 that is designated as a felony and where the victim of such offense was a minor.
Okay, and so I want to focus in on two things you slid in there that were going to be follow-up questions. There are different dates for which something becomes permanently barring someone from seeking the right to restoration. Is that not correct?
Yes.
And you threw in the word casually, retroactively.
That's
Do you remember
correct.
saying that?
I did.
And is that, in your understanding, not a nod to Article 1, Section 5's provisions as to the retroactive declaration of disenfranchisement or inability to be re-enfranchised?
Objection, Your Honor. To leading again, and I want to clarify my objection here.
Okay.
My understanding is that under the rule that permits me to call an opposing party during our case in chief and cross-examine them as if they were called by the other party's case in chief, I don't believe that rule allows the counsel for that party to also lead. I believe the questioning is supposed to be as if it is a direct examination. That's why I'm objecting to the leading.
Want to cite me to that rule, please?
It's Rule 611, Your Honor. 611,
Yeah.
Tennessee Rule of Evidence 611
Yeah.
has to do with if
Scope of the cross.
if I call. Yeah,
If
I call.
if I may, Your Honor, it is Rule 611, and it directly addresses this point. Section C of 611 is titled Leading Questions. And if we skip down to C2, the very last sentence, The scope of cross-examination under this paragraph shall be limited to the subject matter of direct examination, and cross-examination may be by leading questions. This is a cross-examination.
And Your Honor, our position is this is not a cross-examination. This is their witness. It is their client. This is direct examination. The cross-examination referenced in that rule was my examination. I was cross-examining the witness because it's an adverse witness. Our position is that applies to my questions, that this is their client and their witness, and so they need to proceed by direct examination.
It gets a little murky because on yesterday, we discussed including the direct examination as part of the cross-examination for purposes of time. So, is the scope of your cross, is it limited to questions related to or arising out of the direct, which was really by leading question, because it was still a direct examination? The 611 just allows you to conduct the direct by leading questions because it's presumed that because he's a party opponent, he would be a hostile witness, but only as to parties. So on direct, we have leading. Is your cross arising out of the scope of the direct, or are you asking questions that if you would call him again on your direct would be different from questions arising out of the cross? Because that does make a distinction.
It certainly does. And Your
Yeah.
Honor, I will admit openly that part of my outline actually says don't lead because it is new stuff. They addressed in their direct the restoration process. They addressed in their direct his role in that process and his interpretation of those laws. This is nothing more than the foundation of that restoration process leading up to the
Yeah.
06 law, which is the one that,
Yeah.
okay.
Yeah, and we interpret the cross-examination, the scope, pretty broad in terms of whether or not it's relevant or arises out. So that's a pretty broad interpretation. So while the questions may be very different, it still relates to duties and obligations that the coordinator has in terms of the restoration of voting rights and the role that his office plays. So to the extent that he's required to understand the laws and the changes in the laws, I think that is closely connected enough to bring it within the scope of the direct examination. So for those reasons, I will.
And Your Honor, my only concern here is that when
Mhm.
we are talking about the key statute that's at issue in this case and being challenged, and he's asking questions of Coordinator Goins about that, if he's permitted to ask leading questions, that allows counsel to essentially lay out what is the lawyer's interpretation of these statutes as a leading question.
Well, you
And
get a
allow Mr.
redirect.
Goins to-
You get a redirect, but I learned as a young lawyer, and it was a hard lesson to learn over in criminal court. That's why I didn't really practice much criminal law, but sometimes you have to think about, the risk of calling a person, a witness, on direct examination because your opposing counsel does get to lead. But even though it's an important aspect of the case, I understand that. That's not how we determine whether or not it arises out of the scope of the direct. So, if you have an argument that it doesn't arise out of the scope of your direct, that would be more persuasive than your
Understood.
other arguments so far.
And I think with this specific question, I know Your Honor touched on it. I didn't ask Coordinator Goins about the language of this statute. I didn't ask him about the 2006 statute, certainly not about the 1996 or the 86 statutes. We didn't look at the text of the statute itself. I didn't ask him to identify the permanently disenfranchising crimes, the legislative history, who voted for it, who didn't. We didn't get into any of that in my questioning. So I do believe this is outside the scope.
But you did ask him about, or did you ask him about the restoration of rights in Tennessee? People who are disenfranchised and the restoration of rights.
I asked him about the process, the later process, once someone has obtained a court order. That's where we started. What happens then? And so we went through, they submitted to the administrator of elections, the administrator of elections sends it up to the coordinator, the
Mhm.
coordinator responds. We went through the process,
Yeah.
but we didn't get into any of the
Yeah.
legalities or the statute.
Right, but the prior acts speak to the process prior to what is in place now. So I think, defense has the right to go back and look at the prior acts leading up to. So I think that arises out of the scope of the direct. So for those reasons, the objection is overruled.
Thank you, Your Honor. I'll restate so you don't have to remember something from a bit ago. These differing dates for when the permanent ban on reenfranchisement became effective for the new crimes. In your role as coordinator of elections, do you believe that is a nod to Article 1, Section 5's retroactivity provision?
Yes.
Okay. And so whenever this General Assembly wants to add, if they would like to add, a new disqualifying law, they could only make it disqualifying from the effective date forward. Is that correct?
Yes.
Okay.
Okay.
Yeah. Your Honor's counsel's asked if I could request a 5-minute restroom break.
Yeah, actually, this is a good time for us, so we're inclined to go ahead and take our lunch break now and then come back about, maybe 10 minutes to 1. It's 10 minutes to 12, so why don't we do that as opposed to taking a recess, coming back, and then having to stop again? Is that okay, Mr. Goins? Okay. All right, very good.
Thank you, Your
Okay.
Honor.
Okay. We'll stand in recess.
To do
No,
review.
no, you're okay. Listen, I'm never going to say no to
we'll just start over. You just tell us when we're ready, and then we're gonna start all over, okay? Okay. All right, court is back in session. Mr. Goins is still under oath. You may proceed, counsel.
Thank you very much, Your Honor.
Yes, sir.
Mr. Goins, we're gonna transition a little bit to a topic we've been touching on, but I'd like to go more in depth. We've talked about the 1986, 96, and 2006 laws, when it went from allowing certificates of restoration to no longer allowing them to allowing them again in 2006. Is that right?
Correct.
Okay. And what I want to talk to you now is about 2006 to the Supreme Court decision in Falls v. Goins, which was, do you remember about the year?
June 29, 2023.
Okay. And so from 2006 to, you knew the exact date, from 2006 to June of 2023, there were 2 avenues for restoration. Is that right?
Yes.
Okay. And those 2 avenues generally were circuit court petition and certificate of restoration. Is that right?
I'm sorry, what period are you referring to, counsel?
2006 to the Falls v. Goins decision in 2023.
Okay, thank you.
Yes.
Okay. And for that time period, let's talk about how a convicted felon were to go about getting a certificate of restoration. Can you give us some insight into how that process worked for each convicted felon?
The majority we saw was when the person was being released from probation, the probation officer would fill out that they had served their time, they were off probation. And if the probation officer knew it, or if they'd send them to a clerk, there's other information they'd put on that COR, Certificate of Restoration. One, whether the victims had been paid, if there's victim restitution, if it had been ordered, and then also if court costs had been paid. And so that was 2 requirements. And then child support, that's something that we checked at our office. So when it came in, the COR came in, we would work with an agency at the state to check to make sure the child support had been paid.
Okay, and what I want to hone in on here, though, is in relation to the certificate of restoration process, I'm trying to hone in on what exactly the convicted felon seeking restoration had to do. And so the first thing you said was they would take this certificate of restoration form to their parole officer, is what I heard you say.
Normally, a probation officer would give it to them, or it could be a parole officer or whatever, but they would give that form to them when they're being discharged.
Okay.
They could do it independently, so if they'd been discharged 5 years and, hadn't lost the form, didn't get a form, whatever, the form was readily available as well.
Okay.
On our website. It could be distributed different places.
And then would the form contain those additional pieces of information you just referred to? Would they have to certify that they had paid their child support and their victim's restitution?
Someone else, a government official, would have to certify that.
Okay, so then they'd have to go collect those certifications as well?
That's correct.
Okay, and then they'd submit those certifications in a packet to whom?
The local election commission.
Okay, and the local election commission would do what with that submission?
They would send it to us.
And then what would your office do?
Verify child support.
And that was it?
Well, no, they would, so in the beginning, so the form changed. At one point, we didn't have the statute they specifically were convicted under. So sometimes it would say that this person was convicted of burglary or whatever, and it didn't have. So at some point, it was added what statute specifically. And so we would look at the statute too. Once that was added, we would look to see if it was someone that wouldn't be eligible. So you'd look at that, you would look at child support, and then you just made sure that a proper authority had, filled it out, not the person, checking it, signifying it, but someone else, a government official, had signed it.
And I think we all know what you're referring to, but for the sake of the record, when you said we would check the statute at some point, you mean you were making that check to see if they had been convicted of one of those statutes for which people were not allowed to apply for restoration?
That's correct. And Beth could probably testify to this better than I, but at some point I remember there was some issue with some of the forms.
Okay.
Because we hadn't put that on there, what necessary statute there was. I remember there was some issue that we had to go there, but that was something that people had to start checking, made sure they started checking.
And so this packet would come to you from the County Election Commission. I think you said would certify child support payment and then the statute convicted upon. And you would then do what with that?
So if everything lined up, then there was a letter very similar to, it's actually kind of a form letter. My signature is electronically put on there, but it's whoever was doing felons would generate, and then they would send to the county.
And what would the county then do?
The county would either register a person or not register.
And so the county would make the decision whether or not to register this person.
That's correct.
Okay. And then the other avenue was to petition the circuit court, right?
Yes.
And if one petitioned the circuit court without going through every step of that petition, would it end in a circuit court order of some sort?
Yes.
And would you receive notice of that order from the circuit court?
Honestly, I don't know. I can't remember whether we did or not pre-files.
If the circuit court issued an order restoring the right, what would the convicted felon then do?
They would submit it to the local county.
And then the county collection commission would do what with that?
They would send it to us. I do remember at one point we got court orders, and then another point we didn't. So I think the law changed. Partly during my tenure, we've received court orders. Sometimes we didn't receive court orders because it was creating confusion too, because we'd get a court order from, Campbell County, and the person actually moved to Davidson County, and so the statute was changed. But yes.
Okay. And when you received it, what would you then do with it? From the
When
county
the court order came in, so we had a few instances where, so when you went to get a court order, you had to certify that you were eligible before the court. And not a lot, but we had some that may have tried to go the COR route, and we knew that they weren't eligible because of child support or something like that. And so if we were to catch something like that, then we would, they didn't get the letter of eligibility.
And so what would the county commission then do?
Well, presumably they wouldn't register the person to vote.
Would you ever reach out to the individual voter to tell them that you thought they were ineligible?
No, we got one instance where this happened. There was a lawsuit that was filed, but the court agreed with us because the person had told the court they were eligible. So ultimately, in that instance, there was some communication with that specific voter because the voter was upset that he had a court order, and so at that point we did talk to that person. That person got an attorney, and then the attorney started. But in general, no. There's occasion where the folks will call us, and that's one very specific that I can recall that we had communication with.
And if someone did call you, would you refer them to the county commissioner, or would you just answer their questions, whatever it was, and choose to register?
So in that instance, in the one situation, I didn't take the call. Kara Har was an attorney that was there that took that call, and I think she
Go ahead.
am I answering the wrong thing? But basically, she just shared with the person, you misled the court, and so in that instance, no, we didn't refer them to the local county. I mean, based on my recollection, and like I say, it ended up in litigation.
Okay.
He was very upset. The reason I remember him very specifically, he was upset. He was an upset person.
Understood.
Well, I understand why he was upset, but
Yeah.
He misled the court.
I don't want to attempt to summarize a Supreme Court opinion that was not short in a couple of sentences, but something about Falls v. Goins led you to change your interpretation of how certificates of restoration and how court orders needed to operate for restoration. Is that right?
Yes.
And generally speaking, was it the opinion of the division that a certificate of restoration alone was enough to restore rights to vote?
It was, and that was based off the. Like I say, I think the General Assembly in 2006 meant to do one thing, but unfortunately they failed to go into Title II, and Title II had language that said you had to have your full rights of citizenship. I never had the ability. The election officials can't restore someone's full rights. We're charged with the voting part, and so when that happened, although the COR process was intended when former Congressman Cohen and Representative Turner tried to pass that bill, they just didn't go into Title II. They didn't change that language. And so the Supreme Court, strictly interpreting the two different statutes and the interplay among those statutes, said, you got to do one, too. That's a step one. You got to have these full rights of citizenship. And then you go to what Congressman Cohen, Senator Cohen at the time said, and you look to all these other things.
And so it became a two-step process for convicted felons.
That's correct.
Or let's be more clear, it became either one or two steps. They could either go straight to the circuit court and skip the certificate of restoration, correct?
Yes.
Or if they had a certificate of restoration, they still had to go to the circuit court after they got that. Is that right? Let me withdraw that.
No,
actually.
no, that's not
yeah.
true.
Let me withdraw that question.
Sorry.
Agreed. Jeez. Let me fast forward. 2025, the statute changed. Is that correct? And it changed it from a two-step process, certificate of restoration and circuit court order, to just circuit court order. Is that right?
That's correct.
All right, now let's talk about that process right now. And I know Mr. Havenreich generally went through it. I want to focus in on a couple of things. Whenever someone files a petition with the circuit court, the Division of Elections gets notice of that. Is that correct?
Correct.
Okay. And you were asked initially if both the Attorney General and the Division of Elections could object to such a petition. And I think you disagreed. Is that right?
Yeah, the original version of the legislation did allow us to object, and fortunately, the legislature took that out.
Okay. And so only the Attorney General.
And I wanted them to take that out, honestly.
And so now only the Attorney General can object.
That's correct.
And the statute's pretty clear. Is the Attorney General objecting on your behalf or on behalf of the state?
The statute says on behalf of the state.
Okay. And so the statute doesn't give you any special standing or any special voice to cause the Attorney General to object, does it?
No.
Okay. Now that said, practically speaking, you can always pick up the phone, call the Attorney General and say, we see a problem, we think you ought to think about objecting, but that carries no more weight than me making the same phone call, does it?
You'd have to ask the Attorney General on
Okay.
that one. I would hope I would carry some weight, but you'd have to ask the Attorney General.
Statutorily, you're not granted any special weight or standing.
No.
Okay. The county clerks, are they notified of petitions for restoration? Or, I mean, sorry, the county election officials.
Only when the voter brings it in.
Okay,
Not notice from the court, no.
okay, perfect. That's what I was asking. Who makes the decision on restoration? The Attorney General, you, or the Circuit Court?
Circuit Court,
Okay.
post false.
And nothing in the statute gives you standing to intervene or to cause the Circuit Court to consider your opinion, does it?
No, and I said post false, I should say post legislation.
Yeah.
But yes, post new law.
When someone receives their order from the Circuit Court, so do you get notice of an order granting restoration?
Will you repeat that again?
Yeah, so let's say the Circuit Court's now decided the petition. We're past the filing stage. They've decided it. And let's say they've granted the petition for restoration. Do you receive notice of that from the court?
Yes.
Okay. And do the county election administrators receive notice of that from the court?
No.
Okay. What does a convicted felon do with that Circuit Court petition?
They take it to the county they're registering in.
Perfect. And what does that county election official then do?
They send it to us.
And what is your role once it gets sent to you?
I have a staff member look at the two documents, look at the one we received, look at the one that was sent to us, and if they match, if it's the actual document, then we send a letter saying we can verify that that's a court order.
And so you're basically, your verification is just to say, it's not forged, this is in fact the court order, is that right?
Yeah, we compare the court orders.
And you make no recommendation on whether to register this person, you just verify that yes, that is in fact the court order.
At that point, the court has restored the right to vote. If it's a valid court order, that right has been restored.
Understood, but you make no decision on registration.
No, it's the county administrator that decides.
Because a felon could have their right restored, but be ineligible for other reasons, is that right?
Yes.
That's all I have on that, and this is gonna be my last topic before just so I'm clear with your honors, I get to my direct, so beyond the scope of cross. You were asked about the new law pertaining to the database that's gonna be kept. Do you remember that?
Yes.
Okay. The one thing I want to focus on is once this database is kept and someone seeks to register, and I think you said we're looking to catch things on the front end instead of the back end.
Right.
Is it the county election officials that query the database, or is it someone in your office?
So we're creating a portal, and the individual county will enter in that information, and it's going to ping the information from a different agency. So it's not like the database is essentially created. So it's not like we're creating a new database. The TBI or Department of Safety, depending on, there's two different portals, but the TBI has already created the database. We're just pinging that database, and I say we're really the local election administrator. And if it says that that person is not a, if it flags them as a person that's committed a felony, then the administrator of elections will tell that individual they're ineligible.
And I know it was just a slip of the tongue because it's easy given how closely you work together, but you said we. Is it a member of your office, or is it the county election officials?
No, we have to create the portal. So the coordinator has to create the portal, but the administrator is the one that will be doing the work locally. And the way it's going to work is going to tie into, so it's tying into their voter registration system.
Hmm.
So the idea is that they don't have to double entry the same. So if you were to come and register to vote, they don't need to enter your name in twice. They'll enter it one time, and then it will not let them go further to register that person to vote. So it's all going to be done locally.
Okay, so the county election official does the querying goes then to other state department, it queries other state department databases, and the county election officials receive the result.
That's correct.
Your only role is setting up the platform.
That's correct.
Okay. I said it was gonna be my last one, just two very discrete questions. Have you ever in your time as a state election coordinator unilaterally decided that a statute that was passed by the General Assembly was unconstitutional and then refused to enforce it?
No.
In fact, I think you testified that you presume they are constitutional and you enforce them all. Is that right?
That's something that has been instilled into me from the Attorney General's office, right? If it's passed, it's just, unfortunately, my role, I get sued quite a bit, and that's just a common law phrase that is used.
Sure. If I could steer you to Exhibit 62 for my last kind of discrete question.
62.
It's the restoration of voting rights after felony conviction thing.
Yeah. So there's so much paper here. Can somebody, is there a way you can hand this to me?
I just
You
have
think
the
it's
one-
over here? That's 63.
Yeah,
Okay.
there.
Well, see, that says 211 on mine, so I obviously
Oh, that's the wrong
taken
one.
a place. Well,
It's that
probably,
one.
okay, here you go.
Sorry, Your Honors.
A lot of paper.
And the only reason I want to look at this again is there's this quirk of the statute that these singled out crimes that forever bar you from seeking restoration are date-based. And Mr. Habenreich went through some specific people with you, and we just, we saw the charge, and we just assumed that that meant that they were permanently disenfranchised. And I wanted to pull out a couple where that's just not true. If you flip with me to are the pages actually numbered? The Bates stamp at the bottom ends 588.
Okay.
And if you look at the fourth one down, I don't want to say his name, inmate ID 6723.
Got it.
his conviction date there is July 1st, 1994, is that right?
Yes.
And he was convicted of forgery of signature of court officer. Do you see that?
Yes.
And in fact, in 1994, which was well prior to the 2006 amendment, that was not a permanently disqualifying statute, was it?
Correct.
And so, in fact, not going to say his name, this specific ex-convict is not permanently barred from registering to vote, is he?
No.
Okay. If we can flip 2 more pages to the one that ends in 90. If you look at the second one down, 6738.
Got it.
That was another brought to the court's attention by Mr. Habenreich. And if we look at his conviction date, it's January 10th, 2000. Is that right?
Correct.
And in fact, he was convicted of making a false statement. Do you see that?
I do.
And in 2000, would that have been a permanently disqualifying conviction?
No.
Okay. Couple more down, 6733. This conviction date is May 7th of 04. Is that right?
Yes.
And again, Mr. Habenreich brought this to your attention. The conviction was for identity theft and forgery. Is that right?
Correct.
And in fact, in 2004, she would not have been permanently barred from seeking to have her right restored, would she?
Correct.
Okay. So, Your Honors, that concludes my cross-examination of this witness.
Okay.
And what comes next is direct. So, Mr. Goins, I'm sure you heard us discussing it, but there are rules that don't allow me to lead anymore, and so I'll be asking you more open-ended questions. The topic is going to be government interests in the underlying statute. And we know there's going to be an objection coming, so what I'd like you to do, if you could, is after I finish my question, if you'll just pause for a second so there's not an answer on the record before counsel has a chance to object. The first question I want to ask you is, in your role as head of the Division of Elections, the coordinator of elections, do you think it's appropriate for you, on behalf of the division, to opine as to legislative intent?
We will object, Your Honor, to this topic. As we previewed before, we believe on the basis of both estoppel and lack of personal knowledge that given defendants' verified answer to the interrogatory where we asked about government interest and defendants told us that they didn't have knowledge, combined with the deposition testimony, very specific on this topic, particularly with Mr. Goins, where I asked about government interest and Mr. Goins told me he didn't know, or he couldn't answer, or he had no position on that. For those reasons, we believe that defendants are both stopped from pursuing this line of questioning, but also that based on the previous statements, the verified interrogatory response and the deposition testimony, that this witness does not have personal knowledge. And so for that reason also, we don't believe this line of inquiry is appropriate.
All right, thank you, counsel. Mr. Hilo?
Yes, Your Honor. The short answer is, as it relates to the interrogatory, as we went out, I don't want to redo all of that, but the first and primary objection was procedural. It was there was a court order limiting what they could seek to discover, and we thought that this exceeded that court order. To remind the court, no motion to compel was ever filed, never ruled on by this court. As to the deposition, it's just not accurate. This witness, and I know you don't want me characterizing testimony, I don't know how to respond without doing a little bit of that. So, if I may. This witness in his deposition very clearly resisted answering questions on behalf of the division because he said he didn't think he should be doing that in that role. After being pressed numerous times, this witness then answered the question. He specifically stated, personally, I believe, and he actually told a personal story about a member of his family who was subject to a violent crime, and he said, I think that there are some people that shouldn't be allowed to vote because they committed certain felonies. Some crimes are so bad that we don't want these people participating in the election process. unequivocally, he stated that, and with his personal anecdote. And Your Honors, that almost mirrors the motion to dismiss standard that they've been trying to say that we can't use anymore, which is the one this court found, which is there are some people that are no longer fit to have their voice heard in elections because of whatever it is that they did that the legislature deems one of those things. And to his credit, as part of his personal belief, he even said, I'm not so sure about this one that the General Assembly said, but I think this other one that they didn't say should qualify also. And so in his deposition, once he was allowed the qualifier, my personal opinion, he answered the question.
Okay. In the deposition, did he,
Oh, and I'm sorry, he also mentioned personally election integrity. My fault.
okay, in the deposition?
Yes, Your Honor.
Okay.
And Your Honor, what I would point out is, when I first asked those questions of Mr. Goins in his testimony, my question was, this is on page 122 of his deposition, so you, Mr. Goins, sitting here today, what is your opinion of the government interest? And his answer was, any opinion I have would be personal. It wouldn't be within this capacity. He is a defendant in this case in his official capacity as the coordinator of elections. Whatever his personal opinions were, whether they came out of deposition or not, are not relevant at trial as a defendant in his official capacity. He told me straight out, there's plenty of other excerpts where he says similar things, but what his personal opinion as Mr. Goins, not coordinator, is not relevant to this case and is not probative of the state's burden to present a government interest. And given the fact that we didn't get an official position at any time, we don't think it's appropriate to bring that in now.
Do we have a copy of the declaration and the answers to interrogatories?
We do. I was going to move it in as an exhibit.
Okay, can we see that, please?
And have a chance to respond when you're ready. Thank you.
Would Your Honors prefer to see the
Yeah, if
interrogatory
you can-
response?
Yeah, our file is electronic, so yes, that would be helpful. Circuit Court does not have a hard copy. We've been electronic for over 10 years, so that would be helpful.
Oh,
I thought you said
I
you
think Your Honors, would you like the copy?
Yes, that would be helpful. Thank you.
Oh, you actually have that
very
in?
much.
Oh, then I do want one.
I just took the paper clip off. I apologize. 3 for the court.
Your Honors, I think if I remember correctly, and I'm flipping to it, it's interrogatory 22, the last
Okay.
one. Is that right? No, it's not. What number is it?
It's 20. Yeah, it is 22.
Page 12, 22. Yes, Your Honor, sorry. I actually did have it right.
And Your Honor, I was just gonna say, to the extent that it is relevant or you want to see it, we also have copies of his deposition, if that's helpful.
So I wanted to point out two things in response to what Mr. Habenreich said. Trying to not characterize what I'm going to ask next. I want to be careful. So, Your Honor, during the deposition, first, these interrogatories were served upon the division. Or they were served upon, I guess Mr. Goins in his official capacity. In his deposition, Mr. Goins did, Mr. Habenreich is correct, refuse to answer on behalf of the division. But what's important to realize is Mr. Goins wasn't the 30026 designee of the division. Ms. Henry Robertson was. Mr. Goins, as Mr. Habenreich stated in the deposition when he said, "That's fine, you're here in your personal capacity." When Mr. Goins said, "I don't want to answer on behalf of the division," his response was, "That's fine, you're here in your personal capacity." And that's when the personal anecdote and the personal opinion was told. And so this deposition was never intended to be the opinion of the division. It was always just Mr. Goins in his personal capacity. And he answered in his personal capacity. And I think the question you just heard me ask is, do you think it's appropriate for you to answer that question on behalf of the division? I wasn't asking about his personal opinion, and then I was going to flow into his own personal opinion.
Okay.
And Your Honor, again, I think that gets to the point. This was a discovery deposition. My first question is, what is the official stance of you as coordinator of elections? Because that's his role as a defendant here. So once I got the answer that I can't answer that, I have no official position as a coordinator, it was a discovery deposition, so I just went on and asked, okay, fine, you're here in your personal capacity. Let's find out what you, Mr. Goins, thinks.
I'm sorry, repeat that again.
So the first question I started with in the deposition was asking about his opinion of the government interest in his official capacity. And he told me, I have no opinion on that in my official capacity. I'm here, I have personal opinions. Understanding that that was a discovery deposition and not
I
testimony for
understand.
trial, I went ahead and asked about his personal opinions.
Okay, do we
But-
have a copy of the deposition, the testimony?
We do, Your
Please.
Honor.
All right, let's take a look at that.
And the only point I want to make with that is, Mr. Goins is here in his official capacity as coordinator of elections.
I understand.
And so getting into his personal opinions is just not relevant.
Okay, you said it was page 122 in his deposition?
Yes, Your Honor,
It spans several pages.
there's lots of questions. The one that I read to you was on 122, but then there's multiple other instances as well.
Yeah. What I read you is on 123. I think it's just the
123.
surrounding 3 pages, I think, would give you.
Okay, all right, we'll take a look at it.
And-
And very good, you have 5 copies, we appreciate that.
Nope, from here. There you go. No, that's not light. There you go. And, Your Honor, I don't know if it's the appropriate time to add this, but there was a 30026 deposition of the division, the Secretary of State, actually. And Ms. Henry Robertson was the designee, and she was also asked that question, and she didn't refuse to answer it. She answered it. And her answer was something to the effect of, there's been a lot of court cases. I have one come to the top of my head that have found these justifications. We agree with those. And
Okay.
she named one specifically, and I think that's on page 26 of her deposition.
Okay, counsel, what page do you want us to look at?
Page 22, Your Honor.
122.
I'm sorry, 122.
Okay, we'll start out at 122, line what?
122, excuse me.
It's actually 121. If you want to scroll, it's right here. Thank you. I think it's 121. That's where it starts.
Yeah. So I'm looking at the bottom of page 122, starting at line 23.
Okay, we have it on the screen. Can we blow it up a little bit?
Say the questions on the page previous. believe we're having a little trouble with the screen, but what we're looking at is at the bottom of 122, my question, starting with, so you, Mr. Goins, sitting here today, and then the answer that I read is on 123. And then there's some other excerpts we can look at as well. So if your honors would like to, do you want to look at the other excerpts as well?
I'm still reading.
Oh, I'm sorry.
I think Judge Cook is still reading and Judge Tidwell as well. Okay, what other pages and lines do you contend are relevant to this objection?
There is a lot. I would,
Okay.
I think, point. Well, let me first point you to page 129. I believe the question begins on line 16.
Okay.
So the question was, the reason I'm asking is because in these kinds of lawsuits, the voter ID suit that you participated in, this lawsuit, the one in federal court, part of a challenge in court is that the court has to weigh the government interest against the allegations. You understand that, right? So objection to form, and the answer was, that's up to the Attorney General, and that's not my role to go out there and say this is the government interest. That's not one of the responsibilities I have. And then the other excerpt I think is particularly relevant. It's on page 130. The question begins at the bottom of the page on line 24. My question was, and the reason I'm asking you this is because the Division of Elections is a defendant in this case. Witness said, mm-hmm. Continued, the Attorney General is a defendant in this case. This is our opportunity to ask somebody, anybody, what is the rationale? What's the government interest for these laws? And that's why I'm asking. And Mr. Goins' response was, I'll leave that to the police. I would say the only other, I would say particularly relevant excerpt, Your Honors, is on 128. 128, starting on line 6, wanted to try to make clear to Mr. Goins, there was some discussion in his answers about what the legislature thought. So my question was, starting at line 6, I'm trying to draw the distinction between legislative intent, which I'm saying is what you're talking about, versus government interest, which is the government needs to have a reason for the laws it's enforcing. There's objection to form. The answer was, once again, the legislature has, no, there's a difference here. They're basically the same, right? Legislative intent and government interest in a sense, meaning that the same authority to pass those is within the legislature. Once they pass it, it's not for me to figure out what the government interest was behind it. Oh, I'm sorry, and I meant meant to kept reading, that's right. If you keep going to the next paragraph of that same answer, starting at line 23, Mr. Goins says, and so that's not part of my equation. I haven't thought about it. And during this deposition, I'm not going to go through and think through those things because I haven't, number one, I don't even know what all those things are.
Okay. Does that complete your response, counsel? Mr. Harvin,
I'm
does
sorry.
that complete your,
Yes, Your Honor, I think those are the highly relevant ones. There are some others, but
okay, Mr. Hillo?
Yeah, two things in response.
Okay.
You noticed that all of their excerpts skipped from 123 to 129. It's because the back end of 123 to 128 is him explaining his personal feelings about the justification. I don't want to read you 6 pages. I'm assuming you read some of it at least. I'll say 2 things, though, that I think are important to this. One, there is no rule of evidence. There is no rule of civil procedure that said only parties can put on evidence at a trial. The Division of Elections doesn't need a position to have a witness who may have a position. In other words, to the extent he doesn't want to speak on behalf of the division, there's no rule that says we are limited to the division to establish an interest. Any number of people in trials come and testify as to ultimate issues all the time. It shouldn't matter where that testimony comes from. It's up to the court to determine the credibility of the testimony. And so we don't understand this idea that a witness, that our side, our party, should be limited to certain witnesses to establish certain things. All trials involve non-party witnesses, and they establish many important parts. Second, there is, underlying all of these objections is this idea of prejudice. That's what the rules are trying to get at, a fair proceeding. There is no question that in his deposition, the current witness that is sitting on the stand testified to the exact thing I'm about to ask him about. There can be no prejudice. He told them during the deposition, and I'm going to ask him the same questions. He's going to tell us. If the court decides that his testimony is not enough, that's for the court to decide. But there's no exclusionary rule that bars him from testifying as to these things. If he wants to make a relevance objection, it's certainly relevant. If he wants to make a capacity objection, I don't know what that is. And so this idea, again, no trial is limited to testimony of just the parties. All trials include third-party testifiers. And here, unlike in others, not a surprise witness. This exact witness sat for a deposition, answered the exact answers.
And Your Honor, I think the point here is that you cannot have a random person testify as to government interests. I understand this is the coordinator, but what Mr. Hellu is arguing is that anybody can come in and talk about government interest.
Is that what you're arguing, Mr. Hilo?
Your Honor, there is no rule of evidence that would exclude that. Yes, Your Honor.
I think the issue here is this is a issue of fundamental fairness. We asked for the official position because this is a constitutional case. We're not suing Mr. Goins personally. It's in his official capacity. So what we were seeking was, what is the state's position? What is the defendant's position on this issue? And the defendants told us, we have no position. We have no information. And then Mr. Goins personally offered some thoughts, but that is not relevant. Everything that happens in a deposition is not relevant. It does not come in as relevant at trial. And so just because he said it at a deposition does not make it admissible or relevant at trial because he was speaking in his personal capacity only, and he is a defendant in this case in his official capacity. Again, that's the distinction we're trying to make here. And if he had said during his deposition, this is the official position of the coordinator and the division, this is what the division thinks the government interest is, that would be a different thing. But with respect to Mr. Hellu, he mentioned Beth Henry Robertson as well. She was the designee. Her answer is largely the same. She didn't reference a case or any kind of government interests in her answer. We also got no answer on that. And so again, Setting that aside altogether, Mr. Goins has offered us no information, and it is improper for him to then come back without us having had a chance to develop that through discovery and offer that testimony at trial.
Well, the lawsuit is filed Pamela Moses versus Mark Goins, Trey Haggard, Jonathan Scametti in their official capacities. Of course, we know that Mr. Haggard and Mr. Scametti were dismissed, so that leaves Mr. Goins as the sole defendant. The lawsuit was filed in his official capacity. Now, in terms of his deposition, it was a discovery deposition. It was not an evidentiary deposition. But we do expect, we have certain expectations for discovery depositions that the parties are going to be able to discover what witnesses, especially parties, are going to say when they testify. Discovery is a very, very important aspect of a lawsuit and of our judicial process. When we think about these types of objections, and I think counsel hit on it, we look at the prejudice, because we know that sometimes the attorneys don't ask every question as precisely or accurately as they would like to. We know that sometimes witnesses don't testify as clearly as they would like. But when the court is considering, and we are the gatekeepers of what evidence comes in, we want to make sure that the evidence is relevant. We want to make sure that the evidence is reliable, right? Which is why we have all of our rules. And then we want to also make sure that the probative value of that evidence is not substantially outweighed by the prejudice, which is Rule 403. But prejudice is very important, and the question that we are considering is whether or not it would be unfairly, because testimony is often prejudicial to one side or another, but the real question is whether it is unfairly prejudicial. And respectfully, if Mr. Goins was, and again, in terms of the credibility of the deposition, Mr. Goins answered the questions as he deemed fit. And it appears that he was being very honest in that he did not have an opinion in the deposition with regard to governmental interests. Mr. Goins has been with the state for over 17 years from his testimony in this trial. He's also a licensed attorney, although he doesn't practice law, and he's very learned at his job. But in his deposition, he took the position, respectfully, that it was not within the scope of his duties to give an opinion regarding governmental interests. Now, he did have an opinion in terms of his personal interest, and that is discussed, and I did read that. So I read through pages 122, and I believe I stopped reading on, was it 132 or maybe 133? But I did read that testimony. And the question is, should Mr. Goins be allowed now to come into the trial and take a position that was counter to his deposition? If he didn't have an opinion in his deposition with regard to an official governmental interest, why should the court now, during the trial, allow him to testify to an official governmental interest? With regard to his personal interest, the court could allow him to testify to his personal interest, but would that really be relevant to the legal issues that we have to determine? What we are looking at in terms of the case law is what is the governmental interest. We can all have opinions, but of course we know that our opinions our personal opinions just are not relevant. So respectfully, while we appreciate that Mr. Goins has his personal opinions, what's really relevant to this case is whether or not the state of Tennessee, and there are many different divisions within the state. Again, the Attorney General is not here. There are no other government officials here, except for officials from the Division of Elections. So the question is, does the Division of Elections, or Mr. Goins in his official capacity, have a position or a thought about what the state's governmental interests are? And I do agree that you can call any witness to testify, so it would not be limited to Mr. Goins' testimony. But in terms of that witness's personal opinion, that would not be relevant, because the question has to do with a government interest. And what's relevant to our analysis is there an official position within the government of Tennessee regarding this statute, and why this statute is constitutional under the level of scrutiny that would apply to it. So that's how I'm thinking about it. You're free to respond, and
On
Yes.
all of these issues, defer to Your Honor, and we'll abide by whatever the ruling is. I'll say a couple of things that
Okay.
come to mind. The first, and I know we've already done the deposition thing, I do want to point out that on page 131, when Mr. Habenreich was pressing, and he said, the Attorney General is a defendant in this case, this is our opportunity to ask somebody, anybody, what is the rationale? What's the government interest for these laws? And that's why I'm asking.
yes,
His answer was, I'll leave that to the pleadings. The pleadings as they existed in this case on that day, the motion to dismiss had those two government interests. This court found those two government interests. And so he's incorporating those pleadings right here in his deposition. And he is directly answering, what is the government interest?
okay, well then, if that is how you're construing that statement, that's fine. That would be your argument during closing, that the interest that was set out by the court on the motion to dismiss, the two interests, and I've not gone back and looked at those interests, but assuming that what you're saying is correct, because I know that the plaintiffs took a little bit of issue to that yesterday, but assuming that we go back and that language is there, if that's the position that you're taking, that Mr. Goins is, that statement, he's saying, well, he's going to rely on what the pleadings say, and therefore he is, what's the word that I'm going to see? Make that determination.
The issue is so paramount to the case, what the government interest is, that I want to make sure the record's very clear on
Okay.
what we're saying here.
Yes.
In a deposition, in his official capacity, when pressed, he gave a substantive answer. If they chose not to go read those pleadings, I think what Your Honor is saying is that substantive answer isn't enough.
Well, no, counsel, no. Now you're becoming argumentative.
No, I don't mean to be. I'm just.
Well, not disrespectfully argumentative,
Yes,
but
ma'am.
you're challenging what I'm saying. And I can't be any clearer. We're not in the fact-finding stage at this point. This is the trial.
Yes, Your Honor.
So we understand the argument. We understand the argument. Now, whether we are going to agree with your argument that statement on page 131, and I'll go back to it, that Mr. Goins says, and this is page 131,
Yes, Your Honor.
line 7. It says, I'll leave that to the pleadings. It will be for the judges to decide what that means, and then how to interpret that in terms of our findings. We understand what your argument is, and I'm not dismissing your argument, But at this point, it's not for us to say whether or not we agree with your argument or don't agree with your argument. That's something that we will consider, but we understand the argument.
I think,
I promise you I do.
I know,
Okay.
I do. It's, I guess where I'm getting stuck
Okay,
is the nuance of that. This deposition is not a legal argument. This is a fact-finding deposition. And so his answers are facts that he's testifying to at his deposition. And in his answer, he says the stuff in the pleadings as his fact, as his testimony. He incorporates them. And so his factual answer to his government interest is to say, they've been stated, they're in the pleadings, that's my answer.
well, that's not what he says here, counsel. So it is up for,
Okay.
and I don't, we're saying the same thing.
I just don't think it's a
I just
legal
want to make sure
argument.
that you understand what, no, I understand what you're saying. You're making the argument that this is what was intended, that that's not what was said, but your interpretation is that's what was meant. We will then determine what was meant. That's our job as the fact finders. That's what we do in a bench trial. We
And-
determine the facts based on the evidence.
Understood. And
Okay.
so as he sits here today,
Yes.
is he entitled to testify to the very same thing? So that that fact is in the record of the trial?
So you want him to testify in his official capacity today that he'll leave it to the pleadings.
That either we can show him, he says, check the pleadings, we can show him the pleadings, he can read the pleadings. into
So
the
now
record.
he's gonna have to read the pleadings to testify. He doesn't know what the pleadings say.
If you don't want me to put the pleadings in
Well,
front of him, I will.
I'm just I'm just asking.
I think he does know what the pleadings say. We won't need to put them in front of him.
Okay. Any objection, counsel, to that?
Yes, Your Honor. Again, this is all after he says, I have no opinion, my official capacity.
Okay, but you understand what Mr. Hilo is now arguing.
Understood.
Okay.
I'm sorry, Your Honor. But this answer, I'll leave it to the pleadings, and I agree. I don't think that means what Mr. Hello says it means. We disagree with that. But in any case, that answer is a personal answer again. We already did the official capacity thing. That was my first question. So the rest of it, this is on 131. My question about is, what is the official position as to government interest? That was back on page 122. This is 10 pages later. So our position is this is the same as any other personal opinion. Anything he wants to say about the different crimes, that's his personal opinion. I'll leave it to the pleadings. Again, this is after I asked him 6 or 7 different times,
Okay.
trying to get an official capacity answer. This is just as irrelevant and inappropriate as trial testimony as any of the other.
Okay. Well, this is what I'm gonna do, and this is what I do generally in some of the trials that I have, so that we're all clear. We're gonna start at page 121. And if you wanna follow along, that's fine. If you wanna put it up on the screen, counsel. All right, so going back to page 121, line 9. Question. So you're familiar with the concept of governmental interest in those cases, inquiry into what the governmental interest is? Answer, yes. Question, okay. So I want to ask a little bit about that here. So, the way felony disenfranchisement works in Tennessee is that, and we've covered this with Beth, but upon a conviction of a felony, the court must render that convicted person infamous, and therefore their right to vote is taken away at that time as an initial matter, correct? Answer, yes. Question. And then there is also a set of permanently disqualifying felonies for which, if you're convicted of any of those, you are permanently unable to vote, right? Answer, correct. Question, I want to separate those two things out. The second part is a subset of the broader felony disenfranchisement. What is your understanding of the government's interest in that first category, just felony disenfranchisement? Mr. Wilson, objection to form. Mr. Harborwright, as to all felons. Answer. That's not. We look at the law. We enforce whatever they pass. That's a legislature. You're getting into what the legislators are thinking and doing. So I would defer to the legislature on that. Question. Sure. But as we've covered, you are in charge of authoritatively interpreting the election laws of the state of Tennessee, correct? Answer. Yeah, but that doesn't have, there's no interplay with governmental interest there. Governmental interest is why they pass it. Once they pass it, that's what I'm looking upon. Question. Sure. So you, Mr. Goins, sitting here today, what is your opinion of the governmental interests? Mr. Wilson, objection to form. Answer. Any opinion I have would be personal. It wouldn't be within this capacity. Mr. Harborwright. So that's, I'm sorry, Mr. Harborwright, question. Well, that's fine. You're here in your personal capacity today. So what is your opinion on the governmental interest involving a felony disenfranchisement? Object to form. Answer. You know, certainly for those that, and once again, this isn't, their governmental issues can be different, but I think those who are guilty of murder, sexual offenses against children, rape, certainly I could see a reason why, as a society, you would not want these individuals to participate in the process. Question. And you said you can see a reason why? What would be that reason? Objection to form by Mr. Wilson. Answer. Well, I'm just saying, as a private citizen, I think those are pretty violent crimes, or crimes you just don't, as a father, I think that they forfeit their right. And strike the and. I think that individual forfeits their rights. Question. And so I guess then I want to ask, you named some, I think you said particularly heinous crimes. Currently the law in Tennessee is that everyone convicted of a felony loses their right to vote at least for some time. Answer. Oh, I was talking about, I'll leave that up to the legislature. The government interest, that's up to legislature. Question. Understood. But I'm asking your opinion as to what's the government interest in depriving everyone convicted of a felony of the right to vote? Question. Objection to form, Mr. Wilson. Answer. I haven't put any thought into that. I haven't put any thought into it. Mr. Harborwright. Question. Okay. And then I think what you are talking about is permanently disqualifying felonies. Is that right? Answer. Correct. Question. So I think you named murder, sexual offenses against children. I think there was one or two other in there. Rape, treason is listed. Answer. I would include, so once again, I'm not the legislator, but you're asking, I would include voter fraud in there as well, because I think that, but they can get that expunged. Question. Okay. Answer, that is, none. I'm not an expert on expungement, but I do know they can get it expunged. There is legislation that passed within the last few years that actually said voter fraud could be expunged. Question, okay. Answer, but me personally, I would differ with the legislature. I would say that's a crime. You should never get your rights restored. Question, okay, I think that you use the phrase, you forfeit your rights if you commit one of these offenses. Answer, that's the statute, and that's what Justice Bivens, that's the wording he used, forfeit. Okay, question, okay. What about the permanently disqualifying offense in Title 39? Answer, yeah, I don't know what those are. I know what in general, but Title 39 specifically, I don't know what Title 39 says. Beth would know, but is that official misconduct? I assume that's those crimes. Question, they are a variety of crimes listed. Answer, yeah. Question, things like bribing a juror, an official misconduct, false reports, those kinds of things. Answer, yeah. Does that ring a bell? Answer, once again, that's kind of akin to, I guess, voter fraud. Question, okay, and you believe that that is appropriate for permanent disenfranchisement? Answer, yes. Objection to form by Mr. Wilson. Question, and why? How are? Answer, well, official misconduct, and don't know everything that's encompassed in those, but you're putting me on the spot here as a legislator, and so maybe I shouldn't be putting the two different roles on. But official misconduct, if you're elected to a specific position and you're in a public trust, then you're betraying that trust. That's a pretty serious thing. Then you're looking at society as a whole and how they're governed. How we're governed. Similar, I suppose, would you say falsifying a jury? I know, once again, that's falsifying something before the court. Certainly important to the type of government that we have to make it work correctly. Question, why would, for example, bribing a juror be appropriate for permanent disenfranchisement, but perjury, for example, not be? Objection to form, Mr. Wilson. Answer, I don't know, I don't even know if that's true. I don't know if that's actually true. But you're going to have to ask the legislature on this. I don't even know when that was added to the statute, unless that was in 2006. Is that 2006? Question, it was in 2006. Answer, you need to go back and ask Senator Cohen, Congressman Cohen, and Representative Larry Turner. He's deceased, but unfortunately, a lot of those legislators are deceased. They are, that was sad when I was looking at how many people have passed, but you'd have to ask them. Question, so, and I just want to make clear here in my questioning, there is a difference between, I think, what you're saying about, which is legislative intent, what was in the legislator's head when they were passing this versus government interests. I'm trying to draw that distinction. Do you understand the distinction here? Okay, is that the question? Yes. Okay, that last statement was the question. Question, and this is from Mr. Harberick. Let me just go back and read that again. And I just want to make clear here in my questioning, there is a difference between, I think, what you're talking about, which is legislative intent, and what is in the legislator's head when they are passing this versus government interest. I'm trying to draw that distinction. Do you understand that distinction here? Mr. Wilson, objection to form. Answer. So rephrase your question. Mr. Harborick, question. I'm trying to draw the distinction between legislative intent, which I'm saying is what you're talking about, versus government interest, which is the government's need to have a reason for the laws that it is enforcing. Objection to form. Answer. And once again, the legislature has, no, there's a difference here. They're basically the same, right? Legislative intent and government interests in a sense, meaning that the same authority to pass those is within the legislature. Once they pass it, it's not for me to figure out what the government interest was behind that. My interest is, if it says go out and pay your employee $5, it's not for me to figure out why the legislature said, or what the government interest is in paying that $5. It's to go out and pay that person $5. And so that's not part of my equation. I haven't thought about it. And during this deposition, I'm not going to go through and think through those things, because I haven't. Number one, I don't even know what all those are. You know, that's Beth. Beth would know each one that's, you know, a disqualifying felony. That's how, she, like I said, this is her expertise. So I don't feel comfortable even pontificating on what the government interest is, specifically when the legislature did it. I can think of many instances where, you know, I may be looking at something saying, why did the legislature pass it? But it's not up for me to decide. And it's not for me to go out there and figure out why they passed it. Question, and the reason I'm asking is because in these kinds of lawsuits, the voter ID suit that you participated in, this lawsuit, the one in federal court, part of a challenge in court is that the court has to weigh the government interest against the allegations. You understand that, right? Mr. Wilson, there may be a typo here, but it says form, perhaps maybe objection to form. Answer, that's up to the Attorney General, and that's not my role. To go out there and say, this is the government interest. That's not one of the responsibilities that I have. Question, I understand that. Answer, I have to execute it. Question, understood. But again, there are circumstances in which, depending on the claims at issue, the government, in defending a law, which is what's happening in this case, needs to articulate what its interest is and substantiate that interest. Do you understand? Mr. Wilson, object to form. Answer, I've answered your question. Mr. Harborick, question. Well, that was a procedural question about how the law works in these constitutional cases. Do you understand that? Answer, I also answered that question as well. Mr. Wilson, objection to form. Answer, that's not my role. That's the Attorney General's role. That's the General Assembly's role. That's not my role. Question. And the reason I'm asking this, the reason I'm asking you this is because the Division of Elections is a defendant in this case. Answer, Question, the Attorney General is a defendant in this case. This is your this is our opportunity to ask somebody, anybody, what is the rationale? What's the government interest for these laws? And that's why I'm asking. Mr. Wilson, objection to form. Answer, I'm leaving that to the pleadings. Mr. Harborough, well, I'll represent to you that we asked that in an interrogatory and we got objections and did not get an answer to that. So, do you believe it's appropriate to then supplement those and give us written responses to what the governmental interest is? Mr. Wilson, object to form. Answer, so procedurally, I don't know what you're asking. You know, I'm not practicing law currently. I'm an attorney, but I don't know I don't specifically know the procedure, what you're asking. Question, do you know what interrogatories are? Answer, I do know what interrogatories are. Question, do they need to be responded to? Answer, yes. I'm not a litigator, you know, specifically, you're asking about follow-up after all those things. Sounds like we objected, sounds like I feel like I've answered that question. Question, so my question is, I'm representing to you that we've asked, what is the governmental interest supporting felony disenfranchisement, permanent felony disenfranchisement in an interrogatory request? I'm representing that to you. I'm also representing that. Answer, okay, so I'll read what the response was if you want me to read that response. Question, it's just an objection. Answer, okay. Question, I don't have it printed out. I'm happy to show it to you if you'd like. Answer, I think that's up. So you have to sue someone. The legislature passes stuff. It wasn't there saying, legislature, this is your government interest. That wasn't me. I wasn't there. I have to have someone you have to have someone that you could sue, and unfortunately, you're looking at the guy you have to sue. I mean, like I say, I get sued. I think I've been sued over 30 some odd times when I was going through my security clearance. I don't even know if I knew about 8 of them. I think I was just mentioned. So, I'm gonna just read a little bit further because it does deal with the interest just a little bit further on page 133. And this is still Mr. Goins' answer. And so if you're asking if I could go back, and we're probably 40 now, maybe even more. I don't know the governmental interest when all those different things have passed. I mean, there's some of these lawsuits still, Shelby Chancery and school district, and I mean, I don't even know all the issues, but unfortunately, I have to be sued. And so that's, once again, the legislature, whatever the government interest that they stated or did not state, that's the government interest. Question. Okay, I want to ask a couple of more examples. So, again, normally we would take up these types of objections pre-trial. It's important that the judges read depositions in its context, not just excerpts, but when you see from the reading of the deposition, it's clear. Mr. Goins respectfully did not have a position or governmental interest. He did not feel that it was within his official capacity to have a position, that was not something that he was responsible for, that he's responsible for enforcing the laws as they are written, and that it was his opinion, it appears that that would be the preview of perhaps the legislators or the Attorney General, but certainly not him. So I don't know how it can be any clearer. The court is going to sustain the objection to the extent that Mr. Goins would be testifying to anything contrary to what's in his deposition. And in terms of the personal opinions, in terms of governmental interest, the court believes that those are not relevant to the issues, to the legal issues that we have to decide, and therefore that objection would be sustained as well.
So, Your Honor, I'm afraid I'm about to ask something that's going to upset the court, so if I could just address the court before I ask it.
Okay.
So the part of the transcript you just read, I'm trying to tread very carefully. If we start where you started, and the point I'm going to try and make is, Mr. Habenreich, very clearly at the beginning said, I want to discuss two categories. Category 1, general felon disenfranchisement. Category 2, the subset of people that can't seek reenfranchisement. It's not how he said it, but it's the two categories.
Okay.
Your Honor, the only question he ever asked was about Category 1. You can't find a single question about Category 2 here, and so we think that's fair game to ask him now.
Okay, let me just go back, counsel.
Your Honor, I did ask about permanent felony disenfranchisement.
You did ask, but let me go back to the page. Let me go back to the page. Page 132, line 4. So my question is, I'm representing to you that we asked, what is the governmental interest supporting felony disenfranchisement, permanent felony disenfranchisement in an interrogatory? I'm representing to you.
Mm-hmm. And again, he's discussing an interrogatory. He does not ask him in the deposition. They're discussing interrogatory. He never says, what's the government interest behind
Counsel, the
Category 2?
witness says he doesn't have any governmental interest. He doesn't know that.
He wasn't asked that specific question. I think you have to ask the question before you're going to tell a court that he can't now answer.
All right, so the questions don't, before that, they don't distinguish between, and let me just go back, because I did see some reference to felony disenfranchisement.
And I'll point you to 121 where the distinction is made. It starts with, I want to separate those two things out.
Did you say page 121?
121. And specifically is when he says, I want to talk about the first category.
And if it will help the court, Your Honor, on page 124, line 18, is where we talk about permanently disqualifying felonies. Again, on 125, line 17, I ask about what about permanently disqualifying offenses in Title 39.
Hang on, let's go
Counsel,
through.
we ruled on it. I'm sorry, we ruled on it. I'm not gonna go back and read those pages again. I do recall that, and again, I think that I read it carefully, so the objection is sustained.
Right, then I think proffer is how we've handled this up till now.
At the end of the testimony, that'll be fine.
No more questions from Mr. Goins.
Okay, thank you very much. Any redirect?
Just one moment, if you wouldn't mind, Your Honor, to confirm.
Okay.
No further questions, Your Honor.
All right, let's take a recess, and then we'll let you make that offer of proof. And officer, if you let us know when they've concluded the offer of proof? Okay, very good, thank you. All right, we'll stand in recess.
So the mic doesn't work, or does it work? Okay, it's working now.
Okay.
Thank you.
And let's just, oh wow, that's loud. I'll just ask you very broadly. Can you think of any possible, without knowing what the legislature was thinking, possible government interests that would support the passage of the laws that permanently ban some felons from seeking reenfranchisement?
And I'll just object to speculation for the record. Go ahead.
Yes.
And can you name some of those for us?
In my deposition, I was specifically given the example of Pamela Moses. And at one point, it was the person that was deposing me, the attorney, he shared with me what she'd been convicted of. And what I shared was that when you're dealing with the government, you want to have honest government. You can't have, my understanding is that she submitted what she was convicted of, according to the counsel, was that she was convicted of submitting a document to a judicial commission about a judge, and it was falsified. And so you got to have honest government. You would, in that instance, that touches at the very foundation of government, and that is someone, because they have done this, if you will, in the governmental process and hurt the foundation of government, that would not be able to participate going forward.
Okay, and so that speaks to specifically, Ms. Moses, can you think of a reason why we wouldn't want someone who's committed murder involved in the elective process?
Yeah, and once again, I was asked at some point, I discussed this in the deposition as well, and this is a little different point. And I shared a personal example of someone that was in the family, my grandfather, who unfortunately lost his life due to another's actions. And that person gets to live. That person gets to go forward. My grandfather never got to vote again because he was deceased because of the actions of another. And so in my mind, that scenario is a scenario where it's almost like retribution in a sense. My grandfather don't get to vote ever again because of the actions of another, and that other shouldn't get to vote either. And I would include other violent crimes in that same category.
Okay. Mr. Goins, in your deposition, you, at one point when asked about governmental interests, said you deferred to the pleadings. To the best of your recollection, what did you know to be the pleadings that you're deferring to? Any interest in those?
So I did read the pleadings, but my recollection may be needed to. I think it was along the line of honest government, election integrity. You want to have. There's certain things, certain individuals that commit crime that really hits at the foundation of election integrity. Voter fraud would be one, right? I mean, that's election integrity. Falsifying documents could get there as well. But essentially, you want to make sure you have. I think it's kind of akin to what I actually said in the deposition separately when it comes to having honest government and election integrity.
That's all I have for the witness.
Mr. Goins, so 2 quick questions about that. We have the answer Mr. Heller just asked you about, which was I'll defer to the pleadings, and then today you have elaborated upon that and mentioned election integrity and honest government. At the time of your deposition, you did mention election integrity, correct?
I mentioned the pleadings, and maybe I'm wrong on this. I mean, as I said here today, I'm still trying to struggle with being the person. Maybe I'm not seeing my role as defendant correctly. Maybe I am the state interest person, but it seems to me that we carry out what they pass. So my thought process is it's the attorneys to figure out and talk about what the government interest is, because I'll look at what I mean. I can come up with a ton of government interests, and if I had been there as a legislator, I could have given you some. This was, this was the reason I would have voted for it. We want to prevent people from going out and raping kids, whatever the case may be. But are these people are so bad that who wants to have people that rape kids, voting for DA, judges, those things. But in my mind, that's the proper way to do it, is to look at the pleadings.
And to follow up on that, so I want to draw this distinction. The testimony you're giving about murder and rape and those kinds of things, those are your personal opinions about what some possible government interests could be.
Yeah, you pushed me in the deposition to get to that point, because once again, I'm maybe being too legalistic, but I'm looking at Title II and what the code says.
Correct.
And essentially, the code says you got a job to carry out the law.
Correct. And exactly. And so I just wanted to make sure the answer was yes, these are your personal opinions, not in your official capacity, correct?
Yes.
Okay.
Well, no, I mean, the pleadings, no, I mean, as a government official, in my official capacity as coordinator of elections, I defer to the pleadings.
I understand, but when I asked you in your official capacity during your deposition, you said you did not have an official opinion on what the government interest was in your official capacity.
Well, I clarified it and said I defer to what's in the pleadings.
Respectfully, you said the piece about referring to the pleadings. You didn't say in my official capacity I refer to the pleadings, or I'll amend my prior answer about not having an official capacity. You didn't say any of that. This was a separate answer pages later, correct?
Objection, asked and answered, and argumentative.
Well, my intent today is that the pleadings give the government interest. Nothing's changed. That if I don't know how the questions were phrased, and I mean, I think I was consistent when it comes to government interest. The legislature, the attorney general, they're more into litigation, figuring out what to say in the courtroom, right? I'm about implementing it. I'm about carrying it on. And perhaps maybe I'm just going to have to go back and look at my duties somewhat as I guess also the quasi-defendant in these cases, but nothing has changed. I going into that deposition, sitting in that deposition, sitting here today, I still believe it's the role of the Attorney General who's arguing these cases on behalf of the legislature and the legislature to espouse those on behalf of the state. Now, I can come up with interest,
I understand.
but nothing has changed. I believe that firmly, that the pleadings.
I understand. So when you say I defer to the pleadings, what you meant was the lawyers, the attorney generals, they'll put forth whatever those interests are in the
Correct.
Objection, asked and answered, and argumentative.
No, I fully disagree. I'm trying to understand what he just testified. Again, I want to make clear here, I believe your answer to my question was correct. When you say I'll defer to the pleadings, what you meant was you defer to what the Attorney General, the lawyers, would put forth, would proffer in this case. That's what you're saying.
Objection, argumentative, and asked and answered. Again.
Then you continue to push me in the deposition. I ended up giving you some other interests.
Understood. I need you to answer my first question, which is, that's what you meant when you said that, correct?
I defer to the pleadings.
Yes.
Yes.
That's what you meant.
I meant
Okay,
that.
Thank you.
Objection, because I couldn't get in quickly enough. Asked and answered, and argumentative. I think that ends the proffer. Is everybody good with that?
Yep.
Okay. You're not excused until they tell you. Sorry, the formality is a thing.
wait for everyone to get in place. And did you
Yes.
complete the offer approved, council?
I think we did, yes, Your Honor.
Okay, wonderful. Okay, any other questions for Mr. Goins before he excuses?
Not a question, Your Honor.
Okay.
But we would like to move the interrogatory responses into evidence as the next number exhibit.
Okay, any objection?
No, no.
Since you handed those up here, I personally already have a copy of those.
I think,
So you don't have to hand those to.
Now, the deposition was not moved in,
correct, Your Honor.
no?
No.
Okay, all right, let's go ahead. Can I give, do you,
What number is that?
Actually, if we could, we'd like to move those in.
you wanna move the
Yeah,
deposition in?
for sure.
We would object to that. That's hearsay.
It's a party deposition.
It's an admission by a party opponent. They can't move it in as a,
Yeah,
As a
you
mission.
can't move it in
I
as
think
part
the
of-
way the rule is written is party depositions can be used for any reason at trial. Let me look up the rule, Your Honor, I'm sorry, but
That is true.
he's a party.
not as substantive evidence, Your Honor. It's still hearsay. We can bring it in as an admission by a party opponent, but the party themselves can't.
Well,
It's
let me
hearsay.
think about it. The court will sustain the objection because it wasn't, if there's an objection, it wasn't brought in during your case in chief, so now you wanna bring the whole deposition in as part of your case in chief?
So, Your Honor, we are admittedly both going out of order. The
Because-
interrogatories he just admitted were not in part of his examination of this
Well,
witness.
the reason why I asked counsel is because it came up during his case and he passed it up to it, but it wasn't marked, so I just wanted to make sure that I didn't make a mistake. But,
It would be, to be honest, its relevancy for us is it would be an exhibit to the proffer.
you wanna mark it for ID? As part of your proffer?
However, we handle exhibits for proffers, yes, Your Honor.
No, it's, if you made the proffer, so if you're asking to proffer it,
All right, if I could just have 1 second to understand the
Okay.
rule real quick, I want to be sure.
okay, that's fine.
Do you know what rule it is? Nope, you're good. All right, so Your Honors, if I could, and it's not a rule of evidence, that's why I was having trouble finding it, it's a rule of civil procedure. And it's 32.01, which is called the use of depositions.
Right.
And it states, at trial or upon hearing of a motion or an interlocutory proceeding, any part or all of a deposition so far as admissible under the Tennessee Rules of Evidence applied through witnesses when they were present or testified may be used against a party who is present or represented at the taking of the deposition or who had reasonable notice thereof. And then, subsection 1, any deposition may be used by any party for the purpose of contradicting or impeaching. Subsection 2. Oh, no, that's it. It's just in that first paragraph, 32.01. Sorry.
You can't enter it unless you're trying to, are you trying to contradict or impeach your own witness? I don't think that the rules call for what you're proposing. I'm sorry, I wasn't trying to step on your toes.
Oh, you're not stepping on my toes at all.
Okay, yes, Your Honors. If that's the ruling, that's the ruling.
Okay, we just wanna make sure, our goal is to make sure that we get it right, so. Okay, so let me pass the deposition back.
And did we,
We didn't yet.
I'm sorry, we're back on the interrogatories as the next exhibit.
Mr. Hilo said he didn't have an objection to it. Is that right, Mr. Hilo, or you have an objection?
Your Honor, he closed his questioning of this witness. It's too late to introduce exhibits.
Okay?
The witness is still on the stand, Your Honor. Again, I would have a chance to redirect if I need to, so my redirect, I'm happy to do it.
To be clear, when Your Honor asked if he had redirect, he said no. That's why we went to proffer.
That's true, that's true.
I mean, as an evidentiary matter, Your Honor, I actually don't have to authenticate or bring this in through a witness. It's an admission by a party opponent, so it's admissible for all purposes of trial.
Well, let me just tell y'all how I try cases, okay? Anytime, I don't think that I've ever had any trial, whether it's been a jury or a bench, where at the close of the witness's proof, if there was an exhibit or a document that was used that was inadvertently not admitted, the court admitted it.
Your Honor,
There's no prejudice.
We'll withdraw.
Now, if it was tomorrow or a week from now, obviously. But again, what would be the prejudice other than the technical that the proof was closed?
Your Honor, we'll withdraw the objection.
Okay. Because we know that the rule is the rule, you close your proof out, but again,
Your Honor, skating on the very thin ice that I appear to be on right now, I have a request.
no, you're not skating on very thin ice.
It's,
No.
and I
no.
apologize for even making it because it is a strange request. The council and I have spoken, and they have decided not to call Beth Henry Robertson in their case in chief.
Okay,
We do need her in our case in chief. We thought we were just going to cross her. She is Mr. Goins' ride to Nashville.
you want to call her out of order? Okay.
But we want to make sure we're not waiving our Rule 42 motion or any other procedural issues that relate to closing their case.
There would be
or
no
opening
waiver.
ours.
And we have no objection.
Okay, all right, Mr. Goins, you may step down, sir, thank you very much.
What's the exhibit number for the
Thank you so much. Okay.
67?
Thank you, okay.
Thank you.
No, you're fine, thank you.
And apologies again for this.
There's no need to apologize.
Yeah.
All right, you want to call your next witness?
I would,
Your first witness.
I would, out of order, like
Yes.
to call Miss Beth Henry Robertson of the Secretary of State's office.
Okay, Ms. Henry Robinson, is it Henry Robinson? Henry Robinson, yes. Okay, with a hyphen, yes, ma'am. Do you solemnly swear or affirm to tell the truth, the whole truth, nothing but the truth, so help you God? I do. Wonderful, please come have a seat. Okay, thanks for being patient all week. Oh, sure. Okay, all right.
I can hold it. Yeah.
Okay, you may proceed, counsel.
Thank you so much, Your Honor.
You're welcome.
Miss Henry Robertson, can you state your full name for the record?
Elizabeth Henry-Robertson.
And where do you currently work?
I work for the Division of Elections,
And how long have you worked there?
30 years.
It's a long time.
Yes.
Miss Henry Robertson, I'm just going to get straight to the point. Were you the 30.026 designee for the Secretary of State's office?
I was.
And the Division of Elections is contained within the Secretary of State's office?
That's correct.
Okay. Miss Henry Robertson, I only have one question for you. Can you fathom any government interest that would support the idea that people who have committed some felonies should not be able to seek re-enfranchisement?
I'm sorry,
Yes.
repeat the last part of that, because you kind of tapered off a little
I'm
bit.
sorry, Your Honor.
That's okay.
That people who commit some felonies should not be eligible for re-enfranchisement.
Yes.
Oh, I'm sorry, I would like to object, Your Honor. Apologies. On the same basis as before, when we've done the interrogatory response, during Ms. Henry Robertson's deposition as a representative of the state, I asked her about the department's position on the state's interest in felony disenfranchisement, and the answer was, from the division's perspective, we are enforcing the statutory language that's been adopted by the General Assembly to carry out the provisions of the Tennessee Constitution. And then so I asked, so the interest there is enforcing the law as it's written? And she says yes. I went on to ask about whether the department has a position on why certain felonies are permanently disqualifying as opposed to other felonies which are not. And the answer was that's a public policy decision of the General Assembly. And then I asked to be clear, the department doesn't have its own position on why certain felonies are permanently disqualifying and others are not. And the answer was not that I'm aware of. So
Okay,
again,
how does that go to government interest?
the first question was about the state's interest. I said state's interest.
State's interest,
in this
okay.
line of questioning. This is,
Okay,
And Your Honor, if he stopped reading at a very convenient point. If you continue reading on that very same page, if we go to the bottom of it, just so you know where we are, he asks, so if we look at topic area 10, and again, this is a 30026, and so there's a list of topics. It talks about the department's justifications for the state having an interest in felony disenfranchisement. I'm summarizing a bit. Do you see that? She responds, yes. So given your prior testimony, I think for topic area 10, there's nothing to point to that you would say other than the interest of the General Assembly. She said yes, and then she said, the case. There's a Johnson v. Bredesen case we mentioned. I was trying to remember it Tuesday, but that case, the court highlights a number of interests that the government would have. He asks, is that a Tennessee state case? She responds, it's federal. He asks, federal case, is it the Sixth Circuit? I think it is.
And all I would say, Your Honor, is, again, the first answer, several answers to my question was, I have no opinion, I have no position on that, I haven't thought about that. And then the bare reference to a case, a Sixth Circuit case, is not a substantive delineation of what those interests are. It's a reference to a reported case. So again, that's not a list or an official position on what the state's government interests are. She said yes. That was the substantive answer. Given your prior testimony, I think for topic 10, there's nothing to point to that you would say other than the intent of the General Assembly. And the answer to that question was yes. Then she went on to mention this case, and just for the court's understanding, I think this case has actually been cited. That was a case about a different provision of the law. It wasn't about permanent felony disenfranchisement. That is not a case that's relevant to this litigation. So again, our position is that's not an answer.
Is that case relevant to this what interest the government would have in this statute?
Yes, the government interest would apply here. Yes, Your Honor.
Same.
And I want to say, he says that she says yes, and then he said she later said that case. It's all in the same answer. There was no pause, no new question, and she explicitly says, but that case, the court highlights a number of interests the government would have.
Okay, and the only question I have is, in that case, do they deal with felony disenfranchisement?
That case is about the 2006 Public Act that we just walked through. It's
Okay.
about the payment of the child support provisions and the payment of victims' restitution, I think. I litigated the case in the district court. That's my best recollection.
And
Okay,
again,
but we're not talking about the child support provisions, and we're not talking about the fines. We're talking about the disenfranchising voters.
We are, and she doesn't
Okay.
say, she says that case highlights a number of government interests.
Right, but relevant to this statute.
No, relevant to topic area number 10. It was her answer to a direct
Okay.
question, topic area number 10.
Okay, the court will overrule the objection. The court will allow the witness to testify, and then we'll see where we go. We don't have a copy of the case, but overruled.
Thank you, Your Honor.
Mhm.
So I'll state the question again.
Thank you.
Sorry, because that was a bit of a time passage. Ms. Henry Robertson, as the designee for the Secretary of State's office, of which the Division of Elections is in, can you think of any interests that may justify a statute that allows certain felons to seek reenfranchisement, but does not allow other felons to seek reenfranchisement?
Yes, and I would point out in my previous deposition, I did point out that the General Assembly had an interest in keeping individuals who had committed certain felonies from being able to vote, register to vote. But certainly election integrity, election security are interests that the General Assembly would have in determining that certain particular felonies that they decide should not, individuals who committed those felonies and have been convicted of those felonies should not be able to vote again.
No further questions.
Okay. Cross-examination?
Ms. Henry Robertson, you said election integrity, I apologize.
Security.
Election security. Are those interests that are mentioned in the Bredesen case?
Not that I recall.
Okay.
There are other cases, and when I did that deposition, I was actually learning a lot because I was designated as that 3002 witness, but that had not been my area. So I was learning a lot, and I was reading a bunch of different cases. There are other cases as well, and I don't remember them off of the top of my head, that point out the government interest, because this statute has been, or this process has been litigated before, so.
Understood. Your Honors, given the fact that there are no other cases, respectfully, that were mentioned in the deposition testimony, and that the witness just testified that the interests that she identified were, to her knowledge, not within the one case that she cited, I think we would move to strike this testimony as not
Okay, did I
responsive.
understand her to say that they were mentioned in her deposition?
No, Your Honor, they're not mentioned in her deposition.
Okay, did I understand you to say that, Ms. Henry, that in your deposition you gave these interests as government interest,
Well,
election security, election integrity?
Your Honor, what I referred to in the deposition was, I said there are cases, and I was trying to remember the cases, and the one that I remembered was Bredesen, Johnson v. Bredesen. But I said there are cases, and I'm trying to remember those cases, and I just named that. But there are other cases that would cite those government interests that we would rely on.
Okay, so when the witness discovered these other interests, apparently she discovered them some way after her deposition.
Yes, Your Honor.
Did she supplement her answers to allege these governmental interests?
Your Honor, the duty to supplement arises for interrogatories, not for depositions, and the interrogatory was objected to on procedural grounds. It had nothing to do with, there was no duty to supplement
So,
and correctly objected to interrogatory.
so this is really the first time that she's testifying to these.
It appeared, I don't know anywhere else, unless someone shakes their head. I don't think so. This is it.
So Robert, what do you say about that?
I think Your Honor said it correctly. Goes back to the fundamental fairness point we talked about before, the estoppel point. Again, we had an opportunity to ask. Ms. Robertson, Henry Robertson said the case. There's Johnson v. Bredesen. And that was the scope. We just determined on her cross-examination that the government interests that she's identifying for the first time today, that were not mentioned in her deposition and are not mentioned in the one case that she pointed out, are new to this case. So again, as an issue of fundamental fairness and estoppel, we don't believe this testimony should be permitted. We do think it should be stricken.
Well, I asked Mr. Helo. Mr. Helo, you said that these interests were in that case that she cited, that we have not read, but you said these interests were in that case, election security, that those interests were in the case. So are they in the case that she referenced?
No, Your Honor, I think what I said was that there were shared government interests, and the ones in that case could apply just as well here.
Okay, but she didn't just testify to those shared government interests. She testified to two others. So
I didn't think Your Honor wanted me interrupting to tell her what she
Well,
should testify to.
no, but you can't. You're absolutely
Yeah.
right. So I appreciate that.
I'm sorry. That thin ice again.
I understand. So, there's an objection on the floor. What do you say to that?
In fact, there's not. There's a motion to strike that is no different than the
Well,
motion
an
to strike
object-
I made.
Motion to strike, I'm sorry.
And I remember how Your Honor handled my motion to strike, and it was asking the parties for briefing, and we would submit that, and I guess,
Well, I didn't know what your motion was going to be, but and your motion was after the conclusion of that witness.
Was
So we'll take it under advisement. We'll apply the same rule. We'll let you file a motion on that, give counsel notice, and then we'll take it up.
and Your Honor, this isn't me trying to be difficult. I think the problem is we have a witness who isn't a practicing attorney, who may not fully know everything included in that
She's been
lawsuit,
with
so.
But that's not an excuse, counsel.
No, I'm saying
That's
for
not- that's
I'm
not-
saying we're not trying to
She's
delay.
got very good lawyers, attorney general,
Yeah.
some of the best lawyers in the state. She's been with the election, division of elections 30 years. She had depositions, she had
Yes, Your Honor.
interrogatories, she was prepared for today, she sat through, so
Understood.
it is what it is.
Wholly
Okay.
agree.
It is what it is. Okay. Any other questions for the witness?
No, Your Honor.
All right. You're excused. Ms.
Thank you.
Henry, thank you. Henry Robertson. Yes, ma'am, thank you. Okay, so now are we going back to plaintiff's proof?
Yes, Your Honor.
Okay. All right, you all have a safe trip home. Please let Mr. Goins know that we wish him the best.
I will.
Okay. Drive safely.
Thank
Okay.
you, Barry.
And let me just say this, I'm gonna have the plaintiffs do the same thing, but this is a much easier question because it was simultaneous with, the court's ruling on allowing her to testimony based on those certain foundations. It's obvious to the court that those foundations were not laid, and it's really a much easier ruling in terms of timeliness, whereas Dr. Baumgartner had been tendered as a witness, he had fully completed all of his testimony, and a motion to strike, exclude, at that stage in the proceeding was, as I referred to it, unorthodox and highly unusual. So this motion is not highly unusual because the court overruled the objection because of certain foundations that were laid. And it turns out that those foundations that the court overruled were not accurate. But again, we're gonna allow the same rule, let them brief it, and then the judges will decide.
Yeah, we defer
Okay.
to the court. Thank you.
Okay, very good. You wanna call your next witness?
Yes, Your Honor. Plaintiff calls the plaintiff, Ms. Pamela Moses.
Ms. Pamela Moses. Ms. Moses, raise your right hand for me, please. Do you solemnly swear or affirm to tell the truth, the whole truth, nothing but the truth, so help you God? I do. Thank you. Please come have a seat. Make yourself comfortable there. Okay, you may proceed.
Good afternoon, Ms. Moses. Would you please say and spell your name for the court reporter?
Pamela Moses, P-A-M-E-L-A-M-O-S-E-S.
Ms. Moses, could you speak up just a little bit?
Yeah, P-A-M-E-L-A-M-O-S-E-S.
Thank you.
Thank you, Ms. Moses. So we're here today to talk about your challenge to permanent felony disenfranchisement. Before we get into some of my substantive questions, I want to hear a little bit about your background. So can you tell me a little bit about what you do and your background?
I am a mother, a musician, an archivist, a human rights advocate, and a person who loves her community and helping people.
And I believe, have you described yourself as a public servant before?
Yes, I'm not a politician. Even though I've sought public office, I consider myself to be a public servant.
And explain a little bit to me the distinction that you draw between being a public servant versus being a politician.
Well, people who are politicians usually have political motivations to do the things that they do. They're usually partisan driven and things like that. Myself, I do things for people because people need help and there are not enough public servants. So I try to help people because people have helped me, and I believe that that's my way of giving back to society.
And is that something that you think you could do in the future if you were able to run for public office?
Absolutely. I think I could, I think I have a lot to offer, especially in a city like Memphis, which is really different compared to other major cities in the state. You know, I've lived in Knoxville, Nashville. I was gonna go to school in Rutherford County, and Memphis needs help. And so I think that as a person who could help the community, it's important to have a voice. And so people that don't have a voice, they lack proper representation.
And is part of having that voice and participating in society include voting and having the right to vote?
Yes, it does, because the law requires.
That's a leading question, Your Honors.
Okay, so
we'll come back to the voting piece. I believe you had told me previous to trial that your family has at least some connection to civil rights history. Can you tell me about that?
Yes, my mother, she was a child plaintiff at the age of 15 in a United States Supreme Court case in which she wanted to learn Latin, and it was not offered at the black school. That was during the segregation period, and the ruling with Brown versus Board of Education had said that separate but equal was unconstitutional, or it was illegal. And so since she couldn't learn Latin and she wanted to, my grandparents, who were also active in their community, they hired Avon Williams, and they filed a lawsuit in Madison County, which ultimately went to the United States Supreme Court so she could learn Latin, and it desegregated the schools in Madison County. So I learned a lot from that happening and the things that happened after that, how important it is to be involved, because she not only got to learn Latin. As a result of that, I got to go to school with white people, because it was something that didn't happen right away, but over time it allowed the schools to be integrated.
Thank you for that, Ms. Moses. Let's turn to talk about some of the issues in this case. Do you have a conviction from 2015?
Yes, I do.
And what was that conviction for?
It was a large indictment of things that I think the main conviction, the felony conviction, was tampering with evidence, but we still haven't figured out to this day exactly how I tampered with evidence, but that's what the conviction was.
And did that case for the tampering with evidence conviction, did that go to a jury trial?
No, I was, I call it coerced, but I was under duress because I was being held on a $500,000 bond, and so I entered into a involuntary or voluntary guilty plea because my mother needed to have a medical procedure at the Cleveland Clinic, and she needed someone to take her to Cleveland, Ohio. And so by me being held in jail, there was no way for me to do that unless I got out, and so that's how I entered into this plea agreement. There was no trial. I was set for a motion to dismiss that day, and I ended up taking a plea so I could get out that night.
And so just to make sure I understand, to your knowledge, was a jury involved at all in that?
No.
Okay. How soon after you pled guilty were you released from incarceration?
Maybe a few hours. I had been in jail, though, for 5.5 months. They had arrested me a few days before Christmas, and I got released, I think, April 29th, probably before the third shift came on.
Do you have an independent recollection of speaking with the judge during that plea hearing?
A little bit. I mean, I don't remember verbatim. I know it was Judge Weber McCraw. He was, he had some of the same concerns that I had about the plea. He wanted to know exactly how I had tampered with evidence, and he had more dialogue with the state than he did me, but I don't remember verbatim, but I do remember talking to him that day.
We attached the transcript of that plea colloquy to the second amended complaint. Have you reviewed that at some point?
I think I have, but I don't remember much of it, you know. The whole experience was traumatic for me. I try not to think about it.
Your Honors, we have, I believe this was marked as Defendant's Exhibit 15. This is a copy of that transcript that we would offer into evidence. Sounds like there's no objection. Okay.
Dawn has this stuff.
Next to the stack. Could I have that one handed to the witness, please?
All right, this will be the next exhibit. Thank you.
Ms. Moses, I asked this, and feel free to look through the transcript if you'd like, now that it's in evidence. But my question is, based on the transcript or anything you remember, were you told during this plea hearing that you would be permanently disenfranchised?
No, I don't remember being told that, and I don't think I was.
Did anything about voting or suffrage or voting rights come up during that?
Your Honor, it's leading, sorry, objection leading.
Your Honor, that's not a leading question. I'm asking whether it came up or not.
It doesn't imply the answer. The answer could be yes, it could be no.
Understood, Your Honor.
Okay, overruled.
So, Ms. Moses, the question was, did anything about voting rights or suffrage or losing your voting rights come up during that hearing, to your knowledge?
No,
Did anyone mention the free and equal elections clause?
I don't believe so, no.
Did anyone mention Article 1, Section 5 of the Tennessee Constitution?
No, I
Sorry,
don't.
what was the question before that?
Did anyone mention the free and equal elections clause? And then the following question, did anyone mention Article 1, Section 5 of the Tennessee Constitution? And Ms. Moses, I'm sorry, did you answer that second one?
No,
Okay. Did you know as a result of this that you were going to be permanently disenfranchised?
no,
And we'll talk more about that in a second. And based on your recollection in the transcript, did you intend to waive your right to vote by pleading guilty that day?
no. I
Okay,
was just trying to get out.
understood. Let's actually rewind a year before 2015. In 2014, did you get a notice from the Shelby County Election Commission that you recall?
I may have.
And the reason I ask is because, do you recall having a core certificate of rights restoration filled out for you in 2014?
Objection, Your Honor. It's a combination of leading and assuming facts not in evidence.
Let's take the first objection. Leading, is it leading?
I'm asking if she recalls that happening or not.
Does it imply that it happened?
No, Ed, I'm asking if she remembers whether it happened or not.
Sustained as to leading.
Ms. Moses, do you recall did you get your rights restored in 2014?
Yeah, I think I had my rights restored from a previous conviction from over 20-something years ago.
Okay. And separately from that, did you register to vote in 2014?
I may have.
Okay. Let's talk a little bit about 2019. In 2019, did you attempt to register to vote?
Yes.
What happened there?
I believe in 2019, after I had experienced, in 2019, I had experienced like a really adverse situation here in Memphis, and I decided I wanted to run for mayor to at least bring light to what had happened to me. I thought this would be a good way to help people understand how broken the criminal justice system was. So when I went to run for mayor, I think I received some type of letter or documentation that I couldn't run because I wasn't registered to vote or something like that.
Okay. So let's look at what is been admitted as trial exhibit 65. I hope. And if we could find a copy for Ms. Moses. And this was previously marked before it was admitted, plaintiff's exhibit 181.
Just so you know, doing my best to not read it at all.
Oh, that's fine. No, that's fine.
Okay, thanks.
There it is. Thank you. Hand that to the book. And Ms. Moses, this exhibit, does that look like what you talked about that you got from the Shelby County Election Commission saying that you couldn't run for mayor?
Yeah, this is it. And the reason I know that this is it is because it's got my mayor email address on here, not my personal email address, and it also has my P.O. box and not my physical address. And usually when a person gets something from official agency, it comes to your, I guess, your home address. So this was when I tried to run for mayor, and I received this letter informing me that I was unable to run because I wasn't registered and I had been permanently, ineligible to vote.
If I may, just for a second, our team is having some difficulty. They messaged me. They were trying to reach you, but obviously you were questioning. So can you explain to her what you need to help with the feedback?
I fixed your mic so you can sit back a little bit.
Oh,
Is it okay now?
okay,
Okay, I'm sorry to interrupt, but I'm just trying to keep the feed going.
okay.
Absolutely, Your Honor. Thank you. Okay, so after you received this, what did you do?
I don't remember exactly what I did, but I probably contacted Miss Phillips because her name is on here. I contacted, several people, and she was telling me
Objection, Your Honor, hearsay.
Sustained is what Ms. Phillips said.
That's fine. You don't need to tell us what Ms. Phillips said. Just tell us what you did after you talked to her.
I made contact with the Shelby County Election Commission, and then I was referred to the State Election Commission. And I drove to Nashville, and I had a conversation with Coordinator Goins and Ms. Beth Robinson. We sat down and talked for a long time about the law and how this had came about. He had apologized, saying that it wasn't him, that the legislator had done this in 2006. He even told me Steve Cohen was behind it because he was a state legislator then. And we just talked about it, and I was like, well, you know, this couldn't be legal. And I think he even informed me I didn't have a citizenship anymore, and I thought it was like a joke or something.
So before receiving this and talking to Mr. Goins, did you know you were permanently disenfranchised?
That was the first time I received any, and I don't know that this is noticed, but that was the first time I had any knowledge of it.
Okay. I want to ask you a couple of other questions about being otherwise eligible to vote. So are you over the age of 21?
Yes.
18, I'm sorry.
Yes.
And are you a United States citizen?
I was born in Kingsport, Tennessee.
And are you a citizen and resident of the state of Tennessee?
I have been for over 40-some years.
Okay. Just have a couple more questions. So I believe hold on, let me think about this for just a second. One moment. Ms. Moses, since learning that you were permanently disenfranchised, have you become familiar with the statute and the list of crimes that are in that statute that are permanently disqualifying?
Yeah, I've learned a lot about this. I know our system is broken. I've learned that, and that people need to be more cognizant of what they put before the legislator, regardless of what political party they are, because it's not right.
Ms. Moses, given your understanding of the crimes and the statute, I want to ask you a few questions. Have you ever committed murder?
No.
Have you ever kidnapped anybody?
No.
Have you ever committed armed robbery?
No.
Or have you ever committed arson?
No.
But sitting here today, can you vote in the state of Tennessee?
According to the state of elections and the Shelby County Election Commission, I cannot. But I can run for federal office.
Well, that was going to be my next question. Can you run for public office in the state of Tennessee?
No, I can't even serve on the school board, and they need some help.
So this is my last question then, Ms. Moses. Why is it so important to you to get your right to vote back?
Well, it's important to me because, and just because of the timing of this trial beginning the day after Dr. King's birthday, you know, the city always wants to celebrate the dream that Dr. King had, and we should. But you had people like John Lewis and other civil rights pioneers and people that didn't even have names that are important. They died so I could have that right. They were spit on, they were intimidated, they were ridiculed, they had their property taken. People went through a lot for me and my people to have the right to vote. So I feel like as a person who knows my history, as bad as our history is in Tennessee, I feel like it is my American duty to utilize such a precious vote, because the vote is not just something for a person, it's something for a group of people who continue to this day to be disenfranchised. So while we celebrate the dream, some of us are living a nightmare.
Thank you, Ms. Moses. Those are all my questions for now.
Cross-examination?
Yes, Your Honor, thank you very much. Ms. Moses, we've met once over Zoom. My name is Will Halou, and I'm here representing Mark Goins.
How you doing, sir?
I'm doing well. How are you doing today?
I'm holding up.
Okay. I think we're all starting to feel that way. We understand. Ms. Moses, I want to, if I can, take you back to the year 2000. Is that the year you graduated the University of Tennessee?
Yes,
Okay.
yes.
And what was your major at the University of Tennessee?
I had a major in political science with a minor in African studies.
And if I remember from your deposition, and correct me if I'm wrong, you actually took a couple of law classes while you were there?
I took a constitutional law class from Dr. Otis Stevens. He was a blind constitutional law professor. I did take that, yes.
Okay. And in the year 2000, were you arrested on a felony charge?
Objection, Your Honor. We have a few objections to this line of testimony.
Didn't see that coming.
First objection is to relevance. If the court will permit me just a moment to say why. So the 2000 conviction that I think Mr. Hillary wants to ask about was for an offense that was a non-permanently disenfranchising offense. Even at the time, there was no permanent disenfranchisement. That didn't come around until 2006. And
Okay.
so,
Can you give me one word objection, so?
Relevance.
I know we-
Relevance,
okay,
I'm sorry.
Relevance, okay, so, okay.
So this conviction that the defense wants to talk about predated even the enactment of permanent felony disenfranchisement, which I believe the court and all the parties have conclusively argued this case is about permanent felony
Well, before you give
disenfranchisement.
your- I'm sorry, just give me the one word, let's see why he says it's not relevant, then I'll give you a chance to respond.
Yeah. And we do have other grounds for the objection,
Okay,
but I'm
well,
happy
no,
to do
no, you
relevance
go ahead.
first.
Tell me what the
Oh,
grounds are.
I'm sorry.
Relevance, okay.
So relevance is the first one.
Okay.
And given the fact that she also restored her right to vote in 2014, that kind of cuts it off. The other objections are there's a lack of foundation here. There's no evidence of why this could be relevant or is germane to the issues in the case. And then I think if we get to any documents, I'll have a different hearsay objection. The last one is that this is under Rule 403 more prejudicial, 404, more prejudicial than probative. To the extent that this is being used, a prior conviction, to talk about her character or credibility, given the relevance concerns, we don't think this is appropriate to get into.
Okay. Mr. Hilo?
Yes, Your Honor. So I'll respond quickly.
Relevance.
Yes, to relevance first.
Yes, sir.
Mr. Habenreich went through several questions about her restoration in 2014. That restoration would have been from this conviction, first. Second, the witness, I don't want to characterize testimony. May I characterize just a little bit of testimony to explain why it's relevant, Your Honor? And I'll do so lightly without commentary.
I'm sorry, you want to characterize the testimony?
Just a little bit of what she just said on direct to inform why it's relevant to the reader, to the cross.
Well, I don't know that that's necessary, but if you have to,
I think
okay.
the witness testified that she wasn't sure she was waiving, or didn't know she was waiving her right to vote when she pled the second time in 2014. Your Honor, that she was convicted in 2000 and sought to restore in 2014 makes that hard to believe. She knew that pleading and being convicted meant she had to have her right restored. Why else would she have done that? And so I need to get that in evidence to lay the foundation of how she had the
How is
knowledge.
that relevant to a permanent disenfranchisement and pleading guilty?
To the extent it was relevant on direct when he was.
No.
Okay.
I'm asking you in terms of, you said that this is relevant.
Yes, Your
So
Honor.
how is it relevant if that is the case? 2000 conviction, I'm sorry, did you say 2000? Yeah, 2000
2000.
conviction, and then restoration 2014.
Yes. Also, because as part of her 2000 conviction, there are documents that I think he referred to which explicitly mentioned that Ms. Moses signed a waiver of a jury trial and that she would lose the elective franchise by pleading. And without getting the conviction in, I can't get the documents in that show that.
And how is that relevant to her being permanently disenfranchised
It is relevant
in
that
terms of a guilty plea? And the constitutionality of the statute that's before us,
I'm
and whether or not that violates the Tennessee Constitution. Now's your time to
I know,
explain.
my
What the
co-counsel's
deal-
writing me a note, and I think I know what it's gonna say.
That's okay.
You're asking me to argue against a point I've been trying to make from the beginning of my involvement in this
Now-
case.
Exactly.
And so, to the extent her waiver of a jury trial by plea, and again, one of our big arguments on Article 1, Section 5 is, to the extent it says a conviction must be by jury, we say that a waiver, that can be waived, right? That's one of our arguments. And as to the extent there's an as-applied challenge, because you've already dismissed the facial challenge, her waiver is relevant to that issue.
Okay.
Ooh, that was pretty good.
I would, the only point I want to make is about the 2014. Another reason that the 2000 conviction isn't relevant, aside from the permanently disenfranchising piece, is because 2014 is when, as of that time, she was an eligible voter, had her rights restored, she had the right to vote as of 2014. That was foundation to talk about what happened in 2015 when she pled guilty and that right was, she was disenfranchised. So the 2014 is the starting point. She had a right to vote, she was a registered voter. 2015, she's disenfranchised, and then we move forward. Again, what happened in 2000 leading up is not relevant.
Okay, hold on 2 seconds.
Oh, and one thing I did mean to say, Your Honor, I intend to conduct this cross very quickly without ever trying to impugn her character or any prior bad acts or anything. That's not the purpose of any of this.
Okay. Can we take a recess for a moment?
All right.
we're missing a witness.
Okay, it appears that everyone is back from the recess. All right, the panel has had a chance to confer, and we are going to overrule the objection as it relates to relevance. We understand that this is a argument that the state has put forth with regard to the constitutionality of Article 1, Section 5, the particular statute that Ms. Moses pled guilty to, and whether or not she has waived a right to a jury trial. So we will overrule that objection as it relates to lack of foundation. That will be overruled as well. We think there's been a foundation laid in the case so far that there was this 2000 conviction. As it relates to 403 or any attempt to impugn the character of Ms. Moses, this evidence is not being offered for purposes of her character or any past bad acts that she may or may not have committed. And then in terms of the 403 objection, whether or not the probative value is substantially outweighed by the prejudicial effect, the court finds that it would not be prejudicial given the arguments that the state has made. Now, the court has not decided with regard to any merits of any arguments made, but we understand that that is an argument, and for those reasons, we will allow that testimony.
Thank you, Your Honor.
You may proceed.
Thank you, Your Honor. Sorry, I don't know why that came out so quietly the first time.
That's okay.
So, Ms. Moses, I'm going to try and pick up where we left off. Are you aware, do you remember being pleading guilty, to several crimes in 2000?
Could you repeat the question?
Yes. Do you remember pleading guilty to several crimes in the year 2000?
I remember being convicted of some domestic charges with my son's father in 2000. I think all of them was with him and his family. We had a toxic relationship.
Yes, and I want to do my best. We're not here to relitigate what happened. But what I would like to pass you is a document. It's a court document called Waiver of Trial by Jury and Request for Acceptance of Plea of Guilty. And I understand there's going to be an objection, so before I pass anybody anything, I guess I should allow it.
Mr. Harbinrick?
Yes, Your Honor. I think consistent with our prior objection, as I understand it, this document is being offered to demonstrate that Ms. Moses was instructed or knew back in 2000 that by being convicted or pleading guilty, she might lose her voting rights.
Well, remember, I'm asking you to just make
I'm sorry,
it
it's
long-
relevance.
Relevance,
I'm sorry.
okay. All right, so the burden is on Mr. Hilo because he wants the documented minutes, so if he'll explain to us why he believes it's relevant, and then we'll give you a chance to respond. How's that? Okay, go
Yes,
right
Your Honor.
ahead.
So
Okay.
this is the document that comes with pleas in Knox County in 2000, apparently. Looks like a form document with the clerk. It gets filed with the clerk.
Okay,
In it, and it's not just signed by the attorneys, it's signed by the defendant. So Ms. Moses' signature is on the document.
okay,
And in it, Ms. Moses is both specifically advised of her right to trial by jury and of several other constitutional rights. And then she is advised that by pleading guilty, she's waiving those. She is also specifically advised that by pleading guilty, she will be declared infamous and will forfeit her right to vote. And so, Your Honor, because of our waiver arguments and because waiver I think they've argued, at the very least, needs to be informed, that to the extent that is an issue, this proves that Ms. Moses had the requisite knowledge and knew exactly what guilty pleas meant, and that you were waiving that jury trial, and that they also meant you were losing your right to vote.
Okay, so when you say what guilty pleas meant, are you referring to her 2000 conviction, or that she knew what a guilty plea meant in 2015 when she pled guilty to a charge that would permanently disenfranchise her?
And so, Your Honors, I would say two things in response to that. And I guess it's going to go to weight to what Your Honors think of that evidence. But that she learned in 2000 that she could demand a jury, and that pleading guilty meant she was waiving that demand, it should be imputed that she still had that knowledge 10 years later, or even 14 years later when she sought to restore her right to vote. Also, that on that day, she learned that in the state of Tennessee, when you plead guilty, that you lose your right to vote. And, Your Honor, also in addition to her signature on this and her attorney's, is a statement that I've discussed these things with my attorney, right? That's in the document. And it is notice to her that she now has the knowledge that her elective franchise will be affected and that she's waiving a jury right when guilty pleas to felonies are made. And that knowledge doesn't just go away. Now, if she wants to testify she completely forgot, I guess that's another thing, and that goes to weight, and that's what you guys have to decide. But we want to show that she had the knowledge.
Well, we understand that, but in terms of and the court is inclined to let the document in, but in terms of the 2015 conviction, the right was restored in 14, and then there was a plea in 15.
Correct. Yes.
Okay. So
That all
you
sounds
just-
right.
Okay. All right. What do you say, counsel? Court's inclined to let it in.
Well, I want to correct a little bit about the actual language in the document here, because Mr.
Okay.
Hello is saying it informed her she was losing her right. The actual language is, the convictions may render me infamous, denying me access to the elective process, and making my sworn testimony, et cetera, et cetera. It is not a definitive statement. It does not say you are hereby losing your right to vote or anything like that. So
Okay.
I do think it's less clear.
Can we see the document? Mr. Hilo, I'm going to ask you to be a little bit more accurate with the court in terms of your representations. You know, we rely on what the attorneys say, and I'm just going to ask you to just be a little bit more accurate, because the last ruling with regard to Ms. Henry was based on some of your representations. So that's totally different if it says maybe. But again, I'm just going to ask you just to be a little bit more
Understood, Your Honor.
accurate. Okay, let's take a look at it.
And then the only other point I had on the relevance issue
Is that three? I think that's three.
was, Your Honor, as to the idea that something you were told in a plea document or a plea colloquy 15 years before another new charge in a different court in a different part of the state. Again, there's no case law, or there's no law that indicates, for example, if you read your Miranda rights for a conviction or an arrest in 2000, and you were rearrested in 2015, the fact that you read your Miranda rights back in 2000 has no bearing on whether or not you were properly advised in 2015.
And the court understands that, and again, that is one of the legal issues that we are going to have to decide. So when we allow when we overrule the objection on relevance, again, we're going to allow it in, but we have not, as a matter of law, decided how the state's argument with regard to that 2000 conviction, how that affects this case. So I would say the same thing as to this document. The court will overrule the objection and will allow it to be marked into evidence. So it will be number 69? 69, Your Honor. Okay, thank you.
Your Honor.
Hang on 2 seconds.
Yes, ma'am, sorry.
Okay. All right, you may proceed.
Ms. Moses, do you recognize this document?
No.
Well, you and I talked about it during your deposition, didn't we?
Yes, and
Okay.
I recognize it from the deposition, but I don't recognize the document like I've seen it before.
And do you know who Mr. Darrell Humphrey is?
Yes,
And he was your attorney at the time, is that right?
he was supposed to be.
What do you mean?
He was supposed to be my attorney.
Okay. If you'll turn with me to the second page. And I don't want to go through them, but does that list of offenses that's handwritten at the top, do you remember that to be the list that you had been charged with at the time?
I don't really remember.
Okay. I want to look at paragraph 5, and it opens, "It has been fully explained to me, and I understand that I may, if I so choose, plead not guilty to any offense charged against me, and that if I choose to plead not guilty, the Constitution guarantees, and this court will provide me, the right to a speedy and public trial by jury." Did I read that correctly?
That's what it says.
Okay. And I want to skip down to the first sentence of 6. "I understand that if I plead guilty to the offenses listed in paragraph 9, I am waiving my right to a trial to determine my guilt or innocence, and there will not be a further trial of any kind except as to the appropriate sentence." Did I read that right?
That's what it says.
Okay. If we can go to paragraph 8A.
Is that on the same page?
It is not. It's on page 3. Sorry. And I'm just going to read straight from it. "I understand that if the court accepts my plea of guilty and I am convicted of the offenses to which I am pleading guilty, these convictions will be public record, may render me infamous, denying me access to the elective process, and making my sworn testimony subject to attack." Did I read that correctly?
Yes.
Do you remember if you discussed any of these paragraphs with your attorney at the time?
No, I do not.
Okay. And I want to skip to paragraph 9, on page 4, sorry. And it's in all caps is where I'm reading. "Waiver of jury trial and entry of guilty plea, being aware of my constitutional rights and statutory rights, I hereby waive my right to a jury trial and those others listed above, and plead guilty to the offenses listed below. See that?
Yes, that's what it says.
All right, and then if we can flip to the very last page,
What page is that?
it's page 6, the very last one.
Mhm.
Is that, in fact, does that look like your signature right there where it says defendant?
It looks like it could be my signature, but it also looks like there's no date at the top on here. So, you know, I don't know, there's a date above it with right above my signature, and that's not my handwriting. But that does look like that could be my handwriting, but I'm not sure.
Okay. And in fact, at least the signature part, there is a date just above it. It says 16th of May, 2000. Is that right?
Yeah, that's not my handwriting.
Okay. I heard you say that, I heard you use the word coerced in relation to your 2015 plea. Do you remember saying that on direct?
Yes.
Did you actually challenge the voluntariness of your plea in a court of law?
I'm sorry, I don't understand your question.
Sure. Did you in fact go to court to say that your plea in 2015 was not voluntary, and in other words, that it was coerced?
I did try to give the plea back, but the judge, he wouldn't allow me to.
So that was your request to withdraw your plea was denied.
Yeah, I don't remember exactly why, but I do remember, like, once I had got free from the false imprisonment, that I tried to legally go about giving it back because it wasn't what I wanted to do.
And do you remember what you were charged with in 2015? Or what set of facts caused those charges?
Repeat the question.
Yeah. Do you remember what you were charged with in 2015?
It was a lot of charges. It was like a 10-count indictment. In one breath, I was accused of stalking Judge Phyllis Gardner. In the next breath, I was accused of impersonating an attorney. Then I was accused of harassing a county attorney. It was all, you know, just a bunch of mess that was fabricated. And I had no choice but to enter into the plea because the day that we went to court on the charge, if my memory serves me correct, my attorney, who was a young attorney, she had only been practicing 6 months, she had filed a motion to dismiss it. And the district attorney said if she moved forward with that motion, that they were going to put me in solitary confinement where I couldn't use the phone. I could either take the plea and go home and see about my son and my mother, or I could go to solitary confinement. So I took the first decision. That's why I mean by coerced. I don't mean like they put a gun to my head, but that was the circumstances, if my memory serves me correctly.
Okay. And do you remember what exactly you ended up pleading to of all of those charges?
No, it was never really clear. I just know that I had to do probation. I completed it successfully, and I paid my debt back to society for charges that I didn't even do. And I ran into my probation officer the other day at the airport. She gave me a hug, said it was good to see me.
Earlier, Exhibit 68 was entered into evidence, and we don't need to pull it out or look at it. But do you remember that there was a hearing in which a judge talked to you about this plea?
Judge McCraw,
Yes.
this plea?
No, the 2000. Talking about the 2015 plea now.
Oh, okay, we're not talking about this no more.
We're done talking about that.
Yeah, I think I testified to that earlier.
Yeah, and did he not explain everything you were charged with during that hearing?
He may have. I really was just, I just was feeling really bad, you know, and I just don't remember him, you know, saying anything about voting or anything that day. I just know it was just basically, you're going to be on probation. That's about it.
Okay. And you were actually, at that time for this plea, you were represented by 2 attorneys. Is that right?
No, I had one attorney. I think my dad had hired Ted Jones, but he never really. He wasn't active in the. He wasn't active in the sentence, and he didn't really do anything. He just was there. I think he was there, but he didn't say anything either about that. I was mainly dealing with Attorney Holland, the one that had been practicing 6 months.
It was Josie Holland, I think is the name.
Yes, that was her. Very nice young lady.
Okay, and do you remember if the judge asked you, are you represented by counsel, and are you satisfied with their representation?
I don't really remember, but I'm sure he probably did.
Did the judge, do you remember if he mentioned your right to a jury trial during that back and forth?
No, I don't remember, like specifically he may have, but I don't remember.
Okay. Your Honors, just to confirm, 68 is in evidence. It's been admitted.
Okay,
All right, then we don't need to walk through it. It says what it says. So that's all we have for Ms. Moses.
okay, thank you, counsel.
No further questions, Your Honor.
Okay, Ms. Moses, you may step down, thank you.
Thank you.
That is our proof, Your Honor, so the plaintiff rests.
All right, thank you, counsel. Plaintiff rests.
I'm sorry, I apologize. I am being reminded by my counsel, we were asked by the court reporter during the recess to make sure that all the exhibits were correctly marked. So may we take a short break and do that, I'm sorry, before we technically rest?
Well, we can do that when we wrap up, but I would hate to wait right now, but no, we'll come back to that,
Okay,
but that's fine.
Thank you, Your Honor.
Okay. Or if you want to you want to hand them the exhibits and they can check them? Okay. I'm sure one of the attorneys can check while we're moving forward. Okay, the plaintiff rests.
Your Honor, I've said the rule wrong every time I've said it. It's not Rule 42, it's Rule 41.
022?
Yes, Your Honor.
Okay.
So this being a bench trial, there's no such thing as a directed verdict. It's an involuntary dismissal pursuant to Rule 41.022. Your Honors, given timing and posture, I don't want to take too much time. Just want to, if I could, very quickly make the motion. Your Honors, we opened by saying that there were 2 injuries that gave rise to 5 claims. And I think the evidence has brought out that there are only 2 injuries here that are being complained of. One is Ms. Moses' inability to successfully petition the circuit court for reenfranchisement. And the second is Ms. Moses' original loss of her right to vote because it was by virtue of a plea and not a jury conviction. Again, the same 3 buckets that gave rise to 2 equal protection claims, 1 facial, 1 as applied. It gave rise to a substantive due process claim, 1 facial, 1 as applied. And it gave rise to the Article 1, Section 5 claim, which is only as applied as Your Honors dismiss the facial challenge, agreeing that it isn't universally unconstitutional because if there's a guilty plea, or if there's not a guilty plea, it's constitutional. So I want to start quickly with standing. The uncontroverted evidence is that Mr. Goins is at best an advisor to the various county election commissions. And in fact, the unrebutted testimony is they don't always take his advice. The other piece of unrebutted testimony is that Shelby County has their own attorney that they often consult for decisions that need to be made. Mr. Goins testified, and it's unrebutted, that statutorily he is not authorized to add someone to the voting rolls or to take someone off of the voting rolls. He is not authorized to accept an application for registration and approve it or disapprove it. He is not also, as it relates to felony restoration, there's 2 things he's not authorized to do that are both important to this case. He's not authorized to create the operative court order. Only a circuit court can do that. That court order is a prerequisite to any restoration. The second thing he is not authorized to do is after that court order is created, he is not authorized to then take the court order and register Ms. Moses. That is not within his power. His only role is to, unrebutted testimony, check to see if it's been altered or forged. He is to verify that it is, in fact, a copy. That's it. And so any order of this court, as it relates to him, the only binding order of this court as to him would be, you must verify that an as yet non-existent order is, in fact, accurate as to Ms. Moses. That would not be effective relief. That does not get Ms. Moses, it does not cure her inability to seek to be re-enfranchised. It does not cure her ability to vote. It has nothing to do with the Article 1, Section 5 claim, because the Article 1, Section 5 claim is based on plea versus jury, so it's inapplicable there. The point is, Mr. Goins, and there is no alternative testimony, was very clear. He can't either approve or get Ms. Moses the right to vote. He just can't. And I want to make sure to say again, that testimony is unrebutted. And all the statutes that were put on the screen, they use the word advise. He advises. He advises. And if this court were to order him to advise, he testified, no one testified to the opposite, that the Shelby County Election Commission may or may not listen to him. A circuit court may or may not listen to him. He doesn't even have the standing to walk into circuit court on a petition to have the rights restored. Only the Attorney General has that. And he gets no special standing with the Attorney General. He's just another person.
Does that apply to both the facial and as applied?
Yes, Your Honor. It doesn't matter whether it's facial or as applied. He has no power here.
Who do you say does have the power? Who is the correct defendant?
Your Honor, the easiest defendant to name would be the Shelby County Election Administrator, who is statutorily charged with registering voters and accepting the certificates accepting the court orders. The second person would be, I hesitate to say this because I hate saying state officials may get sued, but the clerk of the court for the circuit court in which she would petition, because it's the court that issues that.
But let me ask you this, that wouldn't your argument on a facial challenge, if the only person they sued was the Shelby County Election Commission, that all we can bind would be the Shelby County Election Commission and we couldn't bind the other 94 or 5 counties?
Your Honor, I would say first that, as I think it was Judge Corbin Johnson said at a hearing, this isn't a class action case. No one's asking you to bind all 95 counties. This is a single plaintiff.
Let me clarify that.
Yes.
While it's not a class action because we don't have multiple plaintiffs, the decision of this court will affect the statute that's being alleged to be unconstitutional because it violates Article 1, Section 5, that would have far-reaching results across the state in terms of whether or not one could be permanently disenfranchised on a guilty plea without a conviction of a jury. So I don't want my statements regarding class action. Class action has a specific definition, and we have one plaintiff.
Yes, Your Honor.
Okay, but in terms of the relief, if the statute is unconstitutional because it violates the Tennessee Constitution, then that would apply to to the government, to the state officials, as well as local county officials.
And let me say, Your Honor, in response, and I assume you want comment because there wasn't a question mark there.
No,
but I
don't necessarily need
Yeah.
comment, but I'm just clarifying.
Yes.
You know, what the court meant when the court said it's
Yeah.
not a class action.
And this has been the subject of a lot of federal litigation lately related to the federal government. Here is our position on the answer. The court,
Which answer?
on what an order would do that you're talking about and who it's binding upon and who it's precedential for and the practical effect of it. The court is jurisdictionally limited to the parties before it. That's just a fact of life. That's a basic Article I want to say 3 in the federal government. I'm trying to think of the Tennessee Constitution. It's a basic jurisdictional limit of the court. The court may only order things of the parties before it. Now, practically speaking, in any constitutional challenge, as applied, facial, whatever it is, as to a single plaintiff, there is unquestionably an effect that's wider ranging than that one plaintiff. I think that as the questions Mr. Habenreich asked of Mr. Moses, that as the advisor to all election commissions, that yes, it would be inadvisable to not make all election commissioners and election administrators aware of the ruling of this court, and it being the only interpretation to these things, it would have great precedential value, I assume, absent a stay. So, Your Honors, I think you have to balance the jurisdictional limitations of who you can bind. I don't think anyone would argue that Your Honors could issue an order that bound 95 county election commissioners that were not in the room for any given lawsuit. I think we all agree that that is true. Do we also all agree that 94 election commissioners would be risking a whole lot of liability not to listen to an order that bound one of them that had no contravening precedential effect? So yes, the short answer is you could only bind the Shelby County election commissioner if she were here and was a party to this lawsuit, but that practically speaking, the other 94 would probably listen close. And Your Honors, setting aside the jurisdictional limitations, there's a reason that courts need the right parties before them. As we've already said, the Shelby County Election Commission has its own private lawyers that they pay. As good as I think these lawyers are, and I think they are excellent, I can't tell you for sure what she would have argued in our place. That party hasn't been able to adjudicate its rights. And if this court orders it to do something, well, outside of exceeding the jurisdictional limitations of this court, it's just fundamentally unfair. It would just be like if a court ordered someone else to do something and they came to me and said, now go do it. Well, now wait a minute, I want my say in court before I have to do something a court told me. So, Your Honors, that would be my comment back to your concern, Judge Corbin Johnson.
All right, thank you.
Moving from standing, I want to start with equal protection, and I started, and I want to do this very quickly. In every equal protection claim, you must prove racial animus. Now, there is a small exception, but before I get to the exception, I want to start with racial animus. There was no testimony that the 2006 act was motivated by racial animus, and that is the act that deems the felony Ms. Moses committed one that is disqualifying to apply for reenfranchisement. In fact, the evidence on the act is it was sponsored by members of the Tennessee Black Caucus, that it fundamentally changed reenfranchisement by allowing a much simpler process for all felons, the certificate of restoration that didn't require a court order. So, Your Honors, the testimony proves one thing. It was motivated by the opposite of racial animus. It was motivated by the desire to allow felons to have their rights restored much simpler. And statistically, the one thing Dr. Baumgartner proved to this court is that in that population, felons in Tennessee who are disenfranchised, that blacks as a population rate are overrepresented. And so any statute that makes it easier for felons to regain their right to vote has a positive effect on that overrepresented category of people. Now, the one very small exception to racial animus requires you prove two things. That the effect on a population is stark and, not or, unexplainable on other grounds. Here, first, let's talk about what that's meant in other cases. In the crack cocaine cases, I'm sure we're all aware of, a circuit court, a federal circuit court, found that those cases affected black people in America 98.2%. 98.2% of those cases were against black people in America. That means for every 100, 98 and a little bit more were black. And in that case, they did not strike down the statute. And the reason they didn't strike it is they said it's explainable for other reasons. The passage of that statute is explainable for other reasons. Your Honor, here, we're not talking about something that applies to 98.2%. What we're talking about is a disenfranchisement statute that disenfranchises close to 323,000 people, of which about 200,000 are white, and about 113,000, 10,000, something like that, are black. In other words, it's not 98.2%, it's closer to 35%.
Yeah, but counsel, when you look at the percentage of representation in terms of white citizens in Tennessee versus African American, the difference was stark. I don't have the chart in front of me, but I want to say that African Americans represent 16%. So when you're using that 198, 119 number, that is not consistent with the facts. I mean, African Americans represent 16% of Tennesseans.
Yes, Your Honor.
But yet they are over 200, nearly almost 300% likely to be convicted of a felony and disenfranchised. And we know that some states, and again, we know that some states allow for automatic restoration once you're out of prison. We know that other states allow for automatic restoration after prison and completion of probation. We know that Tennessee is in the outlier of states that not only requires restoration, but certain hoops that individuals have to jump through to be restored. We've looked at the history of Tennessee, and the court is not going to give any opinions about the history, but I'm just having a hard time understanding your position when African Americans represent only 16% of the population. So while more white Tennesseans may be committing felonies and be disenfranchised, they represent 70%. So, I mean, we have to look at those numbers, that 323,000 within the context of our population in Tennessee.
Your Honor,
So I don't think that we can lose sight of that.
Your Honor, I understand. And if this case were about general felon disenfranchisement, I could see maybe an argument.
Well, but when you look at permanent disenfranchisement, the numbers were even more starker.
And
The numbers went up, according to the testimony. And again, we haven't heard from your experts yet, but the numbers went up to 3.2, which is more than 200%. And the population is still the same, 16% versus over 70%. So,
and if I may, what I would say is, and this is why framing is so important. Felons don't have a right to vote. General felon disenfranchisement was never an issue in this lawsuit, right? So we're talking about the application of this law is to 330,000 total people in Tennessee. That's it. That's the entire population the law affects. In no equal protection case that we could find, did the court ever adopt any population number other than the population the statute applies to. You can't randomly just say Tennessee's got 6.9 million people. This statute has no application to 6.6 million of them. It only applies to 300,000 of them. Only. And so the numbers and the rates we should be looking at aren't comparing total population. You start with who are the affected people, and let's look at disparities within the affected people. Dr. Baumgartner explicitly stated on the stand, I have no opinion as to re-enfranchisement scheme in Tennessee. He said it. I asked him twice. He said it twice in a row. I asked him, did you run numbers based on just the population the statute applies to? He unequivocally said no. I asked him why. He said, because they told me not to. They told me what to run, I ran it. That was his answer. And so, Your Honor, it's not our burden to show anything. It's their burden to show a disparate impact. And you know what they didn't do? They didn't show a disparate impact on the applicable population. They showed a disparate impact on a population that was never in the purview of the statute. This would be like using the entire federal population and then a state law in Tennessee that doesn't apply to the people in the other 49 states. That's not what we do. Yes, Your Honor.
Question. When you're saying the 300,000, it was like 330,000.
30.
But isn't that the population of felons and the number of the felons that cannot have their right to vote restored at all was 13,000?
It was 12 and change, I think, maybe 13.
Okay, so is
I
the
don't wanna
relevant
disagree.
population the 13,000 as opposed to the 330,000?
Yes, Your Honor. I would say that. I would say that, so the denominator, the applicable population. So a statewide law that applies to everyone in the state, the applicable population is the state. A re-enfranchisement law that applies to all felons, the applicable population that you compare is the 330,000 and then its racial breakdown, 330,000 and its racial breakdown. And then for this statute,
13.
what category is being burdened? 13,000 of them. And then you look at the racial makeup of that as compared to the racial makeup of the 333,000, and that's how you get the impact, disparate or not. He didn't do it. He says he didn't do it. And so there's no evidence in the record about the racial impact at all to the applicable population. There certainly is no evidence of stark. Because here's what we do know. We do know that as a whole, compared to the population of Tennessee, blacks are overrepresented in both categories. In one category, I think he said it was 2.6 times. In the other category, I think he said it was 3.1 times. And I want to be very cognizant of Judge Corbin Johnson's wanting me to be accurate with my language. I'm doing my best. I think that's what it was. And so that's what we know. And the one thing he would admit, the one thing I got him to admit, is that if you did reduce the population to the 330,000, that it would flip his testimony and that it would positively impact this overrepresented population.
Now, he disagreed with you that it would flip, and I'm not sure I understood how he rationalized that it would flip. What did I miss there?
I think what he did admit openly is that if blacks are overrepresented in the 330,000, that anything that helped the 330,000 get re-enfranchised would more positively affect the black population. They'd be overrepresented in the positive effects. He did not get to the permanently disenfranchised 13,000 population. But again, not our burden, theirs. And they put up an expert that admits openly he does not opine as to those numbers. Now, let's assume for a minute he did. This court would then have to find that this statute is unexplainable on any other grounds other than racial animus. Unexplainable. Felon disenfranchisement generally began at a time in Tennessee when only white people could vote. In other words, it was explainable for reasons that weren't racially motivated because it only applied to white people. You know, whatever the explanation is, it certainly couldn't have been racial animus because it only applied to white people. That's to general felon disenfranchisement. There is, as to the 1986 law, I think what got at, let's skip to 2006, there's no reason to do history. What got added was you had murder, rape, you had these fraud on the government type things is what I said. I think everything from tampering with evidence to voter fraud. And then you had treason. Your Honors, it stretches credibility to say that you can't justify having those people be excluded from deciding who makes our laws, deciding who enforces our laws, deciding who interprets our laws. This is a group of people that has a track record of violating those very laws. In the case of tampering with evidence or voter fraud, this is people who has a track record of undermining government processes. To say that excluding them from the elective franchise, again, we may disagree with the policy, but to say that it's unexplainable, of course it's explainable. We may disagree with the reasons, but we can explain them. And so, Your Honors, complete lack of racial animus proof, complete lack of statistical proof as to the relevant population, and an explainable statute. That is 3 independently dispositive reasons that they haven't carried their burden on equal protection. As to substantive due process, and this is both facial and, unless Your Honors have questions about equal protection. I know I'm talking kind of fast. Okay. As to substantive due process, and this is both facial and as applied, as I said at opening, to be entitled to due process, you must have a right. Court after court after court has stated that when a felon's rights are taken away, they do not have a right to vote. And the taking away is perfectly constitutional. Can't possibly violate substantive or procedural due process in relation to a right you don't have. You are not entitled to process for nothing. Now, if the government's burdening a right you do have, various levels of due process come into play. Everyone agrees, there is no dispute that Ms. Moses was convicted of a felony in 2015, that she lost her right to vote as a result of that felony. Every court in Tennessee agrees that taking that right away was perfectly constitutional. Today, she has no right to which process would apply. She has no right at all. If we get past the fact that she has no right to which process would be entitled, Your Honor, every court examining restoration has always used the rational basis standard unless there's a suspect class under the equal protection analysis. Well, in those cases, under the rational basis standard, courts have uniformly held that any government interest, referring to even ones found by a court that are common sense, defeats a substantive due process claim, because you can't shock the conscience to a right that isn't fundamental. Again, here there's no right at all, certainly not a fundamental one, if there's an explanatory reason for it. And Your Honors have already found those reasons here. You found it in your motion to dismiss, and your order on the motion to dismiss, I'm sorry, Your Honors. In that order, and it's commonsensical, even if you not found it in that order, even without testimony to it, common sense. Now, what is the standard rational basis for burden of proof on their side to prove that there is no possible rational justification for the statute? They haven't done that. They've submitted no proof on that. So, Your Honors, even if we get past those two things and we get all the way to does it shock the conscience? Well, of course not. It's constitutionally permitted. The Tennessee Constitution since 1834 says we're going to deprive felons of the right to vote. It says we're going to give the General Assembly, sorry, I want to be accurate in my words. We're going to give the General Assembly the right to deprive felons of the right to vote. It has said that for 200 years. That Tennessee enacted it can't possibly shock anyone's conscience. In Falls v. Goins, the Supreme Court explicitly stated felons do not have a right to a reenfranchisement process. It was unequivocally stated in that case. And so, Your Honors, I'd say simply, something we've envisioned for the 200-year history of Tennessee can't possibly shock our conscience today. Now, the other thing I'll add is, what was the actual testimony? The testimony was, it's detrimental. That was the word Dr. Birch used. Detrimental. Detrimental and shock the conscience, those are two super different things in my mind. In fact, I don't think you heard a single witness testify that it would shock the conscience. Neither Dr. Holloway nor Dr. Birch, which I think we're carrying the load for them on this, said that this should shock the conscience. And to speak to some of the numbers that Ms. Corbin-Johnson just used, even if we were just talking about general felon disenfranchisement, I think the breakdown was 48 states have felon disenfranchisement. I think the number was I think the number that had finish plus was a low double digit. I think it was 11, if I'm remembering correctly. It was 10. I was very close on that one, I'm sorry. 10 is 20% of this country. That's not conscious shocking to be a part of 20%. Our state agrees with 20% of the other states. That's not an outlier. That's right in there. So, Your Honor, we think there was no evidence on shocking the conscience, and we also, again, the threshold issue, no due process right. Good. I'm going to move on to the last claim, which is this jury versus plea claim. And, Your Honors, you heard no evidence about the original public meaning. You heard some from Dr. Holloway. I don't want to misstate that. You heard some from Dr. Holloway. Dr. Holloway's expert report, if you look at it, in the table of contents, when it discusses Article 1, Section 5, you know what the next word is? Confederate. Article 1, Section 5 was a response to the push to retroactively disenfranchise Confederate supporters for acts that were not disenfranchisable when they committed them. Their own expert says that. Even if their expert didn't, you know what ought to bind every Tennessee court? The Tennessee Supreme Court, which in Gaskin went through an exhaustive analysis of what led to Article 1, Section 5, and it focused on the loyalty oaths that the former Confederate supporters were being forced to sign. And I understand the desire of plaintiffs to pull these 3-4 words out and ignore the rest of the provision. Courts are to look at an entire provision when interpreting it. And this provision on its face bars retroactive, requires a court be involved, and it describes how a court is involved as a trial by jury. You have heard, and it's not appropriate for a Rule 41 motion because we understand it's disputed, you've heard evidence about how involved juries were or weren't. You'll hear more in our case in chief. But Article 1, Section 5 read as a whole has a very specific purpose. And, Your Honors, if you look at the 2006 statute, it adheres to that purpose. There's effective dates for when things become disenfranchising. And those effective dates track the effective date of the law. It's to avoid the retroactivity problem in Article 1, Section 5. That's what Mr. Goins testified. Now, the other thing Mr. Goins testified to, which I didn't include in my opening, and another example of Mr. Goins knowing things that I can't fathom, and we refer to it in one of our motions a lot less eloquently, and this is this idea that could anyone say that the intent of Article 1, Section 5, he used the Epsteins, one pled to child trafficking and rape, one was convicted of child trafficking and rape. Could we possibly adopt a strained reading of this constitutional provision that would allow one of those people to vote from jail? They wouldn't even be disenfranchised. From jail would allow one of those people to vote, but not the other. They've committed the exact same two crimes. Not only that, one straight up admits it. One's like, yes, I did that.
Yeah, but the thing about that is, and again, there are many different ways to look at this. But again, we know that Tennessee is the only state in the country that has this provision in its constitution, Article 1, Section 5. It's the only state that the framers, or the delegates, I should say, at the 1870 convention decided that they were going to include by jury. That's what they decided, long before we were here. And that why did the delegates include that? Could it have been that, and this goes to your hypothetical, if you have one person who is convicted of rape and they're sent to prison, and you have another person who is convicted of rape and they plead guilty, one by jury, one guilty. Both are very serious crimes.
Yes, Your
Okay. And both are subject to criminal penalties. But if the delegates wanted to guard against, and well, let me just preface this. In Tennessee, 98% of the convictions are by guilty plea. 1.2, according to Dr. Bumgardner, are by jury, a jury of your peers. 12 jurors who sit, they listen carefully, they understand the law, they evaluate the facts and credibility, they deliberate. And by far, the U.S. has the best legal system in the world. When we have juries, we always tell our juries that. And overwhelmingly, juries get it right. That's our legal system in this country depends on juries. Juries are a very important part of the fact-finding process and our judicial process.
Yes, Your Honor.
So there is a difference between a guilty plea and a jury verdict. And when you consider Ms. Moses's case, and the court is not making a finding as to facts because on a Rule 41.02 motion, the court is not to weigh the facts.
Yes, Your Honor.
But in terms of your example, how would the state administer an election situation where you have one who's been convicted? Well, the Constitution says you cannot deny the right of suffrage absent a jury conviction. So for the individual who pled guilty, they would have the right to vote. And I know that there is at least one state in the country where convicted felons don't lose their right to vote.
Sure.
They can vote from prison. It just depends on the public policy of the state,
Yes, Your Honor.
right? And our state officials and how they administer those procedures. But in Mrs. Moses's case, Ms. Moses testified that she pled guilty, and we're not gonna go back and look behind her guilty plea. I mean, there was an appeal process for that.
Sure.
But you elicited the testimony, and she said that she pled guilty because she wanted to get out of jail. Her mother was ill, needed to have surgery. She had been incarcerated on a $500,000 bond. 5.5 months. Looking at the possibility of maybe doing solitary confinement. Being represented by an attorney who, 6 months experience. So when Ms. Moses, as any defendant, evaluates their options, very often they plead guilty. 98% of our convictions in Tennessee are individuals who have pled guilty to felonies. Do you see the difference? So it's not to say that whether or not they're guilty or not, they pled guilty, they've been convicted, they've accepted responsibility. But there is a distinction in terms of whether or not to disenfranchise those individuals who have pled guilty from a fundamental right, an important right. The right to vote is no less important than any of our other constitutional rights.
Understood.
Whether it be a right to own arms or firearms, the freedom of speech, the freedom to assembly, they're all important rights. They're fundamental rights. And our Constitution addresses that. So perhaps there was a thought process in Tennessee that for those individuals who plead guilty, perhaps they should have the right to vote. Now, if they are before a jury and a jury finds unanimously that they have committed that offense, then they become infamous and they are not able to vote. So there is a way to administer, in this court's mind, this court sees a distinction. Now, in terms of what the delegates meant, that's an issue for another day, but when you say there's no difference between one who has been convicted by a jury versus one who has pled guilty, in terms of how that would be administered, this, as Mr. Goins said, the state is responsible for figuring it out once we have those laws. And again, our fundamental question with regard to your last argument with regard to not the equal protection and the due process, but with regard to the constitutionality of depriving one of their right to vote absent a jury conviction, that's something that we are going to, that is the $1 million question here. Why did Tennessee? All right, now we could talk about the waiver, but that's just one argument, right? My question to you is, absent the waiver, we understand the waiver and you can address that, but absent the waiver, what other arguments does the state have that the Constitution, Article 1, Section 5, says no individual, and I'm just paraphrasing here, no right to suffrage should be denied absent conviction of a jury? That's Article 5, so that's way up there in the, when they were thinking about the Constitution. It's number 5.
Article 1, Section 5.
It's important. So, absent the waiver argument, what other arguments does the state have that these statutes that permanently disenfranchise people who were not convicted by a jury is constitutional?
Yes, Your Honor.
Apart from the waiver.
Apart from the waiver, and
Yes, sir.
I'll address the waiver very last. Your Honor, I was going to do this at the end, but I'll go ahead and do it right now. I'd like to incorporate the arguments in the unruled upon motion and then address what you asked.
I'm sorry, what'd you say?
I'd like to incorporate the arguments contained in the motions that have yet to be ruled on, or summary judgment motions, into this. I'm not saying that.
Is that in the, because you were on the third phase, so I just want to make sure we're still talking
As
about
to as to all of them. In other words, as to this motion generally, I'd like to incorporate our summary judgment arguments.
Are you going to re-argue them, or are you just
No,
going to rely
I'd
on
just like
them?
to rely on them.
Okay.
I'm trying to, just to save time, I want to make sure that they're
Okay.
considered part of the motion.
Okay.
Now, to address squarely what Your Honor asked.
Yes.
I think there's, if I'm counting in my head right, 3 responses. The first response is this idea that the statute must be read as a whole, and its purpose, its general public meaning, I think, is the technical terminology used by courts.
You mean the Constitution must be read as a whole?
No, well, yes, but any provision of it as well.
Of the Constitution?
Yes. And so Article 1, Section 5 must be read as a whole, not, you can't parse phrases.
Oh, yeah, absolutely. Yeah.
Okay. And so, and again, I've been trained, we're not to say their intent when they passed it, or to say the original public meaning. How the drafters understood it, what they understood it to mean. We would say that the drafters understood it to mean that it was a conviction of an infamous crime, because at that time, and this is disputed, which is what makes it tough on a Rule 41 motion, but at that time, what you're going to hear our experts say is with very few.
Well, now you can't.
Oh, sorry, I'm not using it for the
Okay,
motion.
you
Sorry.
can't bring
Yep.
in what
Forget
your
our
purpose
expert.
would be. Right. You have to rely on.
Dr. Holloway's testimony, along with some of the newspaper articles that she put up on the screen that she was cross-examined about by Ms. Jordan, specifically mentioned guilty pleas as to the guilt to the crime of the individual, and then jury empanelment for the sentencing. In other words, back then, it was understood that a jury would be involved even in a plea. And the most salient statement that Dr. Holloway made is the Supreme Court case of Nolan v. State. It's actually, they entered it as an exhibit. In Nolan v. State, the individual there, who, if I remember correctly, his lawyer was one of the delegates to the 1870 Constitution, and I don't want to misspeak, so you guys correct me. Mr. Nolan pled guilty.
Right, and his lawyer was a delegate to the convention.
And a jury was impaneled for his sentencing.
Sentencing,
Yes.
but not for conviction. Now, if his attorney was a delegate and he represented Mr. Nolan and he knew the process, because the process is set out in the order. There was a guilty plea, there was an impaneling of the jury, there was a trial, and the jury imposed the sentence. Why would Mr., I believe his name was Thompson, was it Thompson?
No,
Why,
oh yeah, Thompson.
I'm not sure.
No, you're right. I think you're right, Your Honor.
Okay, I have a pretty good memory. But why would Mr. Thompson not use language that was clearer? It says conviction by jury. The law at that time appears to have been, because again, from what we've seen thus far, that juries were used for sentencing,
So, Your Honor,
not guilty pleas. So again, and I appreciate the argument.
I don't want to misspeak, and I want
Yeah.
Zach to look at me and shake his head violently if I'm
Okay.
wrong about this. But there is law in Tennessee about the definition of conviction, and I think it is complete upon sentencing. I think there's a guilt phase and a sentencing phase, and it's not all over until it's all over. And that's how they would have understood it.
Conviction by jury.
Yeah, that's how they would have understood it back then. In other words, you can plead, it's not done yet, you're then sentenced. It's how, we still do that in criminal court here. And the conviction order, when you're actually convicted, includes your sentence. In other words, it's inclusive of all of that. And so conviction would include the sentencing part, which juries were impaneled for in 1870. And the Nolan case shows that juries were impaneled for that part. And so, Your Honor, that would be our response. And no one's shaking their head furiously yet, which makes me think I'm okay.
Okay.
I think we do address that squarely in our papers, and so there shouldn't be
Okay.
any question.
Which papers are those?
It's either in our motion or reply for our motion for summary judgment.
Okay, all right, well, we'll take a look at that.
Yeah.
All
And
right,
so-
anything else?
Yeah, the second argument as to that is that they were, if you look at the different language used in Article 1, Section 5, and then I think it's Article 4, Section, help me out, 2, sorry, for general felon disenfranchisement, the authorization.
Right.
Yeah. The difference is denied, is the language used in Article 1, Section 5. It's denied in Article 1, Section 5, and then excluded in Article 4, Section 2. And I think.
What does that say? Repeat that again for us, please.
Sure. In Article
Okay.
1, Section 5, the language is shall never be denied to any person entitled thereto. In Article 4, Section 2, it's shall be able to exclude. They use the word excluded.
May exclude, shall exclude.
May exclude, yeah.
Right.
May, not shall. It's
May.
permissive to the General Assembly, may. Your Honor, we, in our papers, we gave the court the dictionary definitions of those two words back in 1870. And strangely, they're different. And my understanding of the difference, and this is from memory again, is that back then, when you excluded someone, it was affirmatively taking something away, right? It was to remove it from them. The denied, help me out. Yeah, it was to deny admission to something. In other words, one's about taking away, one's about not letting you have it. Right? That's common sense difference. Here, that difference is important because felon disenfranchisement laws affirmatively strip the right. They take it away. Reenfranchisement law that we're talking about here is just about someone who's had it taken away and not being able to get it back. You're being excluded from it. And so what Article 1, Section 5 is saying only applies to that one exclusion situation. And I think that's our argument. I think I butchered it a little bit. We'll add our papers for it. I'm sorry, Your Honors. Now I'm going to jump to waiver. As to waiver, I would mention, as Judge Corbin Johnson said, you know, the stuff at the beginning is the important stuff. The jury trial stuff is at the beginning too, right? It's an Article 1 right. So are a lot of other rights, things like fines not over $50 without being set by the court, things like confronting witnesses at a trial.
Yes.
Those are all the important ones in Article 1. They're right there. Courts have found those waivable time and time again. We know they can be waived, even the important ones. Here, the jury requirement, to the extent there is one, of Article 1, Section 5, is no less waivable. It can be forfeited, just like your right to trial by jury. And there is no question that there was a plea here, and that by definition, pleas waive the right to trial by jury. That's the fundamental thing that they do. I'm not sure what else they do once you strip that out. No one would plead. I mean, that's what you're giving up. You're giving up the right to trial by jury. We know that's waivable. And so, Your Honor, to say it's waivable in relation to one section of Article 1, as every court has done, and then say, but in this other spot, we're going to say it's not. There's no legal justification for that. The right to trial by jury and its consequences are either waivable or they're not.
Well, in any other state constitution where they use the word conviction, that would be a much easier, analysis. Conviction is a conviction is a conviction, and it implicates the Constitution.
Your
And
Honor,
we know that you can waive your right to a jury, and many people do across the whole country. But why is Tennessee unique? What is unique about Tennessee? I mean, we could certainly look at what other states did in terms of how they held their criminal cases back then. Was there a two-part phase? Did a jury have to review the sentencing or oppose the sentencing? But why is Tennessee different from all of the other states? Why did they include this language?
so in Your Honor,
Because it would have been so much easier just to say conviction, even if the jury was involved, right? It would have been so much easier and cleaner to just say conviction, like every other state has said conviction.
Your Honor, and without conceding anything, Your Honor has identified something that is different about the Tennessee Constitution than the other 49. Now, what I would say is that I'm not sure how relevant that is. We don't know that the framers did a survey and then said, we're explicitly rejecting this way and choosing this way. There's been no evidence of that. To be honest, after doing way too much research on the issue, I found no evidence of that, even outside of what's been presented at trial. And so, while it's an interesting historical point that Dr. Holloway testified to, I'm not sure that it's relevant at all. Unless the framers knew that every other state didn't have it, shouldn't matter. And we have no evidence that they did know every other state didn't have it. And so my response is, goes back to what I said earlier. According to their understanding, every conviction involved a jury. That's why it didn't. I mean, it's not superfluous language, it's their understanding of what it is. Now, but I think, Your Honor, that's separate from waiver, right? Even if we're different, let's say they had done the survey and they knew, they were like, listen, we got this one. We're going to make sure that before you lose your right to vote, you're convicted by a jury, right? Section 6, the very next section of Article 1. That the right of trial by jury shall remain inviolate. It's the very next section. They put them next to each other. Court after court after court says, you can waive that one. There's no disagreement by any party here. You can waive that one. Why couldn't you waive the one in the section right before it? you can waive that one, what's the legal
Perhaps
justification?
because it deals with a right to vote. And if the delegates believed that the right to vote was an important right,
The-
and that they wanted individuals in Tennessee to be able to vote, when they pled guilty, right? Just whether or not they were guilty or not, but they pled guilty, so they have a conviction, right? And we know that people plead guilty all the time that are not necessarily guilty. But because perhaps it was such an important right that they included that with the right to vote.
And Your Honor, my response would be simple. They probably did think it was important. The word
appreciate that.
inviolate makes
appreciate
important
that.
look like a little thing. Inviolate. I mean, important's one thing. Inviolate?
Well,
That's a you can't touch thing.
it's interesting that they didn't put that in the section Article 1.5, right? If they had put it in Article 1.5, then arguably, but no one's disputing the right to waive a jury. That's
Yeah, and
part of our jurisprudence.
Your Honor, we can thank Mr. Barker. I think we've got it surrounded. I think you know what our argument is.
We do, and we appreciate it.
Yeah, and I don't want to belabor. I try my best not to get in back and forth with judges.
Well,
I hope I've addressed what
I'm-
you said
I'm-
as best I
I'm
can.
sorry that you perceive it as going back
Oh,
and
no.
forth. I don't perceive it as
Okay.
going back and forth. I just perceive it as having questions
Yeah.
that you've been gracious to answer, and I appreciate that.
Okay, and like I said, I've done my best, and I think that inviolate, I think if people are allowed to waive inviolate rights, that there aren't many that they can't. And they have this structural, not structural argument. To the extent they make it again, I'll stand up and reply to it then. Your Honor, other than being sure to incorporate the arguments in the motion for summary judgment, I think that's all I have.
Okay,
And
you.
thank you for
Okay,
the
thank you so
questions
much.
and.
All right, and thank you for addressing those questions. Okay, we need to change some batteries. So let's take about a 5-minute recess. We're not gonna recess long. And, we'll get that done.
All right.
That wasn't.
Yes.
For the comfort of the speaker, since there's no objections, do you mind if I just sit in one of these chairs so we can have a little more extra
No,
space?
you go ahead and
without-
relax. Okay. Okay, good evening, counsel.
Good evening. Thank you, Your Honors. The defendant's motion under 41.002 should be denied in full. The evidence is sufficient and in fact more than sufficient to entitle plaintiff to a right to relief in this case. First, I would like, as somewhat of a formality, just to do the same thing that Mr. Helu did, which is to incorporate by reference all of our summary judgment papers for the summary judgment motions that remain pending, just to make sure that those are part of the record, the same as theirs are. First, on the defendant's argument that there's no standing over Coordinator Goins, that's incorrect. The evidence is sufficient to show standing. And I have three main points on this. First, the evidence shows that Coordinator Goins, who, by the way, is the state's top chief election official, the evidence shows that Coordinator Goins was the decider in 2019 when Ms. Moses was told that she was permanently disenfranchised. In 2019, she sought to have her voting rights restored, and she applied to register to vote. And those requests were rejected, the evidence showed, because that's what Coordinator Goins decided. He received that request from the Shelby County officials. He told the Shelby County officials that he had determined that she was permanently ineligible to vote, and as a result of his determination, the Shelby County officials sent her a letter saying, based on his determination, we're informing you that you are permanently ineligible to vote, and they said that her requests to register were denied. That was the word. So the evidence showed that he was the decider in 2019. The evidence also showed that
Was he a
Coordinator Goins,
did he have discretion in that decision? I mean, was he just looking at a list, or did he look at the papers and say, you know what, I think I'm going to determine she's ineligible to vote?
I think that under the statutes, he had a statutory duty to make the decision. He couldn't have just not decided. So he was required to decide one way or the other. His determination was that, based on the statutes that disenfranchise anyone convicted of a felony, that she was permanently disenfranchised. But I don't think that he could have just not decided. Similarly, the evidence showed that today, Coordinator Goins would be the decider. And the evidence showed that if this court were to rule in favor of Ms. Moses and declare that her 2015 conviction is not permanently disenfranchising, if she applied to register to vote at Shelby County, the evidence showed that request would go back to Coordinator Goins, and he would be the decider, and under the statutes, Shelby County would have to follow his determination of whether she is eligible to vote. The evidence also showed that in the event that this court were to rule in favor of Ms. Moses, that he would issue guidance to all of the counties, which is consistent with his statutory duty that you heard about to ensure uniformity of the interpretation and administration of the election laws across all 95 counties in the state.
Didn't he testify that he recommends or he advises on the law to the county officials, but he can't make them do what he recommends, and in fact, some have not done what he's recommended, but if they don't follow what his opinion or recommendations are, his office has no authority to hire, fire, remove, re-register, register somebody, etc. So when you say that they have to follow him, that's not exactly what he said.
So I believe I draw a distinction between two situations. On some matters of election law interpretation or administration, if counties request information from him or he can issue memorandum, those are advisory. But the statute specifically says that if a person with a felony conviction goes to register or tries to essentially tries to register, that specific request in the context of felony disenfranchisement needs to go to the coordinator of elections. And as I think the documents from 2019 show, his determination on that specific type of request regarding a person with a felony conviction and their eligibility or ability to register is decisive as to the county. Certainly, even if there were a theoretical possibility that some county in some situation could refuse to comply with Coordinator Goins' directive or advice, there is no evidence that that's a possibility here, and there's no reason to think that that would happen. I mean, imagine a situation where this court issues an order declaring as a matter of law that Ms. Moses is eligible to vote. She registers at Shelby County, and the request goes up to Coordinator Goins, as it's obligated to do under the statute, and he tells Shelby County, yes, comply with the court order, register her, she's eligible. There's no reason to believe, there's certainly no evidence indicating that Shelby County would or even could refuse to comply with his direction on that question.
How does the fact that Shelby County has their own legal team that advises the election commission, the local, play into, I guess, my memory of the testimony was that Davidson County and Shelby County have their own legal counsel, and I don't want to go too far in what my memory of the testimony was, but that they regularly rely on that legal counsel to advise them, at least in some part, of their obligations or their duties, things of that nature.
Yeah, I think that the critical part of what you just said, Your Honor, is in some part or in some issues, they have legal counsel and they may make decisions on their own or in consultation with Coordinator Goins. But the statute set up a specific procedure when a person with a felony conviction is coming back in and trying to become a voter again. The statutes deal with that very specifically, apart from, there were testimony about HR issues or other aspects of election administration. But in the specific context where a person with a felony conviction is seeking to become a voter again, the statute speaks to that very directly, and that request must go, as a matter of statute, from the county election officials, so in this case Shelby County, notwithstanding they have their own lawyers, has to go up to Coordinator Goins for his decision. That's what happened in 2019. That's still what the statutes say would have to happen today.
Well, as this case has been, as we've been discussing, I was trying to think about the standing argument with regard to this case versus the standing argument if Ms. Phillips were not to comply with Mr. Goins' recommendation. So if Mr. Goins made the recommendation that Ms. Moses was eligible for reinstatement and Ms. Phillips disagreed and she refused to comply or follow the recommendation of Mr. Goins, then who would have standing in that, who would be defendants in that lawsuit because there's been a failure to comply would be different than who has standing in this lawsuit. But I just want to make sure that I'm thinking about this correctly. Exhibit number 64 is the letter that came in from Mr. Goins, if I'm not mistaken. And it's dated September 3rd, 2019. It's the email that that I believe he signs and says, please be advised that the voting rights for the following persons, et cetera, Pamela Moses, permanently not eligible. And then the letter from Ms. Phillips is the next day, September 4th, 2019, which is Exhibit 65. So within 24 hours, the administrator of the Shelby County Election Commission notified Ms. Moses. But again, and as I'm trying to think about this, is the standing in this case different than who may be a potential defendant if Ms. Phillips or any other county administrator does not comply with the recommendation of Mr. Goins.
Yes, Your
Because
Honor.
he is required statutorily, according to his own affidavit, to interpret the laws and to ensure that they are uniformly applied across the state. So the fact that you may have a administrator that decides they're not gonna follow his recommendation, does the fact that he can't terminate them or replace them or discipline them have any effect on what his statutory duty is to ensure that the election laws are administered uniformly, and especially in terms of the role that he is playing with regard to who is eligible to vote and who is not eligible to vote. So while he may not issue the certificate and the reinstatement, what role does his office play in the process? And I guess the question is, before the statute, because now the orders go through, and this is what we want to understand, now you have to apply to the circuit court. But assuming that the circuit court were to issue an order, how is the coordinator of elections involved in that process?
So I think that's exactly the right way of thinking about it.
And my second question is, does the change in the law affect the standing argument with regard to Mr. Goins?
So the answer to that question is no. The change in the law does not affect standing as to Coordinator Goins. And the reason is essentially the answer to your first question. Both under the old regime and under the new regime, under the 2025 legislative amendments, the would-be voters, so Ms. Moses's papers to try to become a voter again, would go first to Shelby County election officials, and then under the statutes, this was true before and it's still true, those Shelby County officials must send those papers up to Coordinator Goins for a decision on her eligibility to vote. And he tells them. That's what happened in 2019, and the statutes show that that's what would happen today. Now there would, for a person seeking rights restoration through a court petition, their packet of information now that goes to Shelby County and then up to Coordinator Goins for decision would now need to include a court order. We believe that could be the order of this court, not necessarily the order of a different circuit court in a separate rights restoration proceeding, but regardless of what the paperwork is, under both the old process and the new process, person who has a felony conviction and wants to vote first goes to their county election officials, who take their paperwork and send it up to Coordinator Goins for the decision on whether they are eligible to vote. And he tells the local officials whether they're eligible to vote, and that is the decision. And as you saw in 2019, Shelby County was able to turn around that decision within 24 hours of getting the decision from Coordinator Goins. So he is the one, and on this idea that Shelby County might not follow his recommendation, first of all, there's no evidence of that. No one came in here and said there's any risk, realistic or unrealistic, that Shelby County would not follow his advice on this question. And I don't think anybody would come say that, because this is a situation where the court would have ordered that Ms. Moses is eligible to vote. But even if in the extremely unrealistic situation where that happened, that would be another lawsuit against whoever that official is for not following the law. It doesn't affect standing in this case. My third point on this is Mr. Helu suggested that we should, when pressed on, who are we supposed to sue in their view? If it's not the state's top election official, who is it? And I think he said to sue either a court, which doesn't make a lot of sense, or to sue the Shelby County election administrator. And the issue with, there are two main problems with that. First, if we sued the Shelby County election administrator, I imagine they would probably say we're the wrong defendant, we're not the one who ultimately makes the decision on eligibility, we would just pass Ms. Moses' papers up to Coordinator Goins. He's the one who decides eligibility for a person with a felony conviction, and we would just comply with whatever he says.
But we don't know that, do we?
Well,
I mean, we don't know they would say that.
I think the statutes pretty clearly indicate that that would be the correct answer there. That they are not, the local election officials are not the final decision maker on the eligibility to vote after a felony conviction. That, under the statutes, that request must go up to the coordinator of elections for the decision. That position that we should have sued local officials is also unusual for two reasons. Number one, as the evidence showed, one of Coordinator Goins' main statutory duties in his job is to ensure that the state's election laws are interpreted and enforced uniformly throughout the state in all of the counties. But as you heard during Mr. Helu's argument just now, they're advocating that what we should have done is file a lawsuit that doesn't involve Coordinator Goins, and the outcome of which would only have applied to Shelby County, not to any of the 94 other counties, and we should just sort of hope that the other counties would kind of go along because this court's decision would be thought of as precedential. That's not how it should go. We filed this lawsuit as a challenge to a state statute as unconstitutional under the state constitution, and the proper defendant is the state's top election official who has the ultimate decision-making authority on this issue. So unless there are any questions on standing, the motion should also be denied on the basis of, with respect to the evidence on all of our causes of action. So I'll start with our claims under Article 1, Section 5, the Free and Equal Elections Clause. As the court knows, we have both as-applied and facial challenges under Article 1, Section 5. Mr. Helu did not touch on our facial challenge there, which is not specific to the jury conviction text, but more generally is that this legal regime facially violates the Free and Equal Election Clause because of the way that it manipulates the electorate and the outcome of elections. And we've laid out in our papers why that is so.
I'm sorry, what claim is that again, counsel?
That's our facial challenge under Article 1, Section 5.
Facial challenge, okay.
Correct. We also have an as-applied challenge under Article 1, Section 5, which is what Mr. Helu did discuss in his motion just now, and that's our argument that that the permanent disenfranchisement is unconstitutional as applied to everyone who is not convicted by a jury.
Can we go back to facial challenge? Was that not granted on a motion, or am I mistaken? The
I think
facial
so.
challenge to Article 1, Section 5?
I think it's,
So yes, okay, so here's what
Okay,
happened.
okay.
Yes, we still do, the court did resolve on dispositive motions one aspect of our facial challenge. The court ruled that we cannot make a facial challenge based on the explicit by a jury language in
Okay.
Article 1, Section 5, but we still have a more general facial challenge to Article 1, Section 5 that survived that ruling. And our theory there is that this permanent disenfranchisement law is facially invalid under Article 1, Section 5, the Free and Equal Elections Clause, because of the way that it manipulates the composition of the electorate by disenfranchising such a large number of people, particularly when elections are so close, with the clear possibility for actually impacting the outcome of elections across the state.
You said manipulates the composition of
The electorate.
the electorate.
By disenfranchising such a large number of people, particularly when there are so many close elections across the state, creating a clear possibility that the large the relatively large number of disenfranchised people impacts the outcome of elections. So then for our as-applied challenge under Article 1, Section 5, the constitutional text clearly and unambiguously prohibits the General Assembly from disenfranchising people unless they are convicted by a jury. And the words "by a jury" are the explicit constitutional text, and the cases from the Tennessee Supreme Court and other state courts are clear that we have to start with the constitutional text, and it needs to be interpreted according to its plain text. And the other side's argument, they have a few arguments on this, but their argument is basically that the words "by a jury" in Article 1, Section 5 either mean nothing and sort of can be read out, so that you just have to be convicted, period. Or their argument could be thought of as saying that the words "by a jury" mean by a jury or not by a jury, by a guilty plea. And neither of those is a plausible interpretation of the three words "by a jury." We all know what a jury is. It's 12 people in the box, jury of your peers, and that has clear meaning, and the constitutional text is just so clear and explicit on that, and the evidence is undisputed that Ms. Moses' 2015 conviction, which is the only conviction that on which basis she's permanently disenfranchised, was not by a jury. It was by a guilty plea. There was no jury involved at all. This provision is unique to Tennessee. It's the only state constitution that has that by a jury language, and the evidence from Dr. Holloway helped Your Honors understand why. And that by a jury language was added in 1870 in response to the loyalty oaths, which had required former members of the Confederacy to either swear loyalty to the Union or not be able to vote. And the evidence showed from Dr. Holloway that those loyalty oaths were particularly hated because they deprived people of the right to vote without a jury, without a determination by a jury of their peers of any sort of wrongdoing. And that shows that those words "by a jury," I mean, even without any history, those words are extremely clear. But the history shows why they were put there, and they were put there for a specific reason, because there was this practice. It happened to be the loyalty oaths involving former members of the Confederacy, but there was a practice where people were being disenfranchised without a jury conviction, without being put to a jury of their peers, and that was a specifically hated, odious thing that people did not want, and that's what led to the adoption of this language in the 1870 Constitution. And so that history further supports giving meaning to the clear constitutional text. I think there also was an argument that Ms. Moses, the constitutional text says that the right of suffrage shall not be denied unless there's a conviction by a jury. It uses the word "denied." I think there was an argument that Ms. Moses was not, that her right of suffrage was not denied. First of all, if you look at the exhibit, I believe it's Exhibit 65, it's the letter that Ms. Moses received in 2019 from the Shelby County Election Commission. It says her application to register to vote was denied. It's the word it used. It says "denied." It's the exact same word in the Constitution. So I don't know how they can argue that.
Which exhibit?
I believe it's 65, but let me confirm quickly. It's that really blurry one.
65 is, I think that's what you have.
Mm-hmm. Yeah.
All right, I'm going to go with 65, and if they tell me that it's wrong, I'll fix that in one moment. It's right at the bottom in the last paragraph. It says your registration application or your application to register is denied. So she was denied. She was also denied the right to vote, just in the way that we all use the word. I don't know. She used to be able to vote. She tried to vote, to register, to become a voter, and she was told that she can't And we're all here doing this because they're saying she can't vote. So she's being denied the right to vote. I don't know how else you would even say what's going on. They argued that the waiver point, so they argue that even if there is a jury conviction requirement, which there is, that she waived it. And we have two principal responses to that. First is, this is a right under, this is a provision of the Constitution that cannot be waived by an individual. So there are personal rights under the Constitution, rights that are exclusively personal and individual, like the right to a jury trial for a criminal defendant to establish guilt, that can be waived. There are other provisions of the Constitution that impose structural limitations on the government, things that the government, the legislature, cannot do. And the jury conviction requirement in Article 1, Section 5 falls in that latter category. It is framed, it is articulated as a limitation on the General Assembly's power. The right of suffrage shall never be denied except upon conviction by a jury, and then it goes on to finish the sentence. That is it's not only a personal right, it is a structural limitation on the power of the General Assembly to disenfranchise people, and under the case law, that sort of constitutional protection cannot be waived by an individual.
Now, in terms of the distinction between personal rights and structural limitations, are there some cases that support your analysis and your conclusion, or I'm sorry, not your conclusion, but your argument?
There are, and all of those cases, or at least the main cases, are cited in our summary judgment papers, both our opening motion for summary judgment and reply, as well as our opposition to theirs. Can you search like structural or something like
that? What do the courts say with regard to structural limitations? How do the appellate courts explain a structural limitation?
So I would point the court to several cases. Some involve the subject matter of courts. And so Brown versus Brown, which is a 1955 decision of the Tennessee Supreme Court, and I'm going to paraphrase a little bit here, but this is mostly a quote. It says that considering the state derives its powers from the law and not from a particular person, quote, it necessarily follows, therefore, that constitutional authority cannot be conferred or enlarged by waiver, consent, or estoppel. And so that's...
What case is that?
Brown versus Brown, it's 281 Southwest 2nd, 492, page 501.
Okay.
And then similarly, there are many cases. An old one involving court subject matter jurisdiction is Barthel v. Zachman. It's 36 Southwest 2nd, 886 at page 888. That court said, quote, jurisdiction of the subject matter, which refers to the power of the court to adjudicate the question presented, cannot be waived. And that's analogous to the situation here. The Free and Equal Elections Clause speaks to the power of the General Assembly to disenfranchise people. And it says the General Assembly cannot do that unless the person is convicted by a jury. That is a structural limitation on the power of the General Assembly. Another case, or even more direct, the Gaskin case. It's 661 Southwest 2nd, and the pin site is page 868, said that Article 1, Section 5 of the Tennessee Constitution, that's our provision, quote, prohibits the General Assembly from retroactively disenfranchising convicted felons who have never been adjudged infamous. So that case was about a different aspect of this language in the Free and Equal Elections Clause. It was about the language that required, that prohibited sort of retroactive disenfranchisement, but the Supreme Court recognized and said that Article 1, Section 5 is a limitation. It is a prohibition on when the General Assembly cannot disenfranchise, and they cannot disenfranchise unless the person is convicted by a jury. There are other cases cited in our summary judgment papers, but those are some of the main ones. Even if this right could be waived by an individual, which, as I just explained, it can't, it wasn't waived here. So it's undisputed. The evidence showed that Ms. Moses was not told anything about voting or voting rights or disenfranchisement in connection with her 2015 guilty plea, either in writing or otherwise. There's no evidence that she was told anything. She wasn't.
Is that required?
Yes, as your honors know, waiver in the law requires a voluntary and intelligent waiver of a known right. That's exactly why at plea colloquies in a guilty plea in a criminal case, the court must inform, or the accused must be informed specifically and explicitly of all of the rights that they're waiving by virtue of pleading guilty.
Are you saying that in Tennessee, a judge is required to tell a defendant when taking a plea that they will not have the right, for instance, to vote if the plea is accepted?
So our primary position is that even if the judge said is that this is a right that can't be waived at all.
I understand.
So, but getting past that, if it could be waived, yes, our position is that in order for there to be a valid waiver, a voluntary and intelligent relinquishment of a known right, the criminal defendant in that situation would need to be informed that as a result of their guilty plea, that they would be waiving this specific protection against disenfranchisement under Article Section 5. We also
do you have any authority to back that up?
So I would two responses. One, I would point to general authority just explaining what a waiver is. The voluntary and intelligent relinquishment of a known right. The right has to be known, and if nobody tells the person what the right is, then there typically can't be a waiver. I think Miranda is probably a good example of this. The police officers have to Mirandize people because they can't be thought of to have waived their right to remain silent unless they were told that they have a right to remain silent. There's also the State v. Dorso case from Tennessee, which independently requires that there be a statutory framework for waiver, and that did not happen here. Okay, on my last point, which was that waiver requires sort of informing the person of the right, I would point to State v. Blackman, which is 984 Southwest 2nd, 589. And there's a couple of other cases, but that's a good one. And there's also no statutory framework for the waiver.
Let me ask you this. If the claim, as we heard today in proof, was that it was not a voluntary plea, okay? In other words, I think the testimony was that Ms. Moses did not know she was giving up her right to vote when she entered the plea. The testimony was a little murkier on whether she exercised her post-conviction right to challenge that plea. There was some testimony that she asked to take it back or something along those lines. Everyone heard it, and I can't quite quote it. But my question is, did she take advantage of any collateral challenge to her plea if it was unknowingly? And if not, how does that affect whether she exhausted all available remedies before coming here and saying, this is unconstitutional, I didn't know it? So can she now collaterally attack her plea if there's a procedure in state law to do that and that was not taken advantage of?
Yeah, so she did collaterally attack her plea. The testimony,
is
although
that in the proof?
I believe the testimony, when we see the transcript, will be clear enough that, as she describes it as a layperson, she made an effort to challenge her plea agreement as involuntary, and she did. There's reported court decisions about it that the court could take judicial notice of under the 202 ruling. I don't believe that collateral challenge to her actual guilty plea, like her attempt to undo her guilty plea and plead not guilty and go forward towards a jury trial, has anything to do, has any impact on whether, as part of that guilty plea, she waived the protection in Article 1, Section 5 that prohibits the General Assembly from disenfranchising her absent a jury
Well, I
conviction.
understand. Part of the argument is it was an unknowing plea, and so that's why I asked that question.
Right. It was, but it could be unknowing as to two things. She was saying it was involuntary as to actually pleading guilty. Even if it was voluntary as to pleading guilty, which was the result of the collateral challenge, it was still unknowing with respect to anything having to do with voting. Because the evidence is clear that nobody told her anything about voting.
Did she challenge that collaterally?
She didn't. That is essentially, it's coming up in the context of this case. She sought to vote, and she was told she can't, and she filed a lawsuit saying that that's unconstitutional. Their defense is she waived it, and our response is she can't waive it, but even if she could, she didn't. So that issue is coming up here now.
Well, keep in mind that the guilty plea was in 15. The aggrievement did not happen until 19. So it was not justiciable. There was no controversy until she was denied the right to vote.
Correct.
So would that be able to be addressed in the appellate review of her criminal conviction if it wasn't an issue before that court, if she didn't know until 4 years later when she got the letter from Ms. Phillips? Would that have been something that she could have raised on the appeal from the 15 conviction, or was it not a controversy until the denial?
It would not have, that argument would not have been available to her as part of her collateral challenge to her actual guilty plea. The appropriate place, and I think the only way for her to bring this issue up, was to bring it up in this lawsuit after the events that occurred in 2019 when she tried to become a voter again.
When she found out about,
Correct.
could she argue an estoppel, equitable estoppel? That she was not informed at the time by counsel that she would lose her right to vote and didn't find out until much later? Isn't that a classic equitable estoppel claim?
It might be thought of as equitable estoppel, yes. I mean, the way that we've argued it is just that she didn't waive anything in the first place, so there's nothing to estop, right? I mean,
Are we talking about equitable estoppel in this case, or are we talking about equitable estoppel in an appellate review of her conviction?
right, this would be an argument by her in another context that the state is equitably estopped from disenfranchising her as a result of the 2015 guilty plea, because no one told her about that. Not in this case.
Okay.
Yeah. Okay. Moving on to our equal protection claims. Again, we have facial and as applied equal protection claims. I think the primary argument was that we didn't we didn't establish racial intent. Mr. Healer referred to it as racial animus. I think the standard is actually intent. Animus, I think, signifies more along the lines of hatred. We just have to show that there was a racial intent for that strand of equal protection clause, and the evidence is sufficient to secure a right to relief on that claim. Dr. Baumgartner's testimony regarding the extreme racially disparate impact of these laws is just really striking. And I was trying to follow what Mr. Healer was arguing about how you're supposed to ignore the actual Tennessee population and only look at the smaller population of people who are disenfranchised. I didn't quite follow the math there, but I'll explain what I think are the relevant figures to demonstrate the extreme racially disparate impact, which goes to
I
intent.
took his argument as the number is the 322 as against the 322,000, because the only people affected would be those convicted of a felony. So in other words, I want to hear your response, but I took the argument as, listen, I can't make this challenge because I've never been convicted of a felony. In other words, I'm not in the group that is affected, and I don't want to speak for him, and I don't propose to, because I would get it wrong. So that's what I took that as. In other words, the group we're talking about that's affected is really, it was like 322 or something thousand, and then you also have the 13,000 that are permanently disenfranchised. So that's what I took the argument as. And so I might be wrong, but because you were unclear, I thought I would muddy up the waters even more and say,
No,
this is what I took it as.
Not money, no, I appreciate the clarification. I still think that in any evaluation of whether a government policy is having a disparate impact on different racial groups, you have to look at the total population of black people and white people. And I'll just give you a quick example, some math, to explain why, okay? I'll do a tiny bit of math, and then I'll go to what Dr. Baumgartner said. Imagine there's a state with 110 people, okay? 100 of them are white and 10 are black. Okay? 10 of the 100 white people are permanently disenfranchised. 10 of the black people are permanently disenfranchised, right? I think Mr. Healy's argument would be, of the 20 people who are disenfranchised, it's split 50-50. 10 black people, 10 white people.
I think that what you're leaving out is how many of those 110 have been convicted of a felony, and this would even apply to. I think that's the argument.
Okay, so then in the state with 110 people, 10 people are 10 white people are disenfranchised, 10 black people are disenfranchised, and within each of those groups, 5 of the 10 disenfranchised people is permanent. So you have 20 total disenfranchised people, half are white, half are black. 5 of the disenfranchised white people are permanent, 5 of the black disenfranchised people are permanent. I think according to Mr. Healy's math, that would look like a state that has no racial disparity at all. And yet, in that hypothetical, 100% of the black people are disenfranchised, 10 out of 10, 50% of those permanently. And yet only 10 out of the 100 white people are permanently disenfranchised, 5 out of 100. 5 out of 100. It's clearly, I don't understand how you can do any math that would eliminate a showing of racial disparity without considering the overall black and white population of the state. I don't want to get too far ahead of myself. You're not going to hear any evidence like that from their expert either. Nobody's going to say, nobody has said, and nobody is going to say in this case that that's the appropriate math from the stand.
On the motion for involuntary dismissal, let's just focus on what's already in evidence.
So let's focus on exactly what's already in evidence.
Okay.
Dr. Baumgartner is in evidence. Here is the correct way to think about racial disparities of permanent disenfranchisement in Tennessee. Black people are 16.5% of this state's total population, but they are 40.2% of the Tennesseans who are permanently disenfranchised. White people are 72.5% of the Tennessee population, a large majority, but they are only 55.4% of those permanently disenfranchised. And as Dr. Baumgartner showed, I think I almost agreed with Judge Cook, at some point it starts getting redundant because there are so many different ways to say and show that any way you slice these numbers, black people are vastly overrepresented in the disenfranchised and permanently disenfranchised populations relative to their share of the overall state population, and white people, by contrast, are dramatically underrepresented in the disenfranchised and permanently disenfranchised populations relative to their share of the overall population. That means, as you heard from Dr. Baumgartner, that black people are disenfranchised at a rate 2.6 times high as the rate of white disenfranchisement, Black people are disenfranchised at a rate 3.2 times as high as the rate of white permanent disenfranchisement. There are different ways to articulate that. You could say that black people are disenfranchised at a rate 220% of the white disenfranchised rate. That's what that's another way of articulating the 3.2 number. And you heard Dr. Baumgartner testify that in other contexts, like racial discrimination in employment, anything over 1.2 or 20% would be considered substantively important. And here we're not talking about 20%, we're not talking about 1.2, we're talking about 220%. Black permanent disenfranchisement is 3.2 times the rate of white permanent disenfranchisement. Dr. Baumgartner's county by county analysis is at least as striking as those numbers. Just a few.
I'm sorry, before you go on, the 3.2%, the 2.6% was equivalent to 220%. What did Dr. Baumgartner testify to with regard to the 3.2%? What was that equivalent to?
Yeah, so let me articulate it as clearly as I can. It's not a percentage, the 3.2.
Okay.
3.2 is a ratio.
Well, I understand
of
the
two
ratio, but was it equivalent to a percentage?
Yes, it's equivalent to 220%.
Okay, and then the 2.6% for just the general disenfranchised, wasn't that the 220%?
That's 160%. So
That
another
was 160%?
yes, another way of saying that black people are disenfranchised at a rate 2.6 times as high as white people. Another way, just mathematically, of saying that is that black people are disenfranchised at a rate 160%
Okay,
as high.
that's the number I missed.
100% plus the 160% gets you 260%, which is 2.6.
All right.
Am
Yeah.
I correct in remembering that all of that data that he analyzed was based on his analysis of just 1 year, 2023?
It was a snapshot of all of the people who were disenfranchised, like going back forever, as of the 2023
As of
cutoff.
2023.
Because that was just the last data that we got from the state.
I think the 2023 had to do with the guilty pleas, looking at the guilty pleas versus the conviction by jury.
That is also true. The data
The
that
2023.
Dr. Baumgartner used to conclude that felony convictions are only by jury in something like 2% of cases and are by guilty plea in 90. That was from the National Conference of State Courts, I believe is the name of the source, from 2023. And I think that was only data from what happened in 2023, jury convictions and guilty pleas in 2023. But I want to be very clear in response to Judge Cook's question. In calculating the rates and ratios of black and white disenfranchisement, 2023 is when we got the database, but that database has all of the felony convictions going back in time for all living people in Tennessee as of 2023. The county by county, again, I don't want to belabor the point. There's so many different ways to say these numbers. On just disenfranchisement, 91 of Tennessee's 95 counties disenfranchised black Tennesseans at a rate higher than white Tennesseans. There are 17 counties in Tennessee where more than 20% of the entire black population of that county is disenfranchised. That's more than 1 in 5 black people in 17 different counties are disenfranchised due to a felony conviction. There was one county, it was Unicoi. It was at the very top of one of those scatter plots. 33% of black people, 1 in 3 black people in Unicoi County cannot vote due to a felony conviction. There is not a single county in Tennessee where the rate of white disenfranchisement is higher than 10%. None. There are 17 counties where the rate of black disenfranchisement is higher than 20%, more than 1 in 5 people. Those numbers are striking, and they're more than sufficient to proceed on the racial discrimination aspect of the equal protection claim.
Let me ask you a question, because Mr. Goins says, well, if you commit a crime, you commit a crime. It doesn't matter whether you're black or white. green, it doesn't really matter. The numbers are the numbers. So how do these statistics tie into the plaintiff's claim, any of the plaintiff's claims, when we're looking at these numbers?
The same would be true of poll taxes. White people and black people both were obligated to pay poll taxes. The same would be true of literacy tests with grandfather clauses. Black people and all 100% of people were subject to literacy tests. The whole point of the analysis that Dr. Baumgartner presented is to demonstrate why this law, which is race neutral on its face, it applies to all people who have been convicted of felonies. It does not talk about race in the law. What Dr. Baumgartner's analysis does, just like what we could do if we could go back in time and do an analysis of poll taxes in 1960 or 1950 in this state, or literacy tests in 1964, those laws, like felony and disenfranchisement, don't talk about race. And on their face, they apply to 100% of people in the state. You have to unpack what the impact is, and that's what Dr. Baumgartner did, and he showed that in a number of different ways that although the law is facially race neutral, it doesn't talk about race. On its face, it applies to everyone. The impact is dramatically, disproportionately to deny black people the right to vote in comparison to white people.
And that goes back to my earlier question, and it may not be for tonight. Your statement that the poll tax applied to 100% of people is obviously correct. But does this apply to 100% of people, or does this apply to those who have been convicted with a felony?
I think their argument is that it applies to 100% of people. 100% of people, 100% of people who have felony convictions can't vote. Just like 100% of people who fail the literacy test can't vote. Just like 100% of people who can't or don't pay the poll tax can't vote.
Okay, so are you agreeing that it's 100% of those with felonies that we're talking about? Not 100% of the population.
No, I think it's 100%. The law applies on its face. The law applies equally to everyone. It says to everyone, if you are convicted of a felony, just like if you fail the literacy test or you don't or can't pay the poll tax, you cannot vote. You then get a subset of the population who can't vote for that reason, either because they have a felony conviction, or because they failed the literacy test, or because they couldn't pay the poll tax. That's a smaller number. What you find when you unpack the racial demographics of those people relative to their shares of the population is that although the law doesn't say anything about race, and on its race, whether you are white, black, or any other race, you can't vote if you have a felony conviction. The impact of the law is overwhelmingly to disproportionately disenfranchise people of one race, and in this case, black people. There is also another strand of equal protection law that a law violates equal protection if it deprives a class of people of a fundamental right. And Mr. Helu argued that there is no fundamental right to vote here, I think essentially because the General Assembly has declared or enacted that people lose their voting rights when they are convicted of a felony. But that argument is circular. It's just saying that because the Equal Protection Clause says if a class is deprived of a fundamental constitutional right, it violates equal protection subject to strict scrutiny. And Mr. Helu is saying if the General Assembly just enacts a law saying that this class of people loses that right, that they don't have a right protected by equal protection. And that's just going in a circular. It's tautological. It's saying this doesn't violate equal protection because the General Assembly passed the law. On equal protection, and this also applies to substantive due process, we believe that the applicable standard is strict scrutiny, but I would say under any level of scrutiny, Mr. Peterson said in our opening statement, you're not going to hear any witness say anything about government interests supporting this law, and I think that's true with an asterisk. The asterisk being that Ms. Henry Robinson was permitted to give narrow testimony about some purported government interests, but we believe, as our forthcoming motion to strike will explain, that testimony was allowed by the court on the basis of a foundation that turned out to be inaccurate, and our objection to that testimony should have been sustained. We will file that motion. We're confident that when that motion is resolved, after you review the papers, the record will be devoid of any testimony from any witness that there is any government interest supporting permanently denying people the right to vote in Tennessee. And on the flip side, there is evidence that permanent disenfranchisement does not advance any of the government interests typically put forward. That evidence came from Dr. Birch, and in fact, as Dr. Birch explained, permanent disenfranchisement, rather than advance government interests, undermines important government interests by stigmatizing people, by creating communities where disenfranchisement is so pervasive that there are entire neighborhoods with substantially depressed numbers of people who can vote, which has implications for the entire community, starting with children who grow up in those communities without sufficient numbers of adults who are able to vote and demonstrate that behavior to that pro-social behavior to them. So there are simply no government interests that could pass even rational basis review, and certainly not strict scrutiny, which, as I said, we believe is the applicable government interest. Finally, coming to our substantive due process claims, and we have facial and as applied.
Before you move on to
Yes.
that, the plaintiffs contend that strict scrutiny applies, and I've been kind of thinking about this, and the state's argument that it's a rational basis because once one has been disenfranchised and they've lost the right to vote, there is no fundamental right. But the way that I've been also thinking about this is we have this statute, and I don't want to misstate it, the one that Ms. Moses was convicted under. What was that statute?
Tampering with
Yeah,
evidence.
the citation number.
I will get
And
that
by
for
this
you.
time, we should all know it, but
There-
Mr. Wilson knows it.
39-16-503.
Okay, 3916?
16-503.
Okay, 503, okay. So that statute was enacted in 2006?
Not the criminal statute.
The one that permanently disenfranchises one from voting?
The reenfranchisement statute, 2006.
Okay, this is the one that permanently disenfranchises Ms. Moses?
No,
No,
That's-
her
that's
criminal
tampering with
conviction,
evidence.
that's tampering.
that's the
Okay,
criminal
what
statute.
was the statute that includes this tampering with evidence?
4029-102. That one I know. I thought you were asking about
Oh, I'm sorry.
the tampering with evidence.
Fair question. Okay, and what year was 4029-102 enacted?
2006.
Okay, that's what I thought, okay. So that is the statute that's in question in our case. And that is the statute that the plaintiff brought this lawsuit for, saying that it's unconstitutional, 4029-102. How does the court reconcile the arguments that the state is making that once you're a felon and you're disenfranchised, you have no fundamental rights, so therefore it's rational basis, versus when Ms. Moses pled guilty in 2015, she was convicted by this particular statute, which not only was she disenfranchised, but she was disenfranchised permanently. So what the state is trying to do is use the general disenfranchisement and then sort of piggyback on that and add a different layer and say, hold up, you have no right here. But she had a right before she pled guilty, right? She had the right. She pled guilty to 39-16-503, and then simultaneously with 4029-102, she was permanently disenfranchised. So how do we reconcile whether or not we apply a strict scrutiny analysis, because it's the disenfranchisement of a fundamental right, which is the statute that she is appealing or alleging is unconstitutional, versus the general felony disenfranchisement, which is not before us. See, if Ms. Moses was alleging after she had been disenfranchised under the general and she's now not being restored, okay, the cases that the state cites make sense because you've already been disenfranchised. But the statute that she's challenging permanently disenfranchised her. So did she have a fundamental right to vote before pleading guilty? And now that right to vote has been, or the right to vote ever, because it's not an issue about reinstatement, it's an issue about permanently impairing my right to vote when I plead guilty. See, we can look at it two ways. We can look at it in terms of the restoration, or we can look at it in terms of what happened simultaneously with her pleading guilty. So my question is, how do we reconcile that? How does the court think about that? Because we want to apply the correct standard. And there's no, even the state would concede that if we're dealing with a fundamental right, it's strict scrutiny, which is a totally different analysis. It must, what is the standard? Be narrowly tailored to meet a compelling governmental interest versus a rational, totally different analysis. So of course the defendants are going to want the court to apply the lower standard. And that would be premised on she was disenfranchised, she has no rights. Of course, the plaintiff is going to want us to apply a higher standard of scrutiny. But this is what we are trying to reconcile. And I'm having difficulty with the loss of the fundamental right because the statute that's in question permanently disenfranchised her. And to have a statute, it's like saying, well, you lost your right, but then you lost your right again under this second statute, right? So you're infamous, and we're going to disenfranchise you. Now you have no rights. So if you're going to challenge this statute, which allows you to be permanently disenfranchised, you don't have any rights. So it just doesn't make sense to me when the statute that is disenfranchising individuals in Tennessee, not only Ms. Moses, but individuals who come within 4029-102, it's permanent. And if you're going to permanently disenfranchise someone, and then we have that little, that important document, which is the Tennessee Constitution, that gives us some guidance about when and if one can be disenfranchised. How should we think about that standard?
So
And that's what I really need for you to unpack, because there's a big distinction. Is there any cases that you can cite us to that would help us more clearly understand those arguments? Because counsel is correct. The cases are clear. Once you lose the right, you don't have a right. So, but are those cases within the context of trying to get your right back, right? So the laws that are passed in terms of re-enfranchisement, okay, yeah, you don't have the right. So we're gonna look at those laws a little bit differently. But where there's a separate law, should the state or the government be allowed to kind of piggyback on this general disenfranchisement statute and say, well, you don't have any rights. So therefore, you can't challenge any of our other statutes that disenfranchise you. Do you understand what I'm saying?
I do.
This is not an issue about reinstatement. If it were reinstatement, yes, those cases would apply. But this is a totally different statute that the legislature decided that they were going to enact, permanently disenfranchising. And my question is, why should this court apply a rational basis test to a statute which permanently disenfranchises, according to the data, almost 13,000 people in Tennessee at this time?
So, it's a good question. Here's what I think is the key point, or at least one key point. Up until the very moment when she pled guilty in 2015, she had the right to vote. She got her voting rights restored in 2014. She had voting rights. She was a voter right up until that moment when she pled guilty in 2015. And the state's position now is that by virtue of 40-29-102, the instant she pled guilty, she was permanently ineligible to register or vote again. It happened in an instant. She went from being a voter with a right to vote that had been restored just the year before, so it was undeniably there. It was the right to vote that she had right up until that moment of pleading guilty, and it was a fundamental right that she owned at that time, that she held, and it was stripped of her, and permanently so, by virtue of 40-29-102, the instant she pled guilty. That's their understanding of how 40-29-102 operates. Permanently ineligible to vote. And I would point the court to just the cases that the Tennessee cases that declare that the right to vote is fundamental. So, for example, Johnston v. Davidson County Election Commission, the citation is 2014 Westlaw 1266343 at page 3. That's the Tennessee Court of Appeals.
I'm sorry, repeat that again, 2014.
WL Westlaw 1266343 at page 3. This is a case that says, consistent with, I'm paraphrasing a bit here, consistent with the express language of the Constitution, the Tennessee Constitution, and the court's own prior holdings, the right to vote is fundamental under the Tennessee Constitution, and that accordingly a strict scrutiny analysis is the appropriate standard to be applied, and then it goes on to describe the specific situations. The right to vote is 2 points together. Until right up to that moment when she pled guilty, she had the right to vote. It had just been restored. We know she had it. And the case law says that the right to vote is fundamental. Therefore, up until the moment she pled guilty, she had a fundamental right to vote. And according to the state, the moment she pleads guilty, in that single instant, by virtue of 40-29-102, statute challenged in this case, she instantly becomes ineligible to vote or register permanently ever. Done. And in that situation, 40-29-102 is a statute that takes away a person's fundamental right to vote, that being a right to vote that was fundamental, that the person had right up until the application of that statute.
Isn't the statute that's at issue here, the statute where a felon loses their right to vote is not the one that we're being asked to address. We're being asked to address the statute that is, maybe subset's the wrong word, but it's derivative of that statute. Felons lose the right to vote. That's what the statute that's not at issue in this case says. So she pled guilty, she lost her right to vote. But this statute, which is at issue, says that some felons lose the right permanently because of the type of crime of which they've been convicted, right? So, in other words, you're saying she lost the right the minute she pled guilty. Yeah, all felons lose that right, but she's not challenging that. She's just challenging that some are permanently disenfranchised, right?
Yeah.
So she lost her right under the statute that you're not suing over. But this statute is an additional infamous crimes are another set by which you can never get your vote back, right? So she lost her right under the other statute, not this statute. This statute just says you can't restore.
So if anything, she lost her rights under both. I mean, the text of the text of 4029-102 says that basically upon the conviction, that the person is not eligible to have the right of suffrage restored and vote in this state. Oh, sorry, that's not, where's the language of it? Sorry, I'm reading the wrong language.
Well, I mean, what I'm saying, and this is, you know, we've gone way past, I think, directed a motion under 41.02 in a response. But when you're arguing that she lost her
Oh, yeah,
right,
sorry.
yeah, she lost her right under a statute that she's not contesting in this case. This statute is a derivative of that certain people who've lost their right can never get it back. And does the Constitution address having a right to have it restored? I mean, the Tennessee Constitution contemplates that some people will lose their right to vote, okay? And there's a lot of argument over how to interpret when that's gonna happen, right? But it clearly contemplates that some people are going to have that right taken away under certain circumstances. Does our Constitution contemplate any concept of restoration? Or only that it shall be lost?
It certainly allows for restoration. I mean, there's been restoration
Where in the
statutes
Constitution does it allow for restoration?
forever. Well, I mean, I think there have been restoration statutes, I believe.
No, I'm saying where in the Tennessee Constitution is there language about rights being restored?
So I don't believe the constitutional text specifically speaks to restoration, because the Constitution doesn't say that anyone has to be disenfranchised by a conviction. All the Tennessee Constitution does, subject to certain limitations, like the jury conviction limitation, is authorize the General Assembly to enact a felony disenfranchisement regime if the General Assembly chooses to do that. And as part of that discretion, they've included restoration.
Does it authorize the legislature to enact restoration statutes? Or only to take away the right to vote?
I don't think that either party has briefed it. I think both parties' positions, though, would be that the Tennessee Constitution allows the General Assembly to include a rights restoration component as part of a disenfranchisement scheme. I mean, the state has a rights restoration component by statute that Coordinator Goins helps implement along with other components of the state government, and I believe that's been the case for as long as there have been Tennessee statutes. I don't think there has ever been a situation where, under the Tennessee constitutional provision, the General Assembly went and adopted a disenfranchisement scheme with no rights restoration at all for anyone.
Even though not specifically authorized to do so.
It's not explicit. I think that the clear takeaway, though, is that by simply conferring the authority on the General Assembly to enact felony disenfranchisement, the General Assembly has authority to
well,
determine.
hang on. If your argument is that it has to be conviction by a jury, because y'all have been very specific about, let's just say y'all are being strict constructionists, right? Conviction by a jury, conviction by a jury. Well, if I want to apply that same language, the Tennessee Constitution says that no right of suffrage shall be taken away, I'm paraphrasing, without a conviction by jury. But it is completely silent about restoration. It says, so if it's silent about that, how does the legislature then have the authority to restore people when they've taken it away because of X, Y, or Z under the Constitution?
It hasn't been briefed. Neither party's addressed it. No one's argued in the case.
I'm just asking for
yeah,
your,
I think
your
that
argument now.
I'm saying it hasn't been briefed only to say that I don't have like case law or anything addressing that specifically. My understanding is that that provision of the Tennessee Constitution has been interpreted to allow rights restoration schemes for as long as it's been in the Constitution, that there have always been rights restoration
But not
schemes.
in the Constitution. Not in the Tennessee Constitution. The language about restoration is not in it.
The Tennessee the words restoration don't appear in the Constitution.
So if the statute that's not being contested, the one that says all felons are disenfranchised, if there was never a statute put in place to restore any felon's voting rights, you'd have nothing to look at in the Constitution to say that there should be restoration, right?
Counsel, why are you shaking your head? That's not appropriate. It's not appropriate. It's not appropriate.
Understood, Your Honor. I didn't know I was doing it.
Sure you did. Because I've been looking at you. So you don't shake your head like this and not know that you're shaking your head, counsel, respectfully.
All right, back to what I asked you.
Yeah, so, first of all, no one in the case is arguing that, and,
No, I know no one's arguing that. I'm interested in your perspective because of all the arguments here and your perspective. What I'm saying is, if the statute that's not being contested, all felons lose the right to vote, and there was never any restoration statute of any sort enacted by this legislature, what would be the response? That you couldn't look to the Constitution and say, it's unconstitutional that I can't have my right restored, because the Constitution doesn't provide for it, right? Does that clear it up?
I think I understand your question. So, so first of all, I think there would still be the same equal protection and substantive due process challenges to that law. That would be, if I'm understanding your hypothetical situation here, this would be a situation where the Tennessee Constitution authorizes the legislature to enact felony disenfranchisement, but not any kind of restoration. If you do disenfranchisement, you can never allow restoration as a constitutional command. And the legislature then just enacts a law that says felony disenfranchisement upon a conviction and says nothing about restoration. Mm-hmm. If that law had the kind of racially disparate impact that this law has, and the kind of conscience-shocking effects that I'll get to when I talk about substantive due process, I think we would be here making the same arguments, or at least the same types of arguments, that legal regime, although authorized by the provision of the Constitution speaking to felony disenfranchisement, that power of the General Assembly remains constrained by the Equal Protection Clause and substantive due process. So if I could just use another example, I mean, the federal Constitution authorizes Congress to regulate interstate commerce. Statutes that Congress enacts pursuant to the Commerce Clause are still unconstitutional if they violate equal protection because they're racially discriminatory, or if they are conscience-shocking because they violate substantive due process. So, however you conceive of the power that the General Assembly has under Article 1, Section 5 to enact some sort of felony disenfranchisement regime, whether it includes restoration or not, and in your hypothetical it doesn't, that's the legislative power under that one provision of the Constitution remains constrained by the Equal Protection Clause, because whatever the legislature enacts under the sort of principal constitutional authority can't discriminate against on the basis of race, and that power also remains constrained by substantive due process, because even a statute that is, or a legal regime that is enacted and adopted pursuant to constitutional authority violates the Constitution if it shocks the conscience and violates substantive due process. Does that answer your question?
Sure.
Okay. On substantive due process, again, we have facial and as-applied challenges to permanent felony disenfranchisement under substantive due process, and the standard there is conscience-shocking, and the evidence shows and is sufficient to show that permanent disenfranchisement here is conscience-shocking for multiple reasons. First of all, it's arbitrary. It is arbitrary in multiple ways. Because of the jagged line selecting some offenses, some types of convictions for permanent disenfranchisement and others not. And the cross-examination of Coordinator Goins showed that while a conviction for tampering with evidence is permanently disenfranchising, a conviction for forgery is not. A conviction for and I can't remember exactly the language and don't have the, but forging something by a public officer. Kidnapping, not permanently disenfranchising. Perjury is not permanently disenfranchising. Armed robbery, not permanently disenfranchising. So there are many offenses that are similarly of either a violent nature or similarly of a sort of dishonest nature or like misuse of government proceedings that are not permanently disenfranchising, but evidence tampering is. It's arbitrary. It's also conscience shocking. The law is also arbitrary because of what you heard Coordinator Goins testify, that he's done no analysis of the law's racially disparate impact. Okay. And also the large numbers of people who are disenfranchised is conscience shocking, and the racial disparities are conscience shocking. Mr. Helu offered two arguments on this that I'll just touch quickly before I wrap up. You know, he said that basically this disenfranchisement has been around for a couple of hundred years. It's extremely old, so how can it shock the conscience? There are lots of laws that can and should shock our conscience even though they were old, right? The laws barred women from voting for well over 100 years before the 19th Amendment. Poll taxes were used for many, many decades, maybe over 100 years in some states, before they were struck down by the US Supreme Court in 1966. Literacy tests were used in states for dozens or over 100 years in many states before they were eliminated by the Voting Rights Act of 1965. There are lots of laws that are extremely old that can and should shock our conscience, and this is just one of them. And his other response was that there are lots of other states that have felony disenfranchisement, and that is true, but it's also no defense. At the time of the 19th Amendment, there were numerous states that barred women from voting. At the time of Brown versus the Board of Education, there were numerous states that had racially segregated schools. There's no other states are doing it to defense, to unconstitutional government action.
I want to say I appreciate you engaging in the discussion with me. I mean, I think all of us, we're all invested in, you know, it's an interesting issue. It's complex, you know, it's complicated. And from my perspective, I remember being on y'all's side of things, I was a pretty zealous advocate myself. And I think both sides have been well prepared, fought hard, zealously, not in any uncivil type of way. And I was not particularly bothered by Mr. Helu's nodding the head. And that's okay, it's subject to different interpretation. And I'm not critical of my colleague for it. But I just remember sitting out there and I remember thinking to myself, they're getting what I'm saying. And it's not really anybody, like if somebody over here was nodding their head, I'd be like, well, maybe I'm making a point they understand or I'm on the right path. But I just appreciate everybody in the case. I know everybody's worked hard. We're all tired. Lord knows we've all put a lot into this, and so I appreciate you engaging with me on that, and you know the respect back and forth.
I appreciate that, Your Honor. The last thing I would say is that under Rule 41002, we think that their motion should be denied now. Alternatively, the rule expressly allows the court to defer ruling until after the close of all evidence. So alternatively, we would request that the court do that. And then if there are no other questions.
No questions for me, Judge? Nope, okay.
Thank you, Your
Thank you
Honors.
very much. All right, well, it is 6:48, and it's been a long day. So what we're proposing is that we get another date to come back. It's a little bit late in the evening to start the defendant's proof. We have two experts. I'm assuming any other witnesses that you anticipate?
Your Honor, we anticipate two experts, and if I could just reply to the response for 2 minutes.
Absolutely, you may. Yes, sir.
And Your Honor,
Okay.
I caught myself nodding again. I've been going over what my argument's going to be to shorten it, and I have a cadence. And I'm sorry if it bothered Your
Well-
Honor, and
I didn't see it.
I caught myself doing it again after you said it, and I didn't mean to.
All right.
I apologize.
It's okay. Again,
Yeah,
I'm just used to a certain
understood. It was my fault.
lawyers conducting themselves a certain way in a trial, and while my colleagues may not have had an issue with it, if a lawyer is sitting there, it wasn't just a slight nod, counsel, and we can look at the tape.
No, I'm not doubting Your Honor at all.
Okay, it wasn't just a slight nod, so since you brought the issue up again, it was, that's different than.
Understood, Your
So,
Honor.
again, I'm not singling you out. If any lawyer in the courtroom made those types of gestures, I would ask them not to do that.
Understood.
Okay.
If I could very quickly, and I'm going to use this to address very specific questions that I now have better answers to. We asked about the timing of a conviction, because I know we were saying it's after sentencing. There's a very specific Tennessee case. It is State v. Dixon, and it actually involved an elected official who was seeking to run again, who had committed one of these acts that caused him to no longer be qualified for reenfranchisement. And the Court of Appeals was trying to set the date of his conviction. And quoting the Tennessee Court of Appeals, judgment of conviction shall set forth the plea, the verdict of findings, and the adjudication and sentence. In other words, conviction happens after sentence. And that gets exactly to the question you asked me about what they understood it, and impaneling juries for sentencing. The conviction would happen after sentence. And if you'd like the site, it's 2018 Westlaw, and it's 1168693.
I'm sorry, repeat that?
2018 WL for Westlaw, 1168693.
All right, thank you.
Another very just discrete, specific thing. Your Honor asked about guilty pleas and being advised of the loss of the elective right and whether it was their position that that needed to be done. Two things. Based on the court case Ward v. State that Your Honors all cited in the motion to dismiss, when they dismissed the procedural due process claim, because the loss of the elective franchise is a collateral consequence and not a punishment, Tennessee courts have already ruled that criminal defendants do not need to be advised of that loss. And like I said, Your Honor's already cited it in the order on the motion to dismiss. To address Judge Tidwell, your questions about the population, using specifically his example of the 110. I think where we're differing is, and the easiest way to say it is, if this court were analyzing a county ordinance pursuant to equal protection, they would not use state populations. They would use that county's population. Here, we have a statute of very limited application. It only applies to convicted felons. It doesn't apply to anyone else. And so if there were 110 convicted felons, and of those, I forgot the exact example he used, but let's say, I think it was 20 total, had committed this subset, the permanently disqualified from seeking reenfranchisement. And 10 of those were, or 5 of those were white and 5 were black. Then the disparate impact upon the applicable population would in fact be 1-to-1. It would. His example that he used is what I'm saying. We are not discussing general felon disenfranchisement. If we were, if 40-20-112 were at issue, we would take the whole state's population. Because every one of us, if we commit a felony, is guided by that statute. The scheme to reenfranchise, which by the way is what the 1986 law was called when they first had the certificates of restoration, its application is limited only to the population of people that are felonies. And then when we're looking at the disparate impact, that's the total population. It applies to 13,000 people as it relates to permanently disqualified. So that's the subset from the total. And then for disparate impact, you look at the racial makeup of that as compared to the racial makeup of the total 330,000. That is what we are proposing. So to the extent it wasn't understood, I did want to explain that. Your Honor, as to a very specific question about Coordinator Goins and what his role is and what it was in relation to this letter about Ms. Moses. The statute is very clear. It never once gives him the power to bind anyone. He advises. That is it is used, and I didn't count, and I want to be precise if I'm going to use a number. It is used time and time again. He advises. He does not have the power to bind any county election administrator.
Well, let me ask a question with regard to those exhibits. If he only advises, are you referring to advisors in terms of the law or advisory in what capacity?
Your Honor, I think it definitely includes in terms of the law. I think he dispenses other advice. If they have a question about keeping a polling location open, they may call him, and he may respond. If they have a question about flooding, they may call him, he may respond. I think it's primarily legal issues, but to the extent there may be other issues, I'm sure he's helping them through those.
All right, so in terms of exhibit, was it 50?
I think 65 is the one that was discussed.
Let's see.
Full.
65 and 64, how would you characterize his letter dated September 3rd, 2019, which is second page of Exhibit 64?
Your Honor, they're pulling it, if I'm remembering it correctly. That is a version of him letting a county administrator know, this is what I think the law requires. This is what I think the law says. Now, I think the exhibit that's most telling.
Okay, well, this is what the letter says. It says, please be advised that voting rights for the following persons in Shelby County cannot be restored at this time for the reasons listed below. And it says, Pamela Moses, reason for denial of restoration, permanently ineligible to register to vote in Tennessee due to conviction, see Tennessee Code 4029-204, sincerely, Mark Goins, and it's addressed to Ms. Phillips.
Yes, Your Honor.
So is that a recommendation that is that an advice, is that a recommendation, or is that a decision?
I note that he opens the letter with, please be advised. He's fulfilling his statutory duty to advise that election commissioner.
So it's a recommendation?
It is his advice to that election commissioner. Yes, Your Honor.
Okay.
And then more tellingly is Exhibit 65, which I think was discussed, when Ms. Moses was actually notified. That letter came from the Shelby County Election Commission, copying the Shelby County Election Commission's attorney, not Mark Goins. And so, Your Honor, it's clear from the record, Exhibit 65, that her communication, the Shelby County Election Commissioner is the one who made that communication. And not only that, but the Shelby County Election Commissioner, when she wanted to copy her legal advisor, copied her private attorneys, not Mark Goins. Your Honor, that's all I have.
Thank you, counsel.
And to answer your other question, we anticipate 2 expert witnesses. One should be very, very short. And by very, very short, I mean like less than 25, 30 minutes.
Okay.
It's the rebuttal statistician. I think our plan on direct to historian is to be very, very short. But we are going to admit his report, and I would not be surprised, and I'd be remiss not to mention, that if the other side did that, I would probably have to ask questions about the whole report. So we just don't know how long the cross will take. You get that about right? Yeah, they're nodding.
Okay, well, we've decided that we are probably going to have to reset this case. It's 7 o'clock now. It's been a long day, so does anyone have any scheduling conflicts with the first week of March, March 2nd, March 3rd? And we appreciate the estimates of time, but we know that what may start out as an hour or two may be 4, and we
Is that the old
don't want to
adage?
be here.
Never
Yeah.
trust a lawyer who says they only have one more question.
I believe that is fine for plaintiff.
Okay, September 2nd, I'm sorry, March 2nd, yes, March 2nd, 3rd.
The only thing I would say is I have a hearing the 4th, but I've got to think we'd be done by the 4th.
Well, we hope so.
Yeah.
If we start on the 2nd, anyone else have a conflict?
You
What-
control some of that.
What about our parties? I know Mr. Goins is not here. Is that a good date for the plaintiff? That week, that Monday and Tuesday? And we'll let you check with your client as well to make sure that that's a good date for him, in case he wants to be here. Okay. All right, is that a good time for the AOC staff and our media team? Jordan, good date for you as well? Okay. And what about our experts? They're important, so we want to confer with them.
March is fine.
March 2nd?
I'm gonna have to look at my calendar, because I don't have access to it.
Oh, you can't pull it up online or?
I know.
Because we really want to set it around, we want to set it around your schedule, so.
I will make it happen.
All right, very good.
Okay, all right, well, we appreciate that. Okay, so what
All right,
time
then.
should we start on the 2nd?
This was not put into evidence, so I just want to hand it back to somebody.
What, do we want to say 9:30? 9:30 on the 2nd?
We're fine with our report set.
You're fine with that? Okay. 9:30? Okay, well, very good.
All right.
Okay, well, it's been a pleasure having all of you here. Thank you all for all your hard work, and are there any final issues before we wrap for the evening?
One moment.
And are you gonna keep the exhibits, or should we, you know what, I think the court should probably keep them. What do you think?
I would say that the court should keep them just in case I end up having any scheduling conflicts.
Okay, I appreciate that, but before you all leave, if both sides, because this is what we generally require, that both sides get with the court reporter, go through the exhibits, make sure that they're in order, and that there are no exhibits missing.
Yes, Judge, if I may, on that point.
Okay.
During a recess, the court reporter handed us the current stack of exhibits, and I went through with, at least through my notes and my tracking of things, and there's a decent number of exhibits that are not in that batch currently.
Okay,
It's possible that they're scattered throughout, and so they
absolutely.
can confer with defense counsel and make sure we have a complete stack.
Okay, why don't you tell us which exhibits are missing?
So the exhibits I have that are missing from the court reporter stack over there are Exhibit 12, Exhibit 13, Exhibit 16, Exhibit 17, Exhibit 18, Exhibit 19, Exhibit 20,
Wow,
21, 22, 23, 24,
really?
25, 26, 27, 28, 29, 30,
No way.
31, and 67.
Wait a minute, I stopped at 29. 29,
Sure, but to simplify it, Your Honor,
29,
it's
30.
Exhibit 12 and 13, and then Exhibits 16 through 31, and then Exhibit 67. So those are exhibits
Wow.
that, according to my records, have been admitted, but are not in that stack.
Okay,
And then there are 6 exhibits that were marked for ID only,
that's correct.
and according to my records, that's Exhibit 32, Exhibit 40, 43, 44, 46, and 53. And I'll just note that those 6 exhibits that are marked for ID only are not in that stack either.
Your Honor, if I may, I think that's on purpose. I remember Your Honor saying she learned a lesson in a criminal trial and you handed
Right.
those back to the
Right.
parties.
I just want to make sure that there's somewhere where there's a marking of what
Right.
those 6 exhibits are.
Right, well, they should have been handed back to the attorneys that proffered them.
Understood, Your Honor.
So, okay, so just hold on to those. Now, we have to locate 12, 13, 16 through 31, and 67, so,
Um, Your Honor, if I may, I believe, now, only on 12 and 13, it's one of the paralegals, and we did find it in the stack. The issue was that they were paperclip, they were not paperclip.
oh, okay,
So 14 was on top, and below that was 13, 12, they weren't initially accounted for when we were going
Okay.
through them. And maybe we just need to,
okay.
first off, go through the stack of the exhibits that we have again. And I do know 67, I believe, was up there with you guys, I don't remember marking that.
Yeah, because these may have been like 1-page or 2-page statutes, so it's impossible for all of those to be missing. Do you want to go through them again?
You want me to go through, I'm sorry, to go through the
He
stack?
was saying maybe the paper clip
Right.
joined multiple exhibits.
It's entirely possible that
Uh-huh.
somehow they got mixed into that batch and that when I was flipping through and tracking it, that they're buried in there and that I didn't see them. But I looked at the face of each paper clipped document and put them in order, and
Okay.
this is my record. I mean, again, the fact that 16 through 31 are completely missing lends me to believe that there's some stack that was misplaced or buried or what have you.
Okay, well, as much as we would like to adjourn, we can't do that until we have the exhibits.
Your
So,
Honor,
who wants to be responsible for going through that stack again and trying to locate all of these exhibits?
I'll work on it right now, Your Honor.
You work on them? Okay.
I was gonna say that, I know Ms. Jordan's been keeping fairly meticulous notes, and we had traded electronic files of the exhibits. If they wanna compare notes, I'm sure if something's missing, we can quickly recreate it from the electronic file.
So just step off while we work on it for a
Yeah.
minute.